Good morning, ladies and gentlemen. We'd like to call to order the Judiciary Committee meeting for March 15th. Several bills on our agenda today. Reminder for folks testifying. It is 3 minutes. It is a strict 3 minutes, so please be cognizant of your time so that we can get to members' questions if there are any. We also have a decent list today, so we would like to get to folks before it gets too late in the day. With that, first on the list is Cooper Caraway. Cooper Caraway with us? All right. Then we will move on to the Chief Justice of the Connecticut Supreme Court, Richard Robinson. Justice Robinson, it's nice to see you without having to put you under oath.
Good morning. How you doing? O'Donovan. Good morning. I'm O'Donovan Murphy, Director for the Marshal's Office. I'm number 17. I'll be sitting with the Chief Justice.
Okay, that's fine. I'll just note for the record that the 3-minute clock, if folks come up and testify together, it's still the same 3 minutes of opening statements. So whenever you're ready.
Thank you very much. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Rick Robinson. I'm the Chief Justice of the Connecticut Judicial Branch. I'm here to testify in support of Section 25 of HB 6874, an act concerning judicial branch operations, the sharing of judicial branch records, and the award of damages in certain civil matters. This section would create the crime of intimidating a judge or family support magistrate when 1, someone commits threatening in the second degree pursuant to 53A62 of the Connecticut General Statutes, and 2, the threat is directed to a judge, either elected or appointed, or a family magistrate, and relates to a ruling or decision made or to be made by the judge, family support magistrate in any official proceeding. Moreover, while second degree threatening is a misdemeanor, the new charge of intimidating a judge or family support magistrate would be a Class C felony. I urge the committee to pass this important legislation. Fundamentally, any judiciary here and around the world, the nation can only fulfill its constitutional obligation if and only if it is free from fear or favor. State justices, judges, and family support magistrates take seriously this obligation to uphold the rule of law. With such responsibilities comes the necessity of having to make difficult decisions where one party is certain to be upset by the outcome. We understand that being the target of criticism comes with that responsibility, even if it is offensive, inaccurate, or peppered with obscenities. This proposed bill is not about that. However, what is not part of the job are attempts to intimidate or threaten or physical violence against judges for merely fulfilling their responsibilities. That is what this bill is about. The safety of our judges keeps many of us awake at night, including me. As an example, here is one threat one of our judges received. I know about Judge X and the judge's family. People think they are safe, but they don't know what can happen. They may not wake up. The party went on to say that if a judge took a particular action, the party will have to have the judge's throat cut. Unfortunately, the number of incidents has increased. We take every one of them seriously and have established our own Office of Protective Intelligence as part of our Judicial Marshals Service Unit. The office will expand our capability to detect and deter potential threats to judges by collecting, disseminating, and analyzing intelligence. Such measures impact not only on the targeted judges, but also on the general security of our courthouses. For each threat, judicial marshals and law enforcement partners must reallocate resources to determine the credibility of the threat. It is a ripple effect that has potential to harm and to turn into dangerous situations for judges, staff, and members of the public. I fully recognize there is already a law whereby someone could be charged with threatening a judge. What is different with the new crime bill is that it goes to the heart of our democracy. People who try to intimidate a judge because of the ruling that the judge has or is about to render works to undermine our entire system of government, because the courts are the protectors of our Constitution and bodies of law. The proposed legislation will go a long way in protecting our judges from harm. And thank you very much.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Mr. Chief Justice, it's great to see you again.
You too, sir.
We have a philosophical debate on this committee on occasion as to whether additional laws with criminal penalties actually work to deter bad behavior. We get requests all the time from various folks, whether it's school referees and umpires to conductors on our trains, saying, we're getting a lot of threats lately. The pandemic sort of seemed to ratchet up certain bad behavior. So philosophically, do you think, I mean, isn't there enough laws on the books right now to protect judges from threats of either one form or another? And why should we move forward with this particular, I wouldn't call it a carve out, but sort of like raise it up as opposed to everything else that we have on the books right now?
Thank you very much for that question. I've been thinking about that a lot myself. This is very narrowly tailored. It only talks about a judge's in the capacity of about to make a decision or having made a decision. That's different from everything else that's going on. Because if you look at the attacks that are going on about judges, it's to the heart of our democracy. It's to the heart of our rule of law and lawmaking. Somehow it's become common for people to feel more energetic about not just voicing their opinions about the judge's decision, but about physically harming the judge. That's different than anything else I've seen before. Trust me, I've had a lot of bad things said about me since becoming a judge, and even more since I became chief. That doesn't bother me. That's just part of the game. But when it comes to tampering with a decision, actually, that kind of a threat, that's totally different from everything else I've heard.
Well, I very much appreciate that response, Mr. Chief Justice. And, I've sort of, we've all been witness to the ratcheting up of threats to members of the United States Supreme Court. And really, to my dismay, there's been members in Congress on the national level that have not really come out forcefully and said, this is just not acceptable behavior. And so the more we have people in authority sort of turning a blind eye to bad behavior, I think it has, if not an explicit, certainly an implicit encouragement of others to maybe take that bad step. So I hear you. I'm very supportive of the request that you're making. I actually think in certain instances, and clearly in this one, if it's in response to a decision or the decision-making process, there's some mens rea, right? There's some thought process. It's not, heat of the moment kind of thing. Unless it happens spontaneously in a court of law, which might put it in a different characterization. And the last thing I'll say is this, is one of my friends from over the years when I was a special public defender, and then even thereafter, Christopher Parakilis, who's a state's attorney, he prosecuted a case to conclusion and was directly threatened by that. And it was a serious threat. And so it can specifically undermine your ability to do your job, not to mention the collateral consequences to loved ones, family members, spouses, children, and everything else. So thank you for coming and testifying today. Thank you, Mr.
Thank you,
Chair.
Senator.
Representative Fishman.
Thank you, Mr. Chairman. Good morning, Chief Justice.
Good morning, sir.
Very nice to see you again.
You too.
I too very concerned about what happened in Washington over the last couple of years and the lack of enforcement there. But can you give me an example of where the current law was insufficient in bringing the bad acts to a tempered tone?
Let me try to put it this way. I think this is one of the crimes that law enforcement, and rightfully so, prosecutors, a little bit intimidated against bringing any kind of action because of First Amendment concerns. And so you need something that's narrowly tailored. And this is actually narrowly tailored in a way that I think you will get law enforcement to act when something occurs, when there's a threat that involves a judge making a decision in court. That is not explicitly there before. So I think it gives law enforcement more guidance on what to do. And you will see prosecutions, but not that many of them.
So at the very advent, let's just say that the act is passive. Unfortunately, a judge has a barn on their property. The barn is burnt down, and the judge believes that it would fall. It was perpetrated by someone who was involved in a case that they thought was going to go adverse. There would have to be a lot of investigation by the police to determine whether or not it was connected to that. I think it would make it a little bit more difficult to prosecute because they're narrowly tailored, but legislators make decisions all the time on bills, and we certainly have passion debates up here. Why would we be treated differently?
Once again, this proposed bill is very narrowly tailored to only deal with a situation where you have, and the thing is, you're talking about a situation where legislators are dealing with a situation where there's hundreds, thousands of people. This is, you have two parties before you, and it's so narrowly tailored that if one of those parties does something like this, then the law enforcement take action on it. So this isn't the kind of thing where you're drafting a law and somebody says some obscure thing that is problematic. This is very refined. It's very granular.
However, decisions, especially by the Supreme Court, many times affect more than one person. I mean, the legalization or the repeal of the death penalty, right? That didn't just affect one individual.
Yeah, I've had some horrible things said about me for many of my decisions, and some of that was from the other justices. But no, in all seriousness, it's not the kind of a thing that this law is trying to get to. This is one where if it says, hey, Chief Justice Robinson, if you vote in the affirmative, if you vote to affirm this particular suit, I'm going to kill you. That's different than, hey, I don't like your decision, you should die.
Well, I'm looking at the language and it says relates to a ruling or decision made or to be made by such judge or family support magistrate in any official proceeding. So that appears to be very general. Another concern of mine here is, well, I find it ironic that the position is being taken in this room that increasing penalties brings individuals into conformity with proper conduct. But that being said, we cherish our parents many times, and let's say individual understands it's a heightened penalty if they contact you in that form, but what if they instead contact your parent in that form? I've had that happen to me. Instead of coming after me because they knew that I could stand up for myself, they came after a family member of mine. Would we extend it to our family members also?
As is currently written, no, you would not.
No, I know, but you would think that the fundamental philosophy is to stop the bad act if the heightened penalty is applied to the judge themselves and the individual who recognizes the harmful nature of the heightened penalty. In the alternative, makes those threats to one that we feel is near and dear to us. I certainly wouldn't want to push it that way. So, I share what Senator Kissel shared. We have this issue on many planes, many times. I don't want to see any of this bad stuff happen to anyone. I just don't know that this is the answer at this point. So I thank you, Mr. Chairman.
Representative Osborne.
Thank you, Mr. Chair. And thank you, Your Honor, for being here this morning. I'm familiar with the with the issue that's before us today in this bill, but some of the questions I have are about why only judges. I understand that judges are the ones whose names are on the decision, but there are a lot of other participants in the orderly administration of justice. You have private attorneys, you have guardians ad litem, you have prosecutors, all of whom have been subjects of these threats and attacks, whether online or in a courthouse. And none of them should be experiencing that. And none of them have the benefit of a judicial marshal to give them a heads up when there is a threat made to them online, in a blog, or elsewhere. So I'm all for protecting people from this type of, so sorry, my dog's in the background, from this type of abusive process and abuse of people, because judges are people too. But I don't think that judges are the only ones who are in jeopardy here. So may I ask your thoughts about how all the participants in cases that go sideways like this can be protected?
Well, and not trying to shirk responsibility by saying that's something for the legislature to think about. And I think you do need to give that some additional thought. The thing that I'm trying to do is protect people in a very particular situation. These are judges who've been experiencing an increase in threats like I haven't seen since the time I've taken the bench. We've had judges nationwide. We've had some murders of judges. We've had bomb threats. We've had guns. We've had people hinting that other people should take action. I could try to cure all of that, but I can't cure all of that. This is something I can do, and this is something you can do. This is action that we can take. I don't think we throw our hands up and do our hand wringing saying we can't stop all of this, so we won't stop any of it. What's the old saying about don't let the perfect get in the way of the good? This is something we can do, and I think it's something that's necessary. I've had threats to me. My colleagues have threats to them. We need to do something to make it easier for judges to be able to take the bench and make these very difficult decisions. You would think that the biggest worry were cases like criminal cases. The truth is, I don't think I've ever been threatened after handling a criminal case. I have been threatened after civil cases and family cases. That's the nature of what we do.
So again, Your Honor, I'm going to circle back to the fact that there are a lot of people that go into the administration of justice in those family cases. Private attorneys are getting threatened right alongside the judges. The same 50 milligram, that's the wrong word. I'm not very, first, the same 50 mig gun is being threatened to be turned on a judge and on a private attorney, especially when there are participants, or especially when cases concern allegations of domestic violence.
Yeah.
So again, I'm going to come back to, why would this bill only seek to protect judges who already have judicial marshals? Why aren't steps being taken by the judicial branch to expand that protection to the private attorneys and the GALs who don't have the benefit of a judicial marshal system to protect them?
I'm not sure how that law would look. I mean, I know what's going on with the judges, but as far as trying to protect every individual who may touch a case, I don't know how to do that. I wish I did.
I think that I'll say, I think until we figure out how to protect attorneys and GALs who are stepping in to cases that involve domestic violence and involve existing threats, I think that we're doing a disservice to domestic violence victims, because it has an incredible dampening effect on an attorney's willingness to take cases like that in the future when their lives and the safety of their families are in jeopardy, and the judicial branch isn't stepping up to protect them as well.
I'm going to have to disagree with you when you say we aren't stepping up to protect people. We are doing our utmost to protect everybody who uses our system.
But this bill is only seeking to protect the judges. So thank you very much.
Thank you, Representative. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Mr. Chief Justice, for coming in. I have to sort of echo what my colleagues before me have said. Our system overall is based on a system of justice where every litigant and every accused knows that there is an even-handed administration of justice doled out by the person sitting on the bench. And in my view, we need to do everything we can to make sure that when somebody goes into a courtroom, they know that the judge sitting on the bench is going to make a decision based exclusively on the facts and the law, and not because somebody threatened them, or not because of something that happened outside of the courtroom. And to that extent, I think it's important for our laws to make sure that judges are safe and are in a position to make a judgment based on the facts and the law and not based on intimidation. That being the case, we also have a system where we treat everybody the same. And there is no hierarchy of people in our society. One is not better than another. One is not more worthy than another. One is not more deserving of protection than another. And my concern is balancing these two different philosophies, that in one instance, you have to make sure that the judiciary is protected in order to render fair judgments. On the other hand, how do we do that without separating them out and giving them special protection where that the same risks, the same threats are directed on a daily basis against virtually every other person in the courtroom? You know, I know you are the Chief Justice and your job is to protect judges, not everybody else in the courtroom, but how do we balance those two interests? One, to make sure that judges are not held as more important than everybody else. And on the other hand, how to protect them, to make sure they can do their job. Do you think that this is the bill, this is the way to balance those two interests, which I think are competing?
Thank you very much. A lot of hard questions in there. First thing I want to say is I'm going to push back again. My job is to protect everyone who comes into our courthouses, not just the judges. It's everyone who comes into our courthouses. What makes this different is that I have an obligation to protect the rule of law, and that judges should make decisions based on the facts in the case and the law as it is. In order to do that, we shouldn't have the situation with outside threats coming in and judges being intimidated, not because they have to make hard decisions, but because someone is threatening their life. The thing we don't have here, and I said this is narrowly tailored, I think it is narrowly tailored, is we have judges whose families are threatened too, as well as the judge. We're not asking for that. Do I want that? I would love to have that. How do I structure that? I don't know. But my wife has been subject to some really horrendous stuff, and you've probably heard about that. I'm not asking for that protection. I'm going to do my best to protect her myself. So this isn't the same. We're talking about the person who's making the decision in the courtroom. Yes, there are incidents where other people are hurt, who are threatened, but this is very narrowly tailored because the decision maker has to be able to make that decision. Our entire constitutional democracy depends on that.
Okay, well, I appreciate your response. Thank you, Mr. Chairman. Appreciate it.
Representative Callahan.
Thank you, Mr. Chairman and Chief Justice Robinson. It's always good to see you. I apologize I'm not there in person this morning. I'm coming at this, and I've heard my colleagues speak about this, and the good ranking member address issues around this as well. As you know, I had a father who sat in the seat you sat in my family, and he were subject to threats at some time. As a kid, I was driven to school by the police because of threats. I was also a football official, which we had a bill kicking around here for a new penalty for sports officials. I was threatened in that capacity, going to my car after a bad call. And you just spoke with Representative Dubitsky about having to make decisions based on the facts and not feel threatened. Well, as Representative Fishbein said, I believe said, as legislators, we do that all the time. We can't take into account if we rule the right way or vote the right way, I should say, that that will influence our vote. We're trying to vote for our district and what's best for the state of Connecticut. And as everyone on this panel probably knows, we're always going to anger somebody. So having been threatened as a family member of a judge and having been threatened in other capacities, where do we draw the line? And I know this is a bit redundant, but, and as you know, my previous job with probation, I had to remove my name off the voters registry and let local police know that I have threats against me. We benefit as legislators, and you as well, from the Capitol Police. So we already have another line of protection. But I'm just wondering, without being too redundant, where do we draw the line, Your Honor?
Well, I'm going to tell you, here's a good place to draw a line. Judges have a unique situation where they are the single individual who makes these decisions on these cases. They're not within a group of people. This is something where we are highly focused on. We make these very difficult decisions, and as I said, family and civil cases as well as criminal cases, and we should be able to make them in a way that is threat-free. Will that happen? No. I mean, there's things less than threats, and we'll take all that. But when it comes to threatening your life because of a decision you made, I think that's a place to draw the line.
Well, I appreciate you stating your point of view and appearing before the Judiciary Committee today. Thank you, Mr. Chairman.
Representative Blumenthal.
Thank you, Mr. Chair. And it's great to see you, Mr. Chief Justice. Thanks for being with us today. I suspect, as you've indicated or alluded to previously, that you proposed this provision the way it is because you wanted, in the spirit of judicial modesty, to propose something that was narrowly tailored.
Yes,
that'd be fair to say. And I also take it that it would be your opinion that the scope of this bill, although you're advocating for judges to be protected because of the information that you've received and the experiences of the judges in the Connecticut Superior Court, if we were to deal with other matters, that would be a matter for the legislature rather than in your capacity as the leader of our judicial branch.
You've probably read a few of my opinions. I'm often saying that's a matter for the legislature, not for the branch. And this is a matter for the legislature. And I have noticed that there are other bills that are concerned with specific acts of violence, like domestic violence, that the legislature does take care of or are considering. And so this is one of those things where I think it's a good thing to do something that's very narrowly focused to deal with a particular problem.
Well, I appreciate that, and I've also appreciated your opinions. I'm sure we all do, where you've made reference to our responsibility. I do think, well, first of all, I appreciate this proposal. We've seen an increase in threats generally across the country, but especially against judges, especially in the case of the New Jersey judge, Esther Salas, whose son was murdered recently in exactly this sort of situation. And I think it makes sense to take a very close look at how we can protect judges, because it's not only important to do that to protect the individual judges and to ensure that they're safe and they feel safe, but also to ensure that everyone has confidence in the administration of justice and that it's being fairly administered. So I appreciate you being here, and I appreciate the time.
Thank you, Representative Blumenthal. Further questions or comments? Okay, all right. Representative Doucette.
Thank you, Mr. Chair, and good to see you, Mr. Chief Justice. Thank you for being here with us today. I guess I have a slightly different perspective than some of the earlier speakers in that I think, as Representative Blumenthal just pointed out, we have a well-documented problem. And to the extent, I understand the concerns about drawing the line when we're crafting legislation, but to the extent that we can make people safer, and we have an opportunity to do so, I think that's a fine thing for us to be doing. I did want to ask, because the question has been raised a couple of times, and the comparison been made to our own Capitol Police force, and I think it's a fair comparison. And you have a representative here from the judicial marshals. If you could speak on, or if he could speak on The role of the judicial marshals, I think probably in scale, it's probably a little different than what our Capitol Police do in terms of their duties and how they fit into the job of protecting the employees and the judges of the judicial branch.
Thank you for the question. Absolutely. The marshals are responsible for all court security, including prisoner transportation and the management of the lockups in the courthouses. Additionally, there's a special operations unit that handles threats that are directed towards all judicial employees and the judges. That unit works closely with the Fusion Center, and we have several intelligence agent liaisons that work with the Fusion Center to make sure that anyone who's threatened within the branch that works for the branch, that's a state employee, receives the same type of response that we would give the judges. The problem that we have with threats is it takes marshals away from their primary function of court security, and we have to reallocate them to make sure the judges and staff are safe until we can determine whether or not the threat is one that's imminent. And then we have to track people for prolonged periods of time.
Right, and that was my thought, that you're pulled in many different directions. How many people in that intelligence capacity?
There are approximately 7 assigned to intelligence. The problem is that depending on the threat, there's a greater allocation of marshals to cover the judge in the field. It also takes law enforcement outside of the judicial branch to cover the judges at home.
Right, and how many employees for the branch and how many locations, physical locations?
There's 38 courthouses, and I believe we're down to 540 marshals.
Right. So again, I think the comparison is a fair one to the Capitol Police, but I think in scale and proportion, it is a little different in terms of what you folks are being asked to do. So again, I think that's something to keep in mind as we look at this. Again, I thank you for bringing it forward.
Thank you, Representative Gisette. All right, anybody else who has not asked questions yet? I remind folks, we do have a long list of folks still to testify. Representative Quinn, on something that's not been covered, please.
Thank you, Mr. Chairman. And just very briefly, and I apologize if this was covered, but can you point to any specific instance where current law was insufficient to punish someone who would threaten a judge?
Yeah, I believe I addressed that question earlier. And what I said, well, my belief on this is that I think there's a problem when law enforcement is leery about bringing charges or seeking to have charges brought against an individual, because they really were, and rightfully so, about First Amendment concerns. People have a right, especially when it's the judiciary. I'm perfectly fine with people saying all kind of horrible things. I'm not fine with somebody threatening my wife or my life. But I think this will make it so that law enforcement can prosecute under certain conditions, very narrow conditions, where before it may have been, we don't know if we can do this, or we don't think we can get a conviction. The prosecutor may say, we can't get a conviction on this one. But this is very specific. And so I think that what will happen is the cases that are brought will be brought because the prosecutor knows that they can actually win it. And it's a very serious thing.
Okay. Thank you very much, and I appreciate you being here.
Thank you.
Representative Quinn raises a question that I've sort of been struggling with, and I've heard you say this a couple of times, Mr. Chief Justice, that
Yeah.
law enforcement is leery to bring a charge. So right now, and if you look at the language of the bill before us, it refers back to threatening in the second degree pursuant to 53A62, which is a Class A misdemeanor. Has anyone, to your knowledge, been charged under 53A62 for threatening a judge?
Not that I know of. I know I know judges have been threatened and charges have not been brought.
Okay, just because, I mean, we often hear sort of from folks, obviously we wrestle with the penal code day in and day out around here, right? And we often hear this notion that prosecutors are leery to bring charges, that the higher the charge is. So if you move something that is now a Class A misdemeanor up to a C felony, so something that's punishable by up to a year in prison, and we don't have a record of anyone been charged for that crime of threatening a judge, and we now move it up to a C felony, which is punishable by up to 10 years in prison, at least the data I've read and seen, and what we hear time and time again and here is the higher the penalty, the less likely something is to be charged. Are you or the branch aware of some other data on that? But I mean, because we often hear there's this inverse relationship. You heighten a penalty, it's less likely to be charged.
I am not aware, but this is my own personal belief that because the elements are so narrowly defined here, that I don't think you'll have that problem with this piece of legislation.
But if you look back at 53A62, right, which is the underlying statute that I think we're sort of kind of trying to amend here, except we're putting something in, and we're always, I hope the Supreme Court can appreciate this. We're always try to be careful about where we stick things into the penal code when we draft stuff, so that things aren't kind of sticking out on their own, like this would be kind of its own crime that refers back to another statute, but isn't really in that statute. If you look back to 53A62, it says if you threaten somebody, it's a class A misdemeanor, right? But if you threaten someone in certain protected locations, daycare centers, schools, there's a few other things listed, that then becomes the felony offense. That's then a D felony, not a C felony, which you're asking for, but it's a D felony. So I just can't help but wonder, sort of, isn't the solution here to say threatening is threatening is threatening, but one of the protected locations where there may be an enhanced penalty, if we're going to say in our existing statutes that there's certain locations, wouldn't we just add courthouse into that list of locations and leave it at that?
The threat may not happen in the courthouse. The threat may happen, somebody calling in. The threat may happen in the parking lot. I don't think that'll fix the problem. I don't.
Okay, and I guess I hear you, although it's been alluded to a couple times. I mean, I certainly am of the opinion that I think the data supports that just enhancing penalties does not deter crime. And I think you had sort of agreed to that earlier on. So, I mean, I think if the idea is sort of there are certain locations that a threat is going to have more impact on, right? Certainly to your point about someone saying, I'm going to kill you if you rule this way, right? If that happens 3 weeks before while you're running in a park, as opposed to happening the day of the argument before you go sit on the bench while in the courthouse or around the courthouse, I guess you could say. I mean, it does seem like there's a difference in the severity of the threat in that instance, no? And time and location matter.
They do. But I'm not sure that really gets to the problem judiciary's had, or I'll have to give this some thought.
Okay, I guess where I'm going to, and you can get back to us on this, is I guess if I look at the existing penal code, we have threatening that's an A misdemeanor, we have threatening that's a D felony. And essentially what you're asking us to do is go from an A misdemeanor that has not been charged before all the way up to the C felony, skipping the D altogether. And I'm trying to figure out I'm not unsympathetic to the ask. I'm really not. And I understand certainly the threats, and maybe it should be a broader conversation about, threatening the governor, threatening the legislature, whatever. That's a valid conversation the legislature could have if it wanted to, particularly because we do have heightened degrees of threatening already on our statute book. But going from the A misdemeanor currently, skipping the D felony altogether and going straight to the C felony, I think is where I get a little, are we going too big too fast?
That would be up to the legislature to decide how you want to address it as far as the details are concerned. As far as the results, that's what I'm looking for. I'm looking for a situation where judges can feel more comfortable on making difficult decisions, whether it's a D or a C. That is not where my
Okay,
emphasis is
yeah,
going
no,
to be.
I just, because like I said, I worry that if you go all the way to a C, you're actually gonna, we discuss this all the time, you're actually gonna have the inverse problem where you're gonna see less people charged for that conduct because that C is so out of line with where the rest of the penal code is with respect to threatening. Senator Kiss for the second time.
Thank you very much, Chairman Staffstrom, and for what it's worth, I'm in agreement with the good chair. I'm gonna use just a sort of a low-level example, but I used to chuckle to myself even prior to becoming a legislator over 30 years ago. On Palisado Avenue in Windsor, as I was traveling home, I would see a sign and it said penalty for littering like $495. And I laughed to myself saying, that's ridiculous. And when I talk to law enforcement, they go, yeah, we're never going to arrest anybody and charge them because that's a huge amount of money. So that law just never got enforced because it was too high. Now I think it's like $65 or something. Well, the person that has to give the ticket is much more able to do that because they're not going to bankrupt the person who threw something out of their car. I know it's sort of a minor thing. So I'm trying to figure out where the problem really is, because let's assume, and I'm sorry, I forgot your name, the marshal. What I like to know is, do you have data on how often these threats occur? And if a threat occurred across the street at the Supreme Court, is it the marshal that makes an arrest? Do you call the Hartford police that would make an arrest? Are arrests being made? Where's the system gummed up right now? Because I've heard the Chief Justice say, well, the state's attorney can't make a case. Well, they're not even going to look at the facts until there's an arrest. And I would think an arrest is part of the process of being a deterrent, because that's a big impact on someone's life right off the bat, whether a day or a week or a month later, the state's attorney says, I'm not going to move forward with these charges. So I think we all want to do something to help alleviate the concerns of our jurists and to Representative Osborne's concerns, people in the courthouse in general. But I agree philosophically that if we go wild ratcheting it up, and I think C is way too high, because if I'm a state's attorney, I have to get everything nailed down real solid before I even think about bringing that case. Where is the system actually gummed up from your perspective, Mr. Marshall? And if you could, again, say your name, so I'm not calling you by that.
Sure. O'Donovan Murphy, Director for the Marshal's Office.
Thank you, Mr. Murphy.
Thank you for the question. Actually, if it's an on-site threat that reaches the statutory level of a threat, and that's against anyone, whether it's a judge, the marshals would arrest the person and consult with the state police. If it's a threat that's being received by email or phone, that threat is evaluated. We try to identify the person along with our intelligence people using the staff at CTIC to identify the person. And then we'll work with the state police to have the state police determine whether or not they want to enforce the fact that the judge was threatened by phone or email. Those threats seem to fall off with the troopers where they're uncertain as to whether or not those types of threats are true threats. And the problem that we have with those threats are ongoing, they're consistent, and they are increasing. So we see the threat as a threat, and then we have to watch for that person. And I think it's getting gummed up with the interaction between the two agencies. So on site, yes, the marshals make the arrests. Off site, we have to depend on the state police.
And I really appreciate that. And I appreciate what the chairs are saying, because we do have a list of people and I don't want to slow it up. But I'm willing to work with you folks. I think that we need data. We've done this in other areas, especially our criminal laws, but the system from the threat, perceived, real, however written, however, and then what transpires. And I think that all of us would work together to try to make sure it doesn't get gummed up. And that's not necessarily always enhancing the penalty, because again, as Chairman Staffstrom said, the higher the penalty, I think sometimes the colder the feet of the state's attorney that actually has to say, this is the plea offer, and if you don't accept it, I'm willing to go to trial, and because I think I can make this case. And sometimes in our desire to enhance the penalty, we undermine the ultimate goal of making sure justice is meted out. So I think it's complicated, and I think that the ambit might be a little larger than just the jurist. But I think that we're willing to work with you, and whether we can cross that finish line this session or not. But I think we have to sort of dissect it more granularly to get to where we want to go. And that's sort of what I'm throwing out there. So more data to me would be very helpful. Thank you, Mr. Chair.
Thank you. Further questions or comments, Representative Fishman, briefly, second time?
Yeah, I will be brief. you know, I just wanted to, you know, Melissa, Representative Osborne mentioned about, you know, lawyers and especially family cases, you know, I can tell you, I had a case, domestic violence, I'm representing the mom. Kids are being abused in the home and the father had a history with DCF. Now DCF records are sealed for the most part, but I knew about it. And I'm sharing with the court what I knew about the DCF records. And we took a recess. We're coming back in from recess. The guy comes up to me behind me and says, if you mention anything more about my record, I'm going to visit you in the middle of the night and kill you. You know, the marshal's not there to get involved in that. You know, I was gone after in the Meriden courthouse, ended up 4 marshals and a bunch of pepper spray. Now, if that had happened outside, I may have had difficulty. You know, so, you know, marshals are there in the courtrooms, but I think we have to be cognizant. I mean, Julie Porzio was shot in the Middletown, the parking lot, the Middletown courthouse, a lawyer representing somebody in a family case. So, you know, I wish we could all just get along. Ultimately, I just, I'm not in support of what's before us today. So thank you.
Further questions or comments? If not, Mr. Chief Justice, appreciate you coming over. Don't be a stranger. Hopefully we'll see you again soon.
Thank you.
Bobby Riddick. Bobby Riddick with us online. If not, Carol Ann Brown. Go ahead, ma'am.
Good morning, Chairman Winfield and Staffstrom, and distinguished members of the Judiciary Committee. My name is Carol Ann Brown, and I'm the Director of the Racial Justice Project at the Center for Children's Advocacy. The Center for Children's Advocacy wholly supports Senate Bill 688 and urges the committee to pass this very important bill. I am here to testify in addition to my written testimony on Section 8 of this bill that would extend the provision of Connecticut General Statute Section 54-1M, the Alvin Penn Racial Profiling Prohibition Act, so that racial profiling data is collected on all police stops, whether traffic or pedestrian, giving a full and complete picture of any racial profiling that takes place in the state. The problem we have in Connecticut is racial profiling data is currently collected on traffic stops made by police. While helpful, limiting data collection to traffic stops omits any view at racial profiling that takes place during the pedestrian stops on the streets. Collecting data only on traffic stops also omits any glimpse at stops that impact youth under 16 or youth who do not drive. Racial profiling of Black and Brown people is a common problem in Connecticut and across the country. More specifically, youth of color complain about continually getting harassed by police officers while walking down the streets or congregating with their friends. In the inner city, most kids have no place to go and they're hanging out and getting stopped if they are a particular color. Youth are regularly stopped by police on urban streets, but there is no data on whether the stops are motivated by race or in law enforcement had a legitimate purpose. The youth of color detail their negative experiences with law enforcement in these situations. This has also added to youth's negative perception of law enforcement. Why is pedestrian stop data collection so important? By gathering this type of data, Connecticut can identify and combat racial disparities by providing a more comprehensive picture of police stops. This in turn will create transparency and better police accountability. It is crucial to reflect the reality of all police encounters, not just traffic stops. National studies speak to intense and damaging impact that repeated stops by law enforcement can have on the self-esteem and mental health of youth. There is a significant need to take a closer look at data that actually captures these experiences. The time for Connecticut to act is now. As I've outlined in my written testimony, jurisdictions like Boston, New York, Denver, Illinois, and Washington, D.C. are already collecting and analyzing traffic and pedestrian data. Knowing where the problem exists can promote the necessary police training to avoid implicit bias and unconstitutional stops. In effect, the reform would improve public trust for law enforcement. For the aforementioned reasons, CCA supports Senate Bill 688 and urges the committee to ensure its passage with recommended amended language, adding pedestrian stop collection data in Section 8. Thank you for your time, consideration, and opportunity to speak today.
Thank you. Questions or comments from the committee? Questions or comments? Seeing none, appreciate being with us.
Thank you.
Diane Larissella. Diane Larissella.
Yes, hi, I'm just turning on my video. Thank you. For the record, my name is Diane Lauricella. I live in Norwalk, Connecticut. I wanted to thank co-chairs Senator Winfield and Representative Staffstrom, as well as the esteemed members of this committee doing important work. Today, I just wanted to comment on, I support with some modifications or additions, Senate Bill 1023 relating to the operations of probate court. I was in a position that many of us don't hope to have. Several years ago, I graduated from Newtown High School. Unfortunately, my mother passed away. So that means at times that you need to come before a probate court. The experience that I and my family experienced leads me to want to speak today at this meeting, because I don't want to see what happened to us and to me happen to anyone else. I wanted to suggest that there be some additions considered for this particular important bill, Senate Bill 1023. The first is, I believe that when we're talking about line 21, when we talk about, I do believe, first of all, that probate court is such an important place. It's a place where there's a lot of emotion at times. There needs to be, of course, a facility that not only protects the workers in the probate court, but also gives comfort as well as privacy to the people that are coming to probate. Line 21, I suggest you add additional lines related to necessary stationery, other things that a probate court or any court should have. That includes one thing that was missing from the day one that we had to encounter probate in the Bethel Newtown court was a lack of a flyer, a simple flyer explaining the services that are afforded those that come before probate. This would have helped in many ways, helped us avoid the destruction of our family bond because of the lack of transparency about all of the things that can happen. There, of course, on probate on the website, it states that families don't necessarily need to hire an attorney. And in the spirit of that, what would be helpful is that there needs to be a flyer that explains just in bullet points the different services. One thing that was missing, and we should have been informed at the get-go, is that there is a sanctioned mediator services for probate to try to avoid having to hire an attorney. But even if an attorney is there, the children, the parents.
Thank you, ma'am. That's our 3 minutes. Questions or comments from the committee? Questions or comments? Seeing none, appreciate you being with us.
Yeah.
Catherine Hill. Go ahead.
Senators Winfield and Kissel, Representatives Staffstrom and Fishbein, and distinguished members of the Judiciary Committee, thank you for the opportunity to provide testimony today in support of Senate Bill 1196, specifically the section regarding strip searching. My name is Katie Hill. I am an epidemiologist who studies health and incarceration, and I'm currently a PhD student at Yale School of Public Health. Additionally, I'm a steering committee member of Stop Solitary Connecticut. Strip searches are a form of state-sanctioned sexual violence that is being committed daily against men, women, and children in our state's prisons and jails. When I spoke about this bill with currently and formerly incarcerated people about their experiences with strip searches, many revealed that they felt preyed upon by correctional officers who conducted their strip search. A comment about their vulva size, a judgment about their vaginal discharge, a mention of the size of their testicles, laughing, snickering, a suggestion that they should meet up later for sex. Now, please know that this is more than just sexual violence. This is deeply rooted in the fact that mass incarceration is a race-based system with roots in slavery. Solomon Northup in 12 Years a Slave states that during auctions of enslaved people, quote, sometimes a man or woman was taken back to the small house in the yard, stripped and inspected more minutely. Scars upon a slave's back were considered evidence of a rebellious or unruly spirit and hurt his sale. And I hope you find that as devastating as I do. Now, I'm sure you hear today that strip searches are some form of necessary evil in order to reveal contraband and ensure the safety of staff and incarcerated people. Yet, strip searching is an abuse of power that plays out in the form of sexual violence. Further, correctional officers do not need reasonable suspicion that an incarcerated individual has contraband in order to conduct a strip search. The Department of Corrections can and should invest in body scanning technologies to search for contraband and require that all individuals who enter correctional facilities, including staff, to pass through these machines. Note that these scanners have been instituted in states like New York and Tennessee and have been used abroad as well. And scanners have great success at detecting concealed substances without making people remove their clothes. Additionally, if strip searches are deemed necessary, in Connecticut Department of Corrections, correctional officers should document all strip searches, including information about the basis of the search, the gender of both the officer and the incarcerated person, and the result of that search. Thank you again for this opportunity and happy to answer any questions you might have.
Questions or comments from the committee? Representative Fishman?
Thank you, Mr. Chairman. Good morning, Katie. How are you?
I'm good. How are you?
You mentioned you're an epidemiologist. When did you become an epidemiologist?
Sure thing. So I have my master's in public health and epidemiology from Milken Institute School of Public Health at George Washington University, and I received that in 2022, last year.
Okay, so I'm just trying the connection. Is epidemiology connected to your advocacy here today?
Yes. So, I mean, I've focused on a lot of different health issues related to incarceration, substance use and infectious disease. So a lot of HIV and hepatitis work as well. But for me in the context of sexual violence and strip searching as a form of sexual violence, you can think of many health impacts that result from one experiencing that form of trauma, including anxiety, depression, PTSD, sleep disturbances, suicidal ideation, and many other forms of trauma that will stick with individuals while they're incarcerated and as well as they return to their communities.
So I'm just trying to figure out, are you working in the field with prisoners today?
Am I entering prisons currently?
No, I'm just trying to get the connection between, the epidemiology, and you've testified,
Sure thing.
Anecdotally about effects, and I agree with some of that stuff. I'm just trying to,
Yeah.
Is it something that, are you working for corrections or something? Or
I do not work with the Department of Corrections. I am a part of Stop Solitary Connecticut as an advocate and an activist. And I do research with Yale School of Public Health, though I am not testifying on behalf of Yale School of Public Health. My statements are my own. But I do work in clinical trials and independent research with multiple faculty members at Yale School of Public Health on incarceration and health.
Okay, I got that. Your representative capacity. You testified that strip searches are happening on a daily basis.
Mhm.
Where does that data come from?
Sure. So the administrative directive, I believe 6.7 describes strip searches, and that's what Department of Corrections is using to administer strip searches. And then additionally, from conversations with previously and currently incarcerated individuals, I've spoken to many folks over their phone for their allotted time, as well as previously incarcerated individuals, which I believe you'll hear from today on the speaker lineup. And you can ask them as well, but people are getting strip searched pretty much every time they're moving around a facility. So if somebody's going to and from a healthcare visit, a legal visit, a visit with friends and family, trying to speak with a clergy member, things like that, transition between facilities, they will be strip searched upon their return and when they leave.
So I was just trying to ask, because we had somebody recently come before us who claimed that prisoners are dying in prison every day.
Mm-hmm.
And I found that wasn't true. So I'm just trying to figure out, by what
Yeah.
mean, how many strip searches happened yesterday in our prisons?
Yeah, and I think that's a great question. And I think really points to the need for this bill in terms of record keeping. I think that is something that we would love to know. And I think we are reliant on anecdotal evidence from incarcerated individuals, which is certainly important and I believe to be true. But I think it really speaks to the need for having record keeping in this area. So we really do know how many searches are happening. And I believe that they're definitely happening daily. Whether or not someone gets strip searched daily, that will depend on their movement throughout the facility. But they are certainly happening daily at the facility.
So do you believe in your support of this bill that strip searches should never happen?
So I think that there is potentially need for strip searches occasionally. And I think you'll see in the bill that we are really focused on the routine strip searching without a reasonable suspicion. So folks are strip searched kind of as a blanket policy, even if there's no reasonable suspicion. So for instance, I spoke with a woman who was pregnant and left the facility handcuffed. She was with an officer the entire time, and she delivered her baby again with an officer the entire time, and on return to York Correctional was strip searched. And she had just delivered a child, scars still fresh, and was forced to remove all of her clothes, bend at the waist, and cough, right? And so she had just delivered a child. Whether or not I don't believe that in those situations that's necessary, nor if someone has been completely isolated and in the presence of an officer. I'm not sure where they would expect contraband to be coming into the facilities in those instances, besides from a correctional officer.
Okay, so you're aware of the current policy that strip searches are not, under the current policy, not discretionary. You're aware of that.
That there's no reasonable suspicion. Is that what you mean?
Strip searches are not permitted under the policy, just on a whim. Are you aware of that?
Can you
Hold on, folks. We are going to have a public hearing here today, and the question needs to be able to ask questions. The witness needs to be able to answer. We can't have laughing, clapping, cheers, jeers, any sort of show of emotion from the public. All right, it's got to be, we need to let these two testify, ask questions. We need to get an accurate transcript and let folks proceed. All right.
Thank you.
Let me just, I'll ask the question a different way.
Thank you.
How does one who's at a correctional facility make the determination presently whether or not they're going to strip search a prisoner?
It is a blanket policy. So there is in the administrative directive, which I would be happy to provide you with. I don't have it in front of me, but it typically occurs between, like I said, the transfer between facilities or certain units in the facility. So if someone's moving from their cell to an infirmary, something like that. And then additionally to and from visits. And then there's also obviously strip searches that could occur in the case of like lockdowns. If there was something in terms of a belief that there's contraband, like we've heard from the commissioner that, for instance, if there was a missing syringe from the medical unit, that this place can go into lockdown and they can strip search as needed. Whether or not they recover anything is not understood.
Okay, so there is a written criteria.
Yes.
And what fault, you've reviewed the written criteria?
In the administrative directive.
Sure, and it's 3 pages long. Well, the last page is very short, so we won't give a lot of credit to that, but what part of the current administrative directive do you find fault with?
Certainly. I think that if it's the concept of this kind of blanket, any movement, you're receiving a strip search. I think that there should be some form of reasonable suspicion. I think incarcerated individuals should be protected under the 14th Amendment in terms of unreasonable search and seizure, just like any other person would. So I think in terms of just movement, when they've been in chains and they've been under supervision constantly from correctional staff, in my mind, the only way that they're receiving any what would be considered contraband per definition of the administrative directive would be from from a correctional officer, because they're the only folks with access to the outside world.
Okay, I don't see in the administrative directive anywhere that it's talking about what you're talking about. I mean, I'm looking at the list. And I'm not going to read the entirety of the list, but upon readmission to a facility from a halfway house, parole, special parole, transitional supervision, or any other community release program. I mean, at a level, strip searches with a confined criteria are in my opinion, protective of other individuals in that facility as well. So I know you don't have the criteria before you. I do. And I'm just trying to compare that to what's before us as far as a bill. And I don't find the hole that you're.
So are you looking at the current Department of Corrections Administrative Directive, Section 7, inmate strip searches?
Yeah, strip searches when regional suspicion is not
Required,
Yeah.
7A.
Yeah.
I just pulled it up. So you have number 2, when an inmate is unsentenced, charged with a felon. I mean, I could read through all of these. There's 1 through 6. So there's 11 potential instances when a incarcerated individual could be strip searched. So upon readmission to a facility, as you said, upon inter-facility or out-of-state transfer, upon entering or leaving a level 5 unit, upon initial placement in a specialized housing unit. Of note, that would be segregation, chronic discipline, security risk group member, medical inpatient, mental health, protective custody, restrictive housing. So even right there, I mean, I have 5 other reasons I could go through, but if we talk about medical inpatient, mental health, restrictive housing, those individuals are being, monitored and surveilled by a correctional officer their entire time. If they're going for a mental health appointment, or going for a medical appointment, and they're under surveillance the entire time, and they're likely experiencing a health experience, whether it be a mental health crisis or just a doctor's appointment, I'm not sure that it's necessary for an individual to be strip searched to and from that appointment.
I wanted to wait for you to finish that. Out of respect, I didn't want to interrupt you, but if you look at the beginning, you just read that list, right? What's the first sentence before that list starts? It says upon initial placement. It doesn't say during incarceration.
It says
Right.
on admission or return.
No,
If you go all the way up to A2,
that's not connected to that list that you just listed. You were just talking about the list that's under Roman.
yes, but they will also be when they return to their cell, because they would also apply for that.
No, but then now you're going up to Roman 2, and now you're talking about other criteria, but the 6 that you listed have to do with initial placement. So I appreciate the exchange. I look to see, where that hole is, but thank you for coming here today.
Certainly.
Questions or comments from the committee? Further questions or comments from the committee? If not, thanks for being with us.
Thank you.
Ben Howell.
Good afternoon, Senator Winfield, Representative Staffstrom, and the other members of the Joint Committee on the Judiciary. My name is Benjamin Howell. I'm a physician. I live in New Haven in Senator Winfield and Representative Dillon's district. I am faculty in the Yale School of Medicine. I'm also faculty in the SAGE Center for Health and Justice, where we focus our research on understanding and remediating the health consequences of incarceration. This testimony represents my views only and not those of my employers. I am testifying in support of House Bill 6875, which would ensure that all people returning to the community after incarceration will have state-issued identification. I think the important issue around this bill is that release from incarceration is an extremely challenging experience. People reentering the community have to navigate numerous challenges in the process of reintegrating to society, obtaining housing, reintegrating with their families and communities, finding employment, and just meeting basic needs. Not surprisingly, reentry is associated with high rates of unemployment, poverty, homeless, and social isolation. These barriers also mean that it's associated with high worsening health and high risk of death. People released from prison have 12 times the risk of dying in the first 2 weeks after release. In the past, this committee has already acted to attempt to address the seemingly small but crucial gap that hinders the ability of individuals to navigate reentry, having proper state-issued identification at the time of release. Unfortunately, the laudable goals of those reforms have not been realized. I can speak to the experience of those in the Transitions Clinic Network in New Haven, Bridgeport, and Hartford, that almost half of our patients do not have struggle with the fact that they do not have proper identification after release from incarceration. I think our experience are echoed by many community organizations, individuals, reentry centers, housing and health providers throughout the state. Proper identification is necessary and oftentimes, crucial portion of reentering society. It is needed to gain employment, open a bank account, access benefits, access housing, and even access healthcare. And that barrier can be sometimes insurmountable to individuals released from society. Today, you will hear testimony from several people who have personally experienced incarceration in the process of reentry and groups that work in the state with them. I encourage you to listen closely to their stories about the challenges that come with the lack of proper identification. I think their stories reflect a common experience of people reentering community after prison and jail. I think enacting the changes described in HB 6875 are necessary to ensure that people leaving incarceration have proper state-issued identification, a crucial tool needed to successfully navigate life upon reentry. Thank you for this opportunity to testify, and I'm happy to answer.
Thank you.
any
Questions from the committee? Representative Fishbein?
Thank you, sir. What's your name again?
Dr. Benjamin Howell.
Okay, thank you, Dr. Howell. I thank you for coming here today. I'm totally sympathetic to what's before us.
Sure.
I have experience with family members being incarcerated. I know how difficult it is. Very happy that at least one of them is getting on well with his life. My concern, though, with this bill as drafted appears in line 31. And it says not later than 24 months prior to date of release that this is going to happen. My concern is, what if they're not in for 24 months?
Touche. I will defer James Bondari Alexander, who's a lawyer who's looked closely at the language and helped draft it, will be testifying later. I defer to him on those specifics, but I agree, sort of making sure we get this right so that we achieve the goals that we're trying to achieve makes sense. I defer to you all to how that is crafted to make sure that's achieved, and I agree, sort of making sure that those timelines make sense.
Yeah, I
is
just
important.
wanted to flag that.
Yeah.
So I, once again, thank you for coming here today and your advocacy in this area.
problem.
So, thank you, Mr. Chairman.
Further questions or comments? Representative Winfield?
That's cool. I was a rep. I was. Good morning.
Morning.
The bill before first, let me just say I thank you for the work on it. We thought we got this right a couple of years back. Apparently we didn't. We're here again for I don't know which time this is, but yeah, it is Groundhog Day. Aside from what Representative Fishbein just pointed out, are there other parts that you think may need some work? And if so, what are those parts?
Can you repeat the question, Senator Winfield, so I understand?
In terms of the language of the bill, right? Representative Fishbein just pointed out that there's an issue potentially with the 24 months. And I think that may have something to do, and I'm sure Mr. Bandari Alexander will explain it, but I think that has something to do with the fact that the department generally in conversation will talk about 3 years prior to, right? So I think that's where the 24 months comes from. But I was asking if there were other things like that that you had noticed in the bill, since we are attempting to get this right for the
Sure.
final time.
Again, I will defer to Mr. Bandari Alexander, but I think the important thing is making sure that we get this right. And that is the conversation with the DOC as well as the DMV to understand sort of what are the timelines they need to make this happen. What, paperwork do they need for each individual to make sure that this process can move forward, any other barriers, and just to really get it right this time. I will, again, I don't know the inner workings of the DOC or the DMV and sort of what those processes look like. And that's where I will defer to them to make sure that we don't make it a discretionary that they attempt to do this, or that we advise them to do this, but then the fact that they figure this out.
Well, on that, I could say more about the DOC, but the commissioner will be here later. We'll have that
Sure.
discussion. Thank you.
Further questions or comments? If not, thanks for being with us.
Yeah, thank you very much.
Curtis Hudson. Go ahead, sir.
Okay. Oh, it's already on. Aloha, Senator Winfield, Representative Statrum, and ranking members of Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. My name is Curtis Hudson. I'm from New Haven, Connecticut. I'm a smart justice leader with ACLU of Connecticut, and I am here to testify in support of House Bill 6875 regarding IDs for people who are coming out of incarceration. I believe in a society where all people, including people who are coming home after being in prison, should have an equal opportunity to build successful and fulfilling lives. But Connecticut is behind the times. Having an ID is foundational and to begin to reintegrate into society. But instead of supporting people so that we can thrive in the community, Connecticut makes it extremely difficult without a proper identification. To obtain employment, housing, insurance, and just about anything else you need, this is not a good for individuals, and it is not good for our communities. When a person is released from incarceration, they have earned the opportunity to rejoin society. They need and deserve the ability to move forward. Making sure they have the ID is a basic and critical step so that they can be productive members in our community. I am a person who has been through the reentry process in Connecticut and other states like New York. They recognize how important it is to have an ID and make sure either before you leave prison or when you get to the halfway house, they'll walk you down to DMV to have this process done. HB 675 provides direction to the Department of Corrections to create a system that will give every person the essential document like a birth certificate or a social security card and the IDs that we need when we leave incarceration. And the bill also directs DOC and DMV to waive the cost of getting these documents, because when you get out of prison, it is hard to have these, if you're working on the wages in prison, you know how hard it is to have money. And basically, in closing, I would like to leave you with a poem from the late poet Khalil Gibran, and he says, "We are all prisoners of this world, but some are in cells with windows and some without." And thank you for listening.
Thank you, sir. Questions or comments from the committee? If not, Senator Winfield.
I just want to clarify, because part of how we are here today is the conversation about birth certificates, social security cards. The focus that we have is on driver's licenses or non-drivers state ID cards, right? So I just want to clarify that that's your understanding, certainly my understanding. I'm not sure it's everybody involved's understanding.
Right. Well, that wasn't my understanding, but I get it now. And I understand that, and that's true. But all we're just saying how it's so important to have ID when you get out, because if you don't, it's like they make us send mail to ourselves 3 times, and that could take, forever, But
No,
I hear what you're saying. Thank you, sir.
I get it. It's hard to go to a job with just a social security card. So Thank you very much. It's good to see
Thank you. Thank you, panel.
Further questions or comments? If not, Chris Shabani. James Ruhandari Alexan. Bendari Alexander. Okay, you know what? It got cut off on the sheet. Sorry about that.
No, no problem at all. Thank you so much. Thank you to the committee leadership and to the whole committee for having this hearing. I'm here to testify on House Bill 6875, the ID issue. I work as a medical legal partnership director at Yale Law School, and what I do is I work with law students with patients who have health harming civil legal needs, which means doing legal aid work for patients. And one of my assignments is to work with students at Transitions Clinic, which serves people coming home from incarceration. I've been doing this work for about 2.5 years. And the first day I was at this new position at Transitions, I was talking to the doctors about what the common health needs are of people returning home from incarceration. And I was surprised to hear the medical staff and community health workers immediately talk about IDs, because I didn't consider that a health condition. But for our patients, this is one of their greatest barriers, as has already been described, is the fact that they don't have an ID. I've submitted written testimony, so I thought I would use my limited time to address. I see Rep. Fishbein left, but for the record, some of the things that he identified, and also some of what I saw in the commissioner's testimony. First of all, to be clear, what we're talking about is driver's licenses and official state IDs as what should be issued before someone leaves. That's what's going to help someone get housing, employment, and access to healthcare. If you look at the numbers that the commissioner provided, quite the overwhelming majority of identification, in quotes, that are provided to people currently come in the form of Social Security cards and birth certificates, which are not the type of ID that this bill would require. This bill would require proper state identification. On the question of someone with a shorter than 2-year sentence, I think quite simply, the work to get someone with less than a 2-year sentence an ID could just begin the day they come into the facility. And that certainly would not violate this bill, and it seems like a pretty easy fix. Another concern that the commissioner raised is that there are federal limitations on IDs that come with the Real ID Act, which is a federal act. The commissioner identified that they're only allowed to get Social Security cards for people 6 months from release. But I would just note, I was looking this morning at the Social Security Administration's program and administration manual, which is online, and that's just been changed to a year for federal facilities. So we could probably do that too. And the reason we do want Social Security cards is that that might be a precondition for someone getting a real ID. And I'll leave it at there, and happy to take your questions.
Thank you. Questions from the committee? Senator Winfield?
No, but just hello. Good
All
to
right.
see you.
Nice to see you.
All right. Appreciate being with us. Alundin Islam.
Members of the Judiciary Committee, I want to thank all members of the committee for the opportunity to speak. My name is Al-Erdun Islam, and I am a justice advisor with the Connecticut Justice Alliance. Today, I raise my support for HB 6888. To come across the opportunity to implement various youth justice policy changes is more significant than any words I could possibly string together. Diverting young people en masse away from the wrong road by expanding community-based programs is not only a tangible preventative measure for curbing violence and crime, but also keeps the community intact and raises the possibility of mending broken ties between neighborhoods that have more in common than they may have originally thought. I have seen it work just 2 hours from here in New York City. The Neon Arts program was placed in the 7 neighborhoods with the highest rate of crime, all of which were from separate boroughs or different neighborhoods within the same borough. Through the steadfastness of the program, I have watched relationships be built, not only amongst peers, but also with people you likely never catch in the same room together, if not for unfortunate circumstance, like youth from the inner city and law enforcement. To put someone coming home from incarceration on an exalted character by adhering to the pre-approved plan based on responsibly reintroducing them into society is rehabilitation at its core. So often those coming home have no idea which way is west from which way the sun sets. If the objective is true correction, then what could be more correct than making sure someone has a feasible plan they can apply to the outside world so that they do not recidivate? Many of us do not have to deal with the insecurity of wondering if we should save for this hygienic product or that form of sustenance. There is, however, a section of the population whom we refer to as indentured, who do have to penny pitch for things that would be taken for granted in our day-to-day. If pennies exist in their account, seldom do they. We had the wherewithal to make the phones in the judicial system a right in the state of Connecticut some time ago. A leap in the direction of fairness and humanity's existence, no doubt, but better than that would be a follow-up step to ensure funding for a comprehensive commissary implementation plan. Finally, the transition of any person under 18 from the Department of Corrections to the care of the judicial branch is imperative to providing the type of environment needed for that young person to truly prosper. The DOC is not equipped to deal with the underage, and the time and resources it would take to equip the department with the training required to take on such a task would be unwise in that form. While the need for reshaping the culture of prisons is an overlooked aspect of rehabilitation, children 18 and younger do not belong under the custody of the Department of Corrections. Instead, close to home non-prison-like houses with staff equipped in de-escalation tactics and mental health personnel in place throughout the duration of the day and night are alternatives in which our focus should stay. Thank you.
Thank you, sir. Questions or comments, Senator Whitfield?
Not on your testimony directly, but have you testified before?
Once.
Once?
Yes, sir.
Before this committee? Because I don't remember. I would have.
Online.
Oh, okay.
That's probably why it was late at night. I was like 167. Y'all did me dirty. Well,
Not by intention.
I understand. It's all forgiven.
I don't remember that, so I might have not been here, but I just want to say this, you were really, really good. And I hope you testify before us again. Your voice is something that I think people will pay attention to. So thank you.
Inshallah. Thank you, sir. Is there any questions?
Think you're good. Appreciate being with us.
Have a good one, y'all.
Manya Saunders. Manya Saunders with a thumb line. How about Ken Wright? Ken Wright. Tracy Bernardi.
Hi, I'm here. Good afternoon.
Go ahead.
My last name is Tracy Bernardi Guzman now, for the record. Today, I would like to testify before you on Senate Bill 1196 and House Bill 6875 regarding IDs for people living with incarceration. As far as people leaving incarceration. Sorry, there's a bad connection, I think. I'm not even sure. So good day, Senator Winfield, Representative Stafford, Ranking Member, Senator Kissel, Representative Fishbein, and all of the distinguished members of the Judiciary Committee. As I said, my name is Tracy Bernardi Guzman. I'm a resident of Waterbury, and I'm a leader of the Smart Justice Campaign at ACLU Connecticut. I am testifying today in support of two bills, SB 1196 regarding strip searches and HB 6875 regarding state IDs for people leaving incarceration. According to the 2003 Prison Rape Elimination Act, PREA, the Connecticut Department of Correction does not tolerate sexual abuse or sexual harassment of any inmate. In fact, it states that they have a zero tolerance policy. Conversely, it, however, allows staff, guards, and other members to literally coerce people to strip naked against their will and through threat of punishment. In fact, through threat of punishment. For 23 years, I was strip searched hundreds, if not thousands of times. I was ordered to lift each breast, shake out my hair, ordered to face the wall, squat and cough, and then to bend at the knees and spread my butt cheeks and cough. However, honestly, I felt as if I was being raped and abused over and over, to the point where I have severe post-traumatic stress to this day. I knew that if I did not comply, I would be punished. It was like stripping at gunpoint. I once witnessed a group of staff at York CI knock a 300-pound elderly Black woman out of a wheelchair in the West Side gym because she refused to take off her clothes. Everyone in the gym witnessed the guards, including a counselor and other brass, tackle her to the ground and mace her, all because she refused to comply with a strip search. Mind you, she had lupus, she had recent heart attacks, and could barely walk. We all knew we did not have the right to refuse to be stripped, and we would likely be sent to solitary confinement if we refused. I rarely, if ever, saw any real justification for strip searches in my 23 years of incarceration, other than to embarrass, shame, and dehumanize the women who I knew were trying to survive in an incredibly difficult chapter of their lives. I also wanted to mention my support for HB 6875. As a full-time reentry case manager in Waterbury, I can tell you it's extremely difficult for a person who's coming home if they don't have ID. There are men in halfway houses with job offers. They cannot.
That was the bell. Appreciate your testimony. Thank you very much. Seeing no questions, appreciate being with us. And I'll just note for the record, I know it's hard to hear the bell online, so I'm not trying to be rude, cutting you off, but just trying to make sure folks are aware of the time.
Can I just say one last thing, sir?
No, there's no questions from the committee. We appreciate your testimony, and certainly we'll review written testimony as well.
Okay.
Nicholas Buckland. Nicholas Buckland.
Hello, can you guys hear me?
Yep, go ahead, sir.
Good afternoon, gentlemen. As you stated, my name is Nicholas Buckland, and I am a corrections officer at Cheshire CI, approximately 9 years on the job. And something I wanted to speak on behalf is the strip searches and how important that they are. I can only speak on the safety of the inmates and the staff that works there and what has been found during strip searches. For example, in 2015, an individual was locked up by Bridgeport PD. He committed a crime. He had a gun on him, and he made it through the weekend lockup. He made it through the court, and when he got sent to Bridgeport County Jail, another individual advised him that he was going to be strip searched, which caused him to dispose of the weapon. Now, staff had found that weapon because another inmate had told staff, but could we just imagine what could have happened? The offenders that could have possibly been hurt. Something else we have to think about is all the contraband that gets in. A fellow coworker of mine, Stephen Adams, he was strip searching an inmate in the RHU process and found a cell phone. Anybody who's been in the facilities know that cell phones are not allowed. We also have to think about the drugs. A lot of times when we strip search these inmates, we do find drugs, and fentanyl being the new drug of choice in the facilities, it's paramount that we find that. I know that I personally have found drugs when inmates were going through the strip search policy. It's not just for the staff, it's for the inmate safety. I spoke with the intelligence officers at Cheshire yesterday, and just recently they found a tattoo gun that was taped on the inside of the offender's leg in his groin area. We would have never found that unless they did their job, because those tattoo guns carry diseases because they use them on each other. That's all I really have to speak on that. At the end of the day, we got to keep the inmate population safe,
Thank you.
along with all the other staff that work there.
Thank you, sir. Questions or comments in the committee? If, Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony. Just one question.
Sure.
Could you tell us the percentage out of 100% of the time when you're doing these strip searches, how often is it that contraband is actually found during these strip searches? Do you have that information? Through you, Mr. Chair.
So I do not have that information because of the amount of strip searches that I have done, being down in the AP area, whether it be in the RH2 area, what the case may be. But I'm sure there are plenty of examples that can be given by other staff members if they were invited to this hearing. And if anybody who's ever been in a facility, worked in a facility, they would know that.
Thank you for your response. And I do know that, sitting on this committee and also in some of the subcommittees for appropriations, that information has been, it's my understanding that the percentage is very low. So that's why I was asking, since you're actually in the facility doing the work, but I do appreciate your response and the work that you provide there. Thank you, Mr. Chair.
Thank you.
Representative Dillon.
Thank you very much, Mr. Chairman. And thank you for your testimony. And I know that the job can sometimes be difficult, but I'm concerned about gender differences in terms of strip searches as well. Are you aware then of any patterns in that regard?
So I know that if a individual, how can I say this, identifies as not a male, I work in a male facility. If they request to have a female staff member per directive, we have to oblige by that. And I've known in the past, other officers were called to do it and they did it with no issues.
But you had to make the request. It was not protocol.
If a inmate in Chester, because that's where I work, it's an all male facility, and that offender requests to have a female, then the staff has to oblige and give the offender a female staff member.
And I'm not making a claim that females are always better either, but I am thinking about the sensitivity of searching and there are implications,
I know that in the RHU strip searches, because that's typically when a lot of those happen, they're always on camera. So it's always documented.
Okay, well, thank you very much for testifying today.
Thank you.
Thank you. Further questions or comments? If not, thanks for being with us, sir.
Take care.
Kevnisha Boyd.
Good morning. Can you see and hear me?
Yes, ma'am. Go ahead whenever you're ready.
Dear Senator Winfield, Senator Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Kevnisha Boyd, and I live in Hamden, Connecticut. In solidarity with Stop Solitary CT, I stand in support of Senate Bill 1196. I'm a licensed professional counselor and former mental health counselor for the Department of Corrections. I understand the importance of restricting, degrading, and humiliating body cavity searches with no reasonable justification. I resigned from the Department of Correction in 2019 due to being vicariously traumatized due to the pervasive dehumanization of incarcerated people. One of the most disturbing aspects of being a mental health counselor for the Department of Corrections is being the gatekeeper of sexual violence, abuse, and offensive behaviors infiltrated by correctional staff. As a mental health counselor, my office was the safest space for incarcerated people to disclose their experiences of sexual violence and the impact of degrading strip searches. Incarcerated people often choose not to report sexual violence during strip searches because the result is punishment, being ostracized, and being isolated. Incarcerated people are often left with the shame of being violated and the pervasive fear of being retaliated against. In my experience, reporting sexual violence from employees was typically discouraged by correctional staff. Due to the rigid chain of command, the stories of sexual violence against incarcerated people go unheard. Today, we hold space and hear their stories with an urgency to make the necessary changes to keep incarcerated people safe. Degrading strip searches experiences limits the therapeutic effectiveness of correctional healthcare staff. My observation of strip searches reminded me of images of slave auctions taking place in an open area with no privacy and a disregard for humanity. Escorting incarcerated people to my office after seeing them naked was always uncomfortable. These strip searches create barriers for incarcerated people to feel comfortable participating in mental health assessments, limiting their access to mental health services. The pervasive traumatization of strip searches impedes on incarcerated people's desire to heal and rehabilitate. Ultimately, unreasonable strip searches induces trauma as a degrading and excessive practice. Senate Bill 1196 will ensure incarcerated people are safe from unnecessary violation of privacy and sexual violence. I urge you to pass Senate Bill 1196 as meaningful legislation to protect the lives of incarcerated children, women, and men. Thank you, and I'm open to questions, please.
Questions or comments from the committee? Questions or comments? Seeing none, we appreciate being with us.
Thank you.
Brian Donahue. Brian Donahue. Justin Elliker. Now with us, Olivia Rinkus.
Thank you and good morning to the Judiciary Committee for the opportunity to testify. My name is Olivia Rinkus, and I'm a resident of North Stonington, Connecticut, and also a student at the University of Connecticut. And I'm testifying today on several bills. I would like to first testify in support of HB 6875, an act concerning the issuance of a state identification card or motor vehicle operator's license to a person being discharged from a correctional facility. The lack of a driver's license or state-issued ID card is a barrier that prevents individuals re-entering society after being incarcerated from obtaining resources such as housing, jobs, and other resources. I strongly urge legislators to pass this bill out of committee and ensure that people leaving incarceration are able to meet their needs. I'm also testifying in strong support of SB 1196, an act concerning procedures of the Department of Corrections relating to strip searches and the transfer of persons who are incarcerated between correctional facilities. People in the custody of the carceral system are human beings and still have the right to be treated with dignity and respect. The use of strip searches is dehumanizing. It's a violation of the 14th constitutional protection against unreasonable searches and a violation of human rights. It's a source of trauma, according to individuals who experience it, which can exacerbate or even create new mental health needs. I urge Connecticut legislators to pass this bill out of committee and protect the rights of individuals in the carceral system. Thank you for the opportunity to testify.
Thank you, ma'am. Questions or comments? Seeing none, we appreciate you being with us. Carlos Robolo. Carlos Robolo. Andrew Ramsey. Go ahead, sir.
Yes, good afternoon. Senator Winfield, Representative, and all staff who are there. My name is Andrew Ramsey. I'm currently living in West Haven. I've just coming home from doing a 30-year prison sentence. I've been home now maybe close to a year and a half. And I'm here just to testify on HB 6875. And basically, I just want to share with the committee about coming home from incarceration and the struggles that we have when we come home. I came home on a thing called a compassionate release. When I came on a compassionate release, there was nothing there for me as whereas to get an identification card or driver's license and things like that in that area. Just bear with me. I was incarcerated when I came home. I didn't know if I have certain documentation, but when I did come home, my parole officer that's told me basically try to get a job and knowing that I will be taking urinalysis from you once a month. I asked him basically to help me out in the areas of getting some kind of identification to get a job. And his response to me was that wasn't his job. So I'm just here today to talk to the committee about that, how struggling it is for a person being incarcerated for 30 years and coming home and doesn't have the proper identification to get a job. Right now, I'm employed at a place called Emerge in New Haven, Connecticut. It's called Emerge Inc. And these people work with people who are formerly incarcerated. Right now, I'm a supervisor at that job. And how I got the job, I went to a job fair, and the only identification I had was a prison ID from the federal system. And I had an ID that my parole officer gave me. And on the ID is just basically a card to show that if I get stopped by anybody, this is who I am. But whereas having a social security card, a state ID or anything like that, I do not have it. And I'm still till this day trying to get those things right now.
Thank you, sir. Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm just a quick question. You said to this day you're trying to get this ID, and I'm just wondering when you actually were released. So how many months or days?
Well, I have been home now almost close to 2 years. When I came home, I was born in Kingston, Jamaica, but I'm a citizen of the United States because my mom fought for my citizenship and stuff like that. But since I've been incarcerated, my mom passed away and my dad. When I came home, all of my documentations was lost. So I had to file some kind of stuff to the Jamaica consulate to get my birth certificate. I got that, and when I went to DMV, they said that they need my social security card, they need a proof of address, and they was telling me they need some other stuff. All the stuff they asked me for, I gave it to them. The next step when I went there was back and forth, mailing back and forth. After I did that, I wrote to the Freedom of Information Act, and they sent me all the documentation to prove who I was. But till this day, right now, the company that I work with, they're the only one right now is trying to see if they could get me some kind of documentations to prove who I am. And all the stuff that I've went through and I show these people is like, it's still back and forth. Until this day, I still don't have no identification. The identification that I have, if you don't mind me showing you real quick, is this 2 identification I have right here. Where it's at. 1 second, I hope you bear with me real quick. These are the 2 identification that I have. Man, Julie.
Looks like my wallet.
I'm sorry about that. They gave me this. This is my prison ID I still have on me. And this is the ID the probation officer gave me. And on the probation ID, it says, the United States Probation and Protection Service. And every time I pull this ID out, it's like, it's a problem. Everybody's like a red flag. Who are you? What did you do? Stuff like that. I cannot fly on a plane to go to a next state or anything like that. So it's like, it's been a whole issue. And I prove to these people that I'm paying taxes. I paid taxes since the past 2 years since I've been home. I filed my taxes. I have a social security number that I use, but the card itself, I do not have that. And when I went to DMV, they're saying that I do need a physical card itself. And I'm like, how can I've been gone for 30 years. I've been gone for 30 years. I came home on an immediate release. So coming home on an immediate release, so many things going on. I don't have any health care and certain things. So it's like, and as I said before, I do not want to go back to what I know because I'm trying to change my life and live productive in society. And it's like, I don't know.
I appreciate it. And I appreciate you showing the IDs that you're having to work with. And just as a human being, it's probably easier for an undocumented alien to get an ID than for you. But the fact that you came from Jamaica probably has gummed it up a little bit, but 2 years seems like an exorbitant amount of time. So thank you for walking the straight and narrow and being a good law-abiding tax-paying citizen. And
Yes, sir.
We'll see what we can do. Thank you for your testimony.
I appreciate this. Thank you, sir.
How
Thank
much-
you all.
Hold on, sir. We got a couple more questions here for you. Representative Fishbein.
Thank you, Mr. Chairman. Thank you, sir, for coming here today. You give us a lot of knowledge. I just wanted to ask you, on the compassionate release, you said a few times that you were immediately released.
Yes, sir.
Once that was done by the Board of Pardons and Paroles, I believe. So once you found out that you were going to get out, do they just let you out that day, or was there a transitional period? What happened?
Well, COVID was bad, but it was a blessing for me as well because I filed a compassionate release during the COVID. And not to get into the main issue about my case itself, but when I got me a lawyer and everything, and when they told me that I had a life sentence, when they told me that my sentence was reduced, all they did was, all I know, they said they calculated my time, only time I had in. I had 30 years in, and all they did was a lady came to my cell that evening and said, give me a number, you got to go home. We got to get you out of prison. They didn't give me no kind of documentation. All they gave me, whatever amount of money I had on my commissary, they gave me a check for that, and they gave me a bus ticket and sent me off on my way.
All right, well, once again, thank you very much for coming here today.
Yes, sir.
That's extremely informative to me because, I have knowledge about how the transitional period process happens in other states. I can tell you it's not like that in my experience.
Right.
And
Well, I was in the federal system, and I'm from the state of New York, and I didn't have even an address to go back to New York. So my brother lives in West Haven, so that's the only address I had to give. So because they said if I didn't give them an address, I would be like homeless. So I had to find an address, and my brother had a home in Connecticut, and that's where I'm resigning right now in West Haven. And I came home that next morning. All I see was a parole officer, and he says that get a job, and I'll be seeing you once a month.
yeah, and the address itself is an issue because, that's tied to probation. So now
Right, right,
indicated as part of my release, this is where I'm going to be for
right.
probation purposes. And for whatever reason, you get there and, your brother's got 8 cats and you're allergic to cats and you can't gotta get somebody else, then they're going
Right.
to put you on your probation. So
Right.
I got it. I very much appreciate you coming.
Thank you, committee. I really do appreciate it as well.
Further questions or comments? If not, Mr. Ramsey, I think we have your contact info someplace, I believe. We're gonna have somebody from the committee staff reach out to you and see if we can ask a couple questions of DMV.
Yes, sir. I do appreciate it.
See if we can get to the bottom with DMV for you. All right, so be looking for an email from committee staff. on
Yes,
that,
sir.
right?
Have a great day.
Thank you, sir. Carl Alexander. Carl Alexander. Patrick McGoldrick. Oh, I'm sorry. Carl Alexander.
Good morning, Senator Winfield and members of the board. I'm speaking in support of Senate Bill 6875. On September 27, I was released from prison after serving 22 years. I received a commutation of my time on June 14th. I was sent to the halfway house in New Haven, Connecticut. And though one can imagine the excitement after serving 22 years of incarceration, I soon realized the barrier that exists in front of me because the lack of identification. I was unable to get employment, find employment immediately. I was unable to open a bank account and receive essential things like medical care. So these barriers that exist could have been prevented in many ways because it was a 3-month span that I had from June 24th to September 27th. DOC was aware of my release and I didn't receive no assistance. So I was forced to contact other returning citizens that went through this process and family members to get some funds to get my identification. Today, I stand in front of you, sit in front of you with my license, and because of this card, I was able to open a bank account. I was able to receive my CNA license, and become a productive member of society without barriers. So I'm in support of this bill, especially when you have returning citizens coming from Puerto Rico. There's no accessibility for individuals. I'm a resident today in the halfway house. It takes a minimum of 3 months for individuals to get employment. Or do we want this to continue on? Or could we just stop it at the head? And it's something as simple as connecting DOC with DMV without having these barriers that exist. So I hope that y'all in support of this bill and it can be a reality, because every day there's another Carl Alexander that's going to return to our community. Thank you.
Thank you, sir. Questions or comments? If not, appreciate you sharing your story with us.
All right.
Patrick McGoldrick.
Good morning or afternoon. I don't have the time in front of me. Chairman Winfield, Staffstrom, and the rest of the Judiciary Committee. My name is Patrick McGoldrick. I'm a corrections officer and chief steward of AFSCME Local 1565. I'm here today to express my vehement opposition to proposed Senate Bill 1196, Section 2, specifically regarding strip searches in correctional facilities. 12 and a half years of correctional experience has formed my opinion on this. I'll quickly relay a couple stories which show why this bill would have disastrous consequences for both staff members and the inmates who we are charged with protecting. Early in my career, I witnessed SRG, which is a DOC term for a gang member / a fellow SRG member in a rec yard with a piece of a razor, because a staff member did not conduct a thorough strip search prior to bringing that inmate into the rec yard. Years later, I was part of an escort for an inmate being admitted to the infirmary at Garner CI. During the strip search, a fellow officer found a sharpened crucifix in that individual's hair, which without a strip search, we would not have ever found. That particular individual admitted that he was planning on using that crucifix to slit his wrists later, which obviously would, is not in line with our job of protecting, inmates, sometimes from themselves, sometimes from each other. I could sit here for the next hour recounting similar occurrences, but I'll spare you. My main issue with this section is that it purports to protect the inmates who reside in our correctional facilities. In reality, it appeases those individuals who cause chaos within those facilities at the cost of the safety of the rest of the population and staff members and the public in general. The other main issue here is a legal one. The United States Supreme Court ruled in Florence versus Board of Chosen Freeholders in 2012 that correctional officers do not need probable cause to use a strip search to prevent the introduction of contraband in a correctional facility, which is what this proposed bill aims to require of correctional staff. In conclusion, while no individual involved, whether the staff member or the individual who's incarcerated, enjoys conducting strip searches, they're conducted professionally in accordance with strict administrative directives, which I believe some of my fellow members will discuss later. Put simply, this selection will allow drugs such as fentanyl, which has become more prevalent, weapons and other dangerous contraband to flow freely. The results will fall squarely on the shoulders of those who support this bill. Thank you very much for your time. I appreciate it.
Questions or comments from the committee? Representative Quinn.
Thank you, Mr. Chairman, and Mr. McGoldrick, thank you for coming before us today. Under current policy, can an officer just do a strip search, or do you need to get a authorization from someone higher up?
There's certain instances when strip searches are, no, I could not just walk up and say I want to conduct a strip search on a particular inmate. That just wouldn't make sense, and we shouldn't have that power. What we use them for is exiting and entering the facility, segregation placements, times where they have contact visits where obviously contraband is an issue. And also in certain cases, like an infirmary placement, like I work personally at Garner, where we deal with the mental health population. And obviously we want to make sure that, like in the example I used earlier, that they don't have something that could potentially harm themselves if they're going through a mental health crisis.
Okay, so you're saying then under current policy, you would get someone's permission before you did one?
No, that's standard in those situations. A segregation placement, like I said, infirmary placement. There is a supervisor present in those, and if that's what you mean by permission, I guess you could say that. But that's a standard practice where it doesn't leave up officers' discretion, and also prevents an officer from just deciding they want to do a strip search, which wouldn't happen. These are standard, set in place instances where a strip search would be used.
How often are strip searches conducted? Is this something that's happening all the time, or is it just under certain circumstances? I mean, in a normal shift for you, how many times would you say that one is needed to be used?
It depends on where you're posted. I mean, that's one thing. I mean, there's certain posts where you would never do a strip search. But if you're working in that admitting and processing room, inmates coming back from court or going out to court, a strip search is conducted. If you're working in the visiting room where you have contact visits, where you have people coming in from the outside, strip searches would be used. If you're working in like the restrictive housing unit, depending if people are being admitted into that unit, you would be doing them. And also, I'm just speaking specifically to Garner, the infirmary, where if you have an individual being admitted into that one of those units, you would be conducting a strip search, which is in those cases, there's a supervisor there, it's recorded. I mean, there's certain ways we record them, obviously, to protect the privacy. No one wants to, we're not looking to expose anyone. And we've improved that greatly over the time I've been in the department, as far as maintaining safety while also keeping in mind the dignity of the individual being strip searched. Because I mean, I do understand. I would, I personally wouldn't like it, but it's something we have to do, to prevent contraband, and in some cases to protect, an individual from themselves when they're in a mental health crisis, like I spoke about.
Okay, the way that I read this proposed section is that it wouldn't ban the practice, but it would require, one, a showing of probable cause, two, permission from someone higher than you, whether it be the shift commander or whoever is designated to take the shift commander's place, and then a filing of a form indicating that that has occurred. In and of itself, how would any of those things negatively impact your ability to conduct a strip search?
Well, I mean, first on the probable cause aspect, I'll bring up again the Supreme Court case from 2012. We're not talking a case from 100 years ago. We're talking 10, 11 years ago, where it was determined by the United States Supreme Court that probable cause inside the correctional facility is not needed to conduct a strip search. Just being that the environment is inherently dangerous. Contraband is a constant issue. And so that's one part of that. Also, the reality of that is logistically, it's not feasible that we would, in a case of, say, a large fight where 4 or 5 individuals are involved, that we would stand there and wait and basically bring the facility to a complete halt while someone filled out a paperwork, assuming a shift commander is on shift, which we don't have shift commanders on holidays, on weekends. Sometimes those posts stay unfilled for months on end. So the whole shift commander part of it is not realistic either. It's just not. That's why I'm trying to give you the reality of what would happen in these, especially an agitated inmate, that we would stand there with them for 20, 30 minutes while someone fills out a form, brings it to a shift commander, then gets permission. It's just not, anyone who's worked in a correctional facility will tell you that that's just not realistic in any way, shape, or form.
Okay. All right. Thank you very much for being here and sharing your thoughts on this.
Representative Dillon? Representative Dillon? Other questions, Representative Fishbein?
Yes, thank you very much, Mr. Chairman. I asked a question. Thank you very much for your testimony. I asked a question earlier about gender when it came to strip searches. In your experience, I know that you've outlined for us what you believe to be the difficulty logistically of approval, and I hadn't thought about weekends, but that's an interesting point on all sides. In your experience, is there any standard protocol for that? Is it up to the inmate to require to request if she's a woman that a search be conducted by another woman?
I would have to defer to some of my other fellow members who work at York, which is specific to, as our only facility for women. I'm sorry. I do know that at Garner, I've only worked with male offenders, inmates. Yes, a woman is not present when there's a strip search of a male going on. They actually oftentimes will have to be relieved by a male staff member so that there is no females present. I'm sorry. And then I would imagine at York, I'm sure they, males are not conducting strip searches. But again, I would defer to some of the other staff members who work at that facility to answer that question necessarily.
Thanks. I'd have to review the testimony we had within the past half hour. That it sounded like there was a little bit of a conflict, but I want to chase that a little bit. Thank you very much for your testimony.
Thank you, ma'am. I appreciate it.
Further questions or comments? Representative Fishbein?
Thank you, Mr. Chairman. Thank you, sir, for coming today with actual boots on the ground knowledge in this area. Understanding that there is a criteria, which is standard operating procedure for strip searches, it appears the language before us deals with something different, which is a suspicion of one carrying contraband. Do you agree with me on that?
Yes, I believe so, but I mean, I just feel like opening that up. I've personally never had dealt with an offender who's said I have contraband on me. I mean, the whole song and dance that we do is that they don't want you to know if they have contraband on them. So I think that's why having a standard time when we use these strip searches makes sense. I almost think that opening up to probable cause could almost open up abuses on our behalf. Like if you had an inmate that a shift commander didn't like, he could just say, oh yeah, you have probable cause, and then we could do a invasive strip search for I'm trying to think of the right word, for ulterior motives. Whereas I think the way we have it, where there's a standard time when strip searches are used, that takes away the possibility of abuse by staff, which I think everyone here would want.
Agreed. So you said that you were talking about your experience. Have you ever had an experience as a member of corrections where you suspected someone, an inmate, of concealing contraband?
Yes, we've had again, I want to make sure I'm not, revealing too much as far as,
just a yes
some of these
or no.
instances, but yes, I have. Yep.
Okay. And
they were found to have contraband in a couple of cases.
Sure. And the language is presented to us, the way I read it, is once you have that suspicion that you could not strip search the individual, that you would have to go through some procedural process. You couldn't detain the individual for the purposes of potential strip search. You would have to go through the procedural process to get permission. And I guess my concern, my question is, do you share that concern that during that period of time that contraband could be transferred to someone else or even be able to be used against another inmate?
Oh, absolutely. Yeah, I mean, like I said, logistically, it's just not realistic to fill out a form. I don't know. Again, I have no idea what that form would look like, but most DOC forms are kind of they're not very quick to fill out normally, and I kind of imagine this would be the same thing. And like I said, there's the issue of not having a shift commander on, and you have those times where, especially most of these situations are emergency situations, that it just wouldn't be feasible. It would grind operations to a halt, and I know a big push has been that operations don't get halted, and the inmates have, you know, the amount of out of cell time that's been legislated on, and I think that would just increase the amount of time where they would have to be locked in their cells while we're waiting to get permission, you know, to conduct one of these searches.
Understood. I mean, of concern to me is a little over a year ago, 2 inmates died in their cell as a result of overdoses. And, you know, obviously some contraband got into that prison system. And, you know, we have to protect those individuals that are under the state's care. So I thank you once again, sir.
Thank you, sir. I appreciate it.
Further questions or comments? Senator Winfield.
Thank you. Good afternoon, Mr. McGoldrick.
Afternoon.
Can you explain to me the probable cause will cause more abuse thing? I completely missed that one.
Are you talking about the case that I cited?
No, you in your exchange, I believe, with Representative Fishbein, suggested that the probable cause standard in the bill would potentially cause more abuse. How were you suggesting that?
Because I believe that if say, I'm going to give just a what if situation, a shift commander has an issue with an inmate for whatever reason, perhaps, I don't know, I'm not going to speculate. The fact that you would leave that open for them just to, they could almost use that form to harass an inmate, whereas when we have a standard of when these searches happen, it takes away that ability for, say, a shift commander or whoever, their designee, whatever the way it's written, to harass an inmate. I don't know. Do you understand what I mean? That I wouldn't.
No, but let me tell you why I'm having.
I hope it wouldn't happen, but I think it could happen.
Let me tell you why I'm having a hard time following you. So, as I understand what you currently do, you have policy for the going to certain places triggers a strip search. Contraband, you have a policy, as part of your policy deals with contraband as well. My understanding is that you have a procedure that's different. What triggers that is different than if I go to the infirmary or something like that. That when there's a suspicion that there's contraband, there are things that you already have to do, and you have to have not the standard in the bill, but you have to have a reasonable suspicion. You have to put that on a form. So I'm having a hard time understanding, given the testimony of those who've already testified, that they're concerned about the more regular movements and this kind of conversation about the suspicion, if you will, of contraband, what the effective difference is.
I think we get lost in the weeds here.
The weeds are important.
Basically, my thing about the form is, if you had, let's just say, we say rogue shift commander who has an issue with a certain inmate, they could, I hate to say, like, falsify that form just to use it for punishment or, you know, harassment of that inmate. Whereas when it's a set time, you know, an infirmary, that that shift commander doesn't have anything to do with an inmate being brought to the infirmary and inmate being brought to segregation. The visits part of it, the admitting and processing. I feel like that almost gives.
To make sure that we're talking about the same thing, let's put to the side the things that are in that category. And let's just talk about contraband in general and the policy you have, because that's where I'm focused right now. So currently with contraband and the policy you have, my understanding, and you can correct me if I'm wrong, I don't work in the system and I'm happy to be wrong if I'm wrong. My understanding is that there is a standard established by administrative procedure that you have to have a reasonable suspicion. Am I wrong on that?
I don't have the directive in front of me, sir. I don't want to misquote it, but I don't think it does say that there needs to be a reasonable suspicion. There's certain areas that an inmate could be brought to, you know, an inmate going out on a court trip. We need to ensure that they didn't make a cuff key in their cell or some sort of, you know, they're not bringing something else out there. It's just standard. Those times when contraband.
Let me just clarify.
Okay.
Are you saying that there's no point at which for contraband there has to be a reasonable suspicion? Is that what you're telling me? Or are you just saying you would have to consult with the administrative directive? And that's fine if you don't know.
I don't know that the word reasonable suspicion is an administrative directive. That's the best way I could put it.
Thank you.
I should have had it in front of me, but I actually don't have it in front of me right now. I know some of my other members.
I was just asking you as someone who would be an expert on it. Thank you.
Thank you.
Sir, let me ask you one final question here. So I think we believe we received some testimony earlier, and I've been doing a little Googling here, which is always dangerous. But it seems to me that there's technology now available for body scanners. You know, if you think about it, you go into an airport, right, and you go through the metal detector at the airport. It's no longer a metal detector. It's one of those you put your hands over your head and the thing goes around, and if you've got a piece of aluminum foil in your pocket, it flags it. Wouldn't your concern, and not to speak for anybody else, but I think the concern of most of the advocates for this bill be if we just move to a system where we had these body scanners and that was the first sort of search, and if there was some sort of probable cause because of the body search, because of the body scan or something else that you needed to then do a strip search, fine, but that would be the exception rather than the rule being, let's just put somebody through a body scanner. And I think it would save a lot of staff resources. It would save a lot of time, you know, be more humanizing and cheaper. Am I wrong about that?
I think in theory, that's a good theory,
I'm right,
but in reality, like, I think the theory that if you had a body scanner that could show everything, a body scanner is most like the way you're talking about is a metal detector. We recently had an inmate who made a homemade weapon out of a brush, a plastic brush. He could walk through that scanner till kingdom come, and that thing will never go off.
No, I'm talking about, have you flown recently? Have you gone to the airport and you go through the thing and they make you put your hand over your head and it goes around and it shows on a screen that says if there's anything in your pockets whatsoever? I mean, that's what I'm talking about.
Yeah, I think for one, in certain cases, potentially maybe like maybe in the admitting and processing area, you could maybe do that. I think you need to remember that a lot of times these places have a large number of people going through. You would have, I don't know how many you would have to buy in order for that to even be feasible. But what I'm talking about, sometimes you have a agitated individual, letting them walk by themselves through that and put their hands up. I think we can understand why that might cause some issues. Whereas,
and you've got probable cause to search somebody. I mean, it would seem to me, but anyway, all right. I see, you know what, the commissioner is here, so maybe I'll ask him a little later about the feasibility of that, but it seems to me that that might be the solution here. All right.
I have a feeling he wouldn't agree.
Thank you for being with us today, sir. Oh, Representative Porter.
Thank you, sir.
Thank you for your testimony. I just wanted to go back to some of the responses. One in particular, you said, can you just explain when Senator Winfield was asking you about the strip searches, you said what was standard. What's the quote unquote standard in strip searching that you were referencing?
Are you referring to the times when a strip search is conducted? Is that, I'm just making sure I'm understanding your question.
Well, I'm trying to understand what you were saying. You referred to the standard, quote unquote, in strip searching. So my question to you is, what is the standard that you're referencing?
The standard times that we could conduct strip searches, like I said, are to and from court, coming from contact visitation, placement in restrictive housing, and placement in like an infirmary setting where you know, if individuals going through a mental health crisis.
Okay, that's the standard. Can you speak to random strip searches?
Random strip searches?
Yes.
I mean, in my case, in my experience, they really don't happen. I've never just randomly strip searched an inmate just for any reason. It's always been in one of those instances that I spoke about before. I've never just walked up and said, I want to conduct a strip search. That's why we have certain times where it's done, to prevent someone who wants to harass an individual from doing something like that. That's why we have those standards. So it takes out that discretion.
Okay, so you're saying you haven't done random strip searches. So why would probable cause? You've never had reason or suspicion. And this is a question. I don't want to put words in your mouth. You've never had reason or suspicion to randomly search someone. It's always been standard. Is that what you're saying?
Well, when there's been a time where there's contraband, generally that individual's being brought into one of those areas, restrictive housing, our AP room, you know, things like that. So yes, there's been times where we've had an individual that they suspected having a cell phone secreted in his body, but he was being brought into, I believe it was the infirmary setting. So the standard came in there. So we have had times, but they're done in one of those spots. If you understand what I'm saying, when there's a reasonable suspicion like that, a lot of times they would be brought somewhere pending an investigation, and that's part of the process, processing them into whether it be restrictive housing or the infirmary.
Okay, so what I'm surmising you're saying is that these are standard procedures in which you're doing strip searches. Random is the exception, not the rule, and not something that you normally do. So within the last month, right, the last 30 days, can you estimate for me, for us, how many strip searches you have personally done?
Again, the post that I'm assigned to, I know you guys might not be aware, we change every 56 days. The post I'm assigned to, I'm outside the secured part of the facility. So I personally probably haven't done more than one or two, possibly on an overtime shift, you know, processing an individual into restrictive housing or something like that. But I could count maybe one or two in the last month.
Okay, and out of those one or two in the last month, did you find, was there any contraband discovered?
No, not in those one or two, no.
Okay. Thank you. I mean, the only thing that I will say is because you did continue to reference the 2012 Supreme Court, Florence versus Board of Chosen Freeholders. And what I will say is that I think that we really need to be challenging the Supreme Court to step up with this Fourth Amendment right. Whether you're incarcerated or not, I believe that people have a right to privacy when it comes to exposure to their bodies, and that, you know, you actually stated the dignity of being strip searched. And I will push back on that because there's no dignity in being strip searched. It's just not. And I'll leave it at that. Thank you again for your testimony and taking the time to be with us today.
Thank you.
Thank you, ma'am.
Further questions or comments? Representative Fishbein for the second time.
Thank you, Mr. Chairman. Sir, I believe when you were speaking about dignity, you were speaking about respecting the dignity of the inmate. Is that clear, or is that?
Yes, within the confines of conducting a strip search, you know, making sure that the videotape part of it, that there's no exposure below the waist. We redress the individual so they're not just staying there, naked. I would push back on the dignity. If we had not strip searched that individual I talked about with the sharpened crucifix, there's nothing dignified about slitting your wrist inside a prison cell either. I would, if I were that individual's family, I would prefer the former to the latter.
And then you were discussing about, there's standard operating procedure, which is a list of instances where individuals are supposed to be strip searched, mostly when they come into contact with an individual who's not an inmate, in my review of the list. That's one category. The other category is this discretionary strip search, if we want to call that, when there's a suspicion of contraband or something like that. I believe when you were asked about your instances of strip searching an individual in the last 30 days, those were not instances where there was a suspicion of contraband. Is that correct?
No, again, I don't want to misquote, but they were like a contact visit. Someone coming, again, a visit with like a lawyer, which again, a lot of times is kind of in a private area because there needs to be a certain amount of privacy, but that also obviously lends the possibility of, if you had an attorney who wasn't ethical, potentially bringing something in for that individual.
Yes.
So yes, no, those weren't those discretionary type that we referred to.
Yes, they were standard operating procedures. So when is the last time that you recall as a corrections officer that you conducted a strip search of an inmate based upon a suspicion of carrying contraband?
Me personally, within the last year, I know we've had times where an inmate was found with some contraband and there was a thought that he had more on him, and we did strip searches, and in some cases we found maybe not as serious contraband, but still contraband that they couldn't have in restrictive housing. That's a part of it too. There's certain things within restrictive housing that they can't possess, which would, so that's part of the reason too. We need to make sure that they don't have these things in a restrictive housing setting, or in a case of infirmary, anything that can harm them. That's a big thing that we deal with at Garner, and that's probably one of the most common ones where we've had individuals who will, like I said, put something in their hair, whether it's a staple or little things like that to cut themselves and injure themselves. So that I believe that's a big part of it. We need to, we would not be doing our duty allowing someone to bring something in who's going through a mental health crisis, allowing them to have something that could harm them.
So
I think we can all agree on that. I hope that's not a outrageous statement.
The system is indicating that your bandwidth is low. I'm trusting that you're hearing my questions. My question specifically was, during the last year, how many times do you recall strip searching an inmate based upon a suspicion of carrying contraband?
If I had to guess, 3 or 4 times, if I had to just give a general guess.
That's fair. So thank you. Thank you, Mr. Chairman.
Further questions? If not, Representative Quinn.
Thank you, Mr. Chairman. I'm going to go out on a limb and say that you and your fellow COs probably hate performing these as much as the inmates hate having them performed. So with that being said, if there was a way that we could accomplish the same thing through the use of technology as opposed to an actual physical search, is that something that you folks could get behind?
In my opinion, if there was some magical technology, I don't believe what we talked about before would do the job. If there was something, for one, it wouldn't be cost effective when we're dealing with, like I said, a situation where we've had 5, 6 individuals go into restricted housing at the same time. I just don't think it's cost effective, and I don't think it's possible really logistically, unless you were just going to outfit every cell in restricted housing with one of these one of these machines, which I'm sure cost a ton of money. But if it could happen in a pie in the sky world, that would be great, but it's just not, it's not logistically or financially feasible, in my opinion.
Okay, thank you.
Sir, at the risk of having to admonish myself for going a second time, how long does it take to perform a strip search?
It depends. I mean, one through the visiting room, generally a couple minutes, I at most, depending on, you know, how quick the individual's moving. Obviously, we don't rush them. I mean,
And how many correctional officers does it take to perform the strip search?
with that, in a situation like that, in a visiting room or admitting a process room, it's generally one-to-one. But restrictive housing placement or infirmary placement, it's usually 3 officers and a supervisor.
So,
you know, just to ensure that everything goes smoothly.
So four individuals, and would you agree with me that we have a shortage of correctional staff right now?
I wouldn't agree with you. No, if you look at, they've poured staff into the department.
Okay, so
I think a year ago I would agree with you, but not right now. No.
You believe the correctional facility is sufficiently staffed?
I can only, again, I'm speaking just to my facility. Yes.
Okay.
They've hired a lot of staff in the last year or so.
Appreciate you being with us.
Thank you.
Judge Beverly Strike Kapalis. Judge Beverly, I'm guessing you're not here to talk about strip searches, are you?
I am not. Senator Winfield, Representative Stastrom, Senator Kissel, I think Representative Fishbein must have stepped out. Members of the Judiciary Committee, I am Beverly Strike Kapalis, the Probate Court Administrator. Thank you for the opportunity to testify today on Senate Bill 1023, an act concerning probate court operations. I did submit written testimony, which goes into much more detail as to the proposals set forth therein. So I will not take your time today to do so at this moment, except to say that I am supporting sections 1 through 6, which are actually the proposals of the probate court system through the Connecticut Probate Assembly in my office. They are largely, in my opinion, technical or modernization of language provisions to offer consistency with other statutory structures. We do oppose section 7, which imposes, in my opinion, a burdensome and unnecessary mandate on conservators who are appointed in many circumstances to represent indigent individuals who need conservators who have no family members or close family friends. And it proposes a mandate with respect to custody of their remains upon their death. There are already appropriate, reasonable provisions in the statute to address those unfortunate situations, and I would respectfully ask you to strike section 7. I do know I have had, my office has had conversations with the Office of the Attorney General regarding sections 3 and 4. The proposed language therein is to, again, parallel and offer consistency in statutory structures with the Connecticut Parentage Act. We have reached a resolution, and I believe they no longer have concerns with the language proposed, but we certainly have agreed to continue our dialogue as the Connecticut Parentage Act actually is implemented throughout our court systems and we encounter any challenging language. And then just briefly offer support of section 25 of House Bill 6874, an act concerning judicial branch operations. And that is the provision that specifically the Honorable Chief Justice testified on this morning. I would echo his comments, remarks, and offer my own support for that section. Noting, I know some of the questions and concerns address the protections that may already be in place for judges in the Superior Court system and in the judicial branch system. I would note there are no judicial marshals in the probate court facilities. They are largely in municipal town halls, and we do have to depend on local police officers who are not on site. And I would just offer my support for that section. I'm happy to answer any questions.
Representative Quinn.
Thank you, Mr. Chairman, and thank you for being here, Your Honor. Were you in here earlier when the woman was testifying remotely about her experience with the probate court? Okay.
Yes.
She had talked about, and as she was saying it, I kind of thought it already existed, but if it doesn't, would it make any sense to do some sort of a pamphlet? You know, how do you represent yourself in probate court?
I would, I think she even mentioned our website, ctprobate.gov. I believe it has, frankly, substantive materials and guidance for all matters. Many of them are also in dual languages and can be translated. I think specifically she started to touch upon the mediation program. When there are contested matters in the probate court, parties can agree to referral to the probate mediation program. And I would say that when there is a contested matters, probate judges actually follow a procedure called a hearing management conference. And that is one of the key items that they share with parties that they have that opportunity. And there's also substantive material on our website about that program. I don't think it requires, nor should it be statutorily mandated. We certainly are very aware of the sources, the resources that should be available to the public, and try to continue to educate them as to those resources and the services and assistance we can offer.
Okay, thank you.
Representative Fishman.
I'll be quick. Thank you, Judge, for being here today. I just want to, for the record, I don't understand why judicial has its own electronic filing system separate from the probate court system. And as you and I have discussed, I think the turbo court system is one of the most cumbersome systems to use. I hope whoever's watching this thing at some point thinks about merging the two systems. I just find it very difficult when I get an email all of a sudden that says that something was filed in a case. Many times we don't have to share documents. Maybe that's a fix that we could have where, in Superior Court, you file something with the Superior Court, you have to send a copy to the other side. I don't see that in the probate court system, but I've got to then, find my login, go find this particular case, go into the case. In the Superior Court system, I just get a link, I click on the link, it goes to the case, and I can identify and look at that. So I know, not your fault. I got it. I thank you for being here and all the stuff you're doing in this area. So thank you, Mr. Chairman.
Thank you for your comments. I'm happy to talk to you offline to help guide you through the ease of what I believe is actually a very good system, especially because the probate court matters are not generally matters of general public interest, but concern very private family matters. And so having perhaps that quick ease of access where you can just click on a document on a website would compromise many family private matters. And so we are very sensitive to that. But I'd be happy to talk to you further. Thank you.
Not to belabor, but there are private sensitive matters in Superior Court also.
Absolutely.
So thank you.
Concur, and there is a right to access of public documents the public has. Judge, let me just ask you real quick on section 25, again, not to belabor, go down that rabbit hole again, but are you aware of any probate judge, or sorry, any threat that has been made against a probate judge that has been prosecuted under existing statute?
I am not aware of any prosecution. I do often, let me take that back. I wouldn't say often. On occasion, we will have a probate judge contact our office about a threat, either in writing or during a proceeding or after, and they are referred to the local police department. Those have not led to an actual charge or an investigation to my knowledge.
Okay, thank you. Appreciate you being with us.
Thank you very much. Have a great afternoon.
I am going to turn this over to Senator Winfield.
Oh, did you have a question? I'm sorry.
No, for the next witness.
Okay.
Yeah. Thank you. Annie Harper. Is Annie Harper?
Yes, I'm here. Good afternoon, everyone. Thank you for the opportunity to submit testimony in support of HB 6875 to ensure that every person living in incarceration has official state identification. My name is Dr. Annie Harper. I'm an assistant professor at the Yale School of Medicine's Department of Psychiatry. The views I express here are solely my own. There are multiple reasons why people who are returning home from incarceration should have proper ID, and I think that's been spoken to and many people will speak to it. I'm focusing in my testimony on access to banking services, which is my area of expertise. So research has shown that lack of ID is one of the main reasons that people who've been incarcerated don't have bank accounts. It can be very costly to be unbanked. People who don't have accounts have to rely instead on alternative financial services such as prepaid cards, check cashers, rent-to-own stores and pawn shops, which can be extremely costly given high fees and interest rates. Also, people without a bank relationship cannot access wealth building loans and have limited options to build their credit, further perpetuating the cycle of poverty. And as a health researcher, I'm particularly concerned about the impacts of poverty on health, which we know are profound. With specific reference to people who've been incarcerated, researchers found that credit is associated with recidivism. People who've been incarcerated are 20% more likely to recidivate if their credit was damaged during incarceration. Research also shows that people returning home from incarceration see having a bank account as a marker of belonging. People who feel that they do not belong socially are more likely to recidivate. Now, bank accounts can be problematic. I've given testimony here before about the devastating consequences of overdraft fees, in particular on low-income people. But thankfully, an increasing number of banks and credit unions are offering free or very low-cost accounts that do not charge overdraft fees. Access to safe and affordable bank accounts such as these are an essential step towards building a secure financial future and re-establishing strong social networks. But without ID, people returning home cannot take that step. I also want to draw attention to specific challenges faced by some populations. I conduct research with people with mental health challenges who are tragically and unjustly disproportionately represented in our prisons and jails. Lack of ID causes serious challenges for this population. I'll tell a brief story illustrating just one of the ways. A person I worked with told me that when he was released from prison, he had no ID. He's a person with serious mental illness, and before he went to prison was receiving supplemental security income, SSI, due to his disability. His SSI, which was being paid into his bank account, was discontinued during his time inside 8 months and then reinstated after his release. When he went to the bank after his release to withdraw funds, he was unable to access his account as he could not remember his login or password, and the bank would not give him access without that information, given that he had no identification. Meanwhile, his SSI continued to be paid into his account. When I spoke with him, he was not only frustrated that he couldn't access his funds to pay for his daily needs, but extremely anxious that due to his inability to withdraw funds, his balance would soon go over the $2,000 asset limit, which would result in his SSI being discontinued. Lack of ID for this person meant not only that he was not able to access the funds needed to meet his basic needs, but also threatened to deny him access to any.
Ms. Harper, the bell is wrong. I will see if there are questions. Representative Fishbein.
Thank you, Ms. Harper, for being here today. You had said that your expertise was in the area of bank accounts for inmates. Can you just explain the breadth of your knowledge in that area?
So my knowledge, it's not expertise with bank accounts for people who are in prison specifically, it's bank accounts for low-income people, people with mental illness, and people with histories of incarceration, marginalized populations generally.
Okay, so if I was to ask you about bank accounts for people that are released, which certainly it's my, in my heart to have people who are released from incarceration not recidivize and to lead productive lives, but you're unable to inform us as to whether or not people that are released have a bank account, or is there some process in Connecticut to do that?
Yeah, no, I can tell you what I know of that. And what I know of that is that there is no standard way that people are connected with a bank account after release. I have heard multiple stories of people who did have an account prior to going into prison, but the account was closed due to length of time, buildup of overdraft fees and things like that. And there is no standard way for people to reconnect to an existing bank account or to open a new bank account.
Well, the buildup of overdraft fees would be strange, I would think, with somebody who's incarcerated and is not utilizing the bank account. I could see like a dormancy charge, some. What
can happen commonly, excuse me for interrupting, if people have bills that, what's it called? Payments that go through automatically that they didn't have a chance to cancel or that they may have forgotten about. Those kinds of payments can take someone overdrawn, and then an unpaid overdraft. Repeated payments can make accounts go overdrawn. Then there's an overdraft fee, and if an account sits there with an overdraft that's in the red for a period of time, it'll typically be shut down by the bank.
Okay, that's fair. No, I thank you, and I thank you for coming here today and giving me a lot to think about. But thank you.
Thank you, Representative. Comment or question from members of the committee, Representative Dillon.
Thank you very much, Mr. Chairman, and thank you, Dr. Harper, for testifying today. In your experience, is there any standard protocol for those who are incarcerated to protect them from having their bank accounts cheated by the state?
As far as I know,
activity.
Pardon me, could you finish that, please?
I'm thinking of bank accounts that would be cheated by the state for inactivity while you were incarcerated. Is there is there in place now any way to prevent that or to help them get their assets back?
So as far as I know, there is no such mechanism, though I know there are some states, I'm thinking Arizona and maybe a couple of others, which are working on this very issue, but not in Connecticut, as far as I'm aware.
Thank you very much.
Thank you, Representative. Comment or question from members of the committee? Comment or question? Seeing none, Ms. Harper, thank you very much for joining us this afternoon.
Thank you.
Margaret Gilbert.
Dear Judicial Committee, my name is Margaret Gilbert from Mystic, and I'm here today to read the testimony of Leroy Moore, who cannot read it herself because she's incarcerated. My name is Leroy Moore, and I am incarcerated at York Correctional Institution. I stand in strong support of portion of SB 1196 that addresses strip searching. During the nearly 8 years that I've been in the custody of the Correctional Department of Corrections, I have been subjected to excessive bare naked strip searches more times than I can count. There are less degrading alternatives to strip searches that need to be explored and would address contraband issues among officers as well. All of us inside are well aware that contraband's main entryway is via staff. Using body scanners will likely dissuade drugs brought in for staff's personal use as well. It's scary knowing our officers are getting high and are responsible for evacuation in case of emergency. If the DOC is concerned about safety and security, then no one could pose a risk, should be excluded from these measures. I have been told my actions of spreading my butt cheeks while bending at the waist while I cough are not sufficient if the officer cannot see the pink. The pink of my vagina was exposed and inspected during 5+ years I was being molested by my family member. I mentally removed my body from the abuse that was taking place, and it feels no different now when officers inspect my bare body. During a strip search, I am not trembling because I'm trying to hide contraband, as I'm often accused of doing. I am re-experiencing this childhood trauma after 40 years of trying to cope with it. I can never admit this weakness to an officer, though, who not only throws my criminal record in my face, but also comments on my weight and my body shape and the scars I bear from past suicide attempts. It is quite clear that this slavery era practice has been retained to break us into submission and compliance. I should not have to shuck and jive to be an American system that now owns the rights to my body. I can confirm for you all that I am broken each time I am further sexualized against my will. But I say nothing and take it in hopes that I can at least take my splintered pieces back. There's no other practice here that I feel so directly assaults my humanity, treating me like livestock. On behalf of all of us who have been raped, trafficked, abused, and who were citizens before becoming chattel, I ask for the chance to exist as something other than an empty shell. We just want a chance to become someone who is actually healing instead of merely coping. Thank you, Leroy D. Moore, 306278.
Thank you. Comment or question from members of the committee? Comment or question? If not, thank you for joining us and reading Ms. Moore's testimony.
Thank you for the chance to do that.
Have a great afternoon. Olivia Montez.
Yes, hello. Thank you again so much for your time and a good afternoon. I had a question regarding the raised bill Senate number 1207. I understand that there are details regarding that there is going to be a review of pre-existing statewide civil rights laws that include titles 51 and 52, and I'm curious as to what additional laws that also pertain to civil rights that would be further examined during this review process, and what this process will look like if this bill is passed.
Thank you, Ms. Montez. Ms. Montez, that bill, along with three other bills, is referred to by several names, sometimes a dummy bill, an extra bill, various bills, placeholder. What it allows for us to do is there are times when there are things in one bill that the bill itself becomes too controversial to use the bill, it gets moved into that. The things people testify to as part of a bill that may need to be by themselves, various reasons why you might need another space for subject matter. So we put up what these types of bills for both criminal and civil. That's what those bills are. So what would be in there would not be established at this point.
Understood. Thank you.
Thank you. All right. Next, we will hear from Lisa Puglisi.
Thank you for having me here today. Good afternoon, Senator Winfield, Representative Safstrom, and the leadership and members of the Judiciary Committee. I'm Lisa Puglisi. I'm an internist. I practice primary care and addiction medicine at the Cornell Scott Hill Health Center here in New Haven. And I direct a clinical program in our state, the Transitions Clinic, that has programs in Hartford, Bridgeport, and New Haven, specifically focused on addressing the health needs of people leaving prison and coming back to the community. I'm here to speak on behalf of House Bill 6875 concerning state IDs and licenses for people who are incarcerated and for planning for their release back to the community. The views I speak on today are entirely my own. You've heard some fantastic personal narratives from people today who have been directly impacted about the ways that this has impacted their life. I am so glad to see that this bill seems to have bipartisan support, as I am here to share additional stories. So I can say that for the past 10 years that I have been doing this work, it has often felt like we are slamming our head, into a wall when we see the same problem over and over. We see hundreds of people returning to the community yearly. And on analysis we've done, 75% of our patients who are released from incarceration have no identification, have no state identification. This creates myriad problems for them. You've already heard of some. I won't belabor those points, but I will say that I can share stories with you of elderly individuals, given the expansion of older incarcerated persons. We see 75 and 80-year-olds coming home who have not walked in years and are wheelchair bound, and then stuck in halfway houses for extraordinary amounts of time while they await necessary documents for ID before they can apply for Social Security and other state resources. While it may seem trivial to have to pay $25 or $30 to get a birth certificate or a Social Security card, I can say that from the narratives my patients tell me that that cost is often totally prohibitive and further prolongs the process. And additionally, identification is necessary for everything. You can't get medicine or controlled substances without an identification. You can't show up for methadone. Maybe you started it in prison. Our state, due to your actions, has had fantastic expansion of methadone for incarcerated people to treat our opioid use disorder problem in this state. You can't show up and get methadone without an ID. And you can't apply for jobs without an ID. Some cities have taken to providing city IDs. Many places don't accept those. And so I think it's something most people can agree on, that ID is necessary for all acts of civil life after release, and especially for all the things you have to do to promote your health.
Thank you, Ms. Puglisi. Comment or question from members of the committee? Comment or question? If not, thank you for joining us this afternoon and providing us with your testimony.
Thank you for the opportunity.
Melinda Johnson.
Yes, good afternoon, Senator Winfield, Representative Staffstrom, and leadership and members of the Judiciary Committee. My name is Melinda Johnson. I live in Hartford, Connecticut. I serve as the chair of the recently established Connecticut Corrections Advisory Committee, and I am director of community engagement and advocacy for the YWCA Hartford region. And today I stand in support of House Bill 6875, an act concerning the insurance or the issuance of a state identification card for motor vehicle operators licensed to a person being discharged from a correctional facility. When the average citizen tries to access healthcare services within the community at a doctor's office, an urgent care, an emergency room, one of the first things you're asked for is identification. The Transitions Clinic Network healthcare providers, one of which you just heard from, serving people returning from incarceration in Hartford, New Haven, and Bridgeport, report that less than half of patients are returning home with proper identification. Not being able to obtain much needed medical support because you aren't able to prove who you are is a barrier that can be life-threatening for some. This seems like it's just a 3-inch by 2-inch problem, right? The size of an ID. But it can lead to immeasurable setbacks and set up individuals to encounter difficulties integrating back into the community. High recidivism rates are correlated with community problems related to poverty, unemployment, education, and health. Establishing continuity for returning citizens through effective discharge planning, including the issuing of state IDs upon release, as well as, releasing medical records, education on insurance options, and connecting people to social services and community would help ensure a more successful integration back into society and benefit both individuals and their community. And so I urge the members of the Judiciary Committee to support House Bill 6875 so that the state of Connecticut can take this crucial step toward building stronger communities. Thank you.
Thank you. Great job on beating the bell. Comment or question for members of the committee? Comment or question for members of the committee? If not, Melinda, it's good to see you again. I'm sure we'll see you in the future.
Thank you.
Shelby Henderson. Shelby Henderson. Brian Withington. Brian Withington. Nathan, Vincent Candelora. Vincent Candelora. Nathan Hunsicker.
Good afternoon. My name is Nathan Hunsicker, and I'm a correction officer with over 16 years of experience at various facilities in Connecticut. I'm in opposition of Bill 1196 as written. I can tell you that it's not a duty that corrections officers look forward to doing. However, I can tell you that it's an extremely important task that must be done to keep staff and incarcerated people safe. The instances in finding contraband are low in percentage, but it's not a rare occasion. I cannot recall specific dates, but it's not rare to send somebody to segregation as a result of contraband found during a strip search. It's actually like pretty much a weekly occurrence in our facilities. One point I'd like to make is the current strip policy is a deterrent itself, which keeps these incidences low. Drugs and weapons find their way into the hands of incarcerated individuals, and there are many opportunities that seem obvious to some of us, like contact visits, offenders coming off the street, and outside trips. Even like a hospital trip could be, an opportunity to get a needle or a quick hand gesture, where you're not looking right at the inmate at the time. You can grab something, and it's important that when you get back to the facility that these contraband is found. But there's also situations which you might not necessarily think will be an opportunity to gain contraband. But criminals are very resourceful, and you would not be surprised what you can find or hide in or on their person. The administrative directives that we currently have outline the circumstances that require a strip search. These are not open to officer interpretation. We do not have discretion to strip search or not to strip search. It's policy. And it's my opinion that this current policy works well because officers are not asked to make reasonable suspicion calls. We just simply look at the administrative directives and we follow them. Do you guys have any questions?
Thank you for your testimony. Comment or question from members of the committee. Representative Quinn, followed by Representative Porter.
Thank you, Mr. Chairman. And thank you for being here, Mr. Hunsaker. We had a corrections officer testifying earlier, and he indicated that one of the problems he saw with this bill was the necessity of a supervisor signing off on the strip search, and that supervisors aren't generally working holidays and weekends. But understanding that regular supervisors may not be there on holidays or weekends, somebody's in charge, right? I mean, somebody is taking over in a supervisory position if the regular supervisors aren't there, correct?
Yes, that's correct.
Okay.
You also have a duty. So, but it would take time for that person that's like, so say we'd be in, a lieutenant would be in charge. They would contact the duty for specific circumstances, who would be available by cell phone at home.
Okay. And also earlier, the possibility of employing body scanners similar to what's used in airports was discussed. What are your thoughts on that? I mean, I've been through them. The first time I went through one, I had a cloth to clean my glasses in my front pocket, and the body scanner picked it up. So body scanners aren't looking for metal, they're looking for objects where they shouldn't be. If that technology is available in an airport, can we employ it in a prison to do the exact same thing and then spare the corrections officers the duty of having to perform something that they probably really don't want to do?
Yeah, you have my vote for that.
Okay. All right. Thank you very much. I appreciate your time and appreciate your service.
Reporter.
Thank you, Mr. Chair, and thank you for your testimony. I just wanted to ask about when these strip searches are done, what level of privacy is afforded to the incarcerated person? Are they done? I mean, do you do several incarcerated people in a group, or is it an individual strip search? Can you just explain to us how that works?
Yeah, normally it's in a room with only the people that are part of the strip search. Usually have a camera operator that they operate the camera from the waist up. You'll have an officer directing the strip search, and then you'll have 2 standby officers in case the incarcerated person acts out or gets starts to try to fight against officers' direction. Sometimes when if contraband is found during these strip searches, if the inmate can like if say it was drugs, they may try to grab the drugs and ingest them, or if it was a weapon, they might try to fight the officers in some shape or form that we're trying to get that contraband.
Just for the sake of time, I'm sorry to interrupt you. I just needed to know the procedure, right? Is it a private process? Are there multiple incarcerated people that are strip searched at one time?
No, it's private.
It's one-on-one.
Everyone that I've experienced has been private.
Okay, and I'm counting. You said there were 4. There's a person that's recording, and 3 officers, if I understood you correctly. Is that correct?
Yeah, and there must be a supervisor also. I'm sorry about that. There's a supervisor that's required as well.
Okay, so that kind of debunks what we've been told just prior, that there are times when supervisors are not available. So if there's a strip search being done, a supervisor is required. Is that correct?
Well, so there's different situations that let me clarify for that. So for example, if you were sent down to the AP room to provide a specimen for, testing, that situation, you would do something, and I've done them in the past. It was one-on-one, it was just myself. And this is in the past. This is like 2006, 2000 to 2012, when I was at Gate CI. But there are situations where it can be, strip search would be conducted by just a one-on-one. But when it has to do with like seg placements and stuff like that, there's like 5 individuals for those strip searches.
I'm sorry, when it has to do with what? I didn't quite hear what you were saying.
When it has to do with like segregation placements, and then it has to do with somebody that's like involved in a use of force, or like if there was a code, if there was like a code blue where inmates had fought, if there was mostly placements, like segregation placements, is when you'd have the 5 total individuals in that area. For the most part, though, every situation is different.
Thank you. And you brought up segregation. So I think one of my questions is, you do strip search going into seg, but when you come out of seg, going back into the general population or a regular cell, let's say, call it that.
Yeah.
Are you strip search coming out of seg, going back into the general pop?
It's been a while since I've worked at Corrigan. Currently I work at York, and so I haven't worked at Corrigan since about 2017 or 18. So it's been a while. I can't recall.
Thank you. And thank you, Mr. Chair.
Thank you, Representative. Comment, question for members of the committee, comment or question? Seeing none, thank you very much for joining us today. Donald.
Thank you.
Thank you. Donald Moody.
Hello, you can hear me?
I do.
Hi. Good afternoon. My name is Donald Moody. I'm from New Haven, Connecticut. I recently was released 9 months ago. I just want to tell my experience with the identification. I support the bill 6874. When I came home, when I was released from prison, I was under a different social security number. So when I came home, I had a very hard time getting my ID, and I also had a suspended license from 1993 that I knew nothing about. I was 15 in 1993. I spent 25 years in prison. So when I was released, it was very hard for me to attain my identification. And my Husky, I couldn't get Husky. I couldn't go to the DMV to get my state ID. I couldn't go to the DMV to get my learner's permit because my social security number was messed up. And for 25 years, I was under a social security number that the DOC had. And I don't understand how that happened. So I support this bill because it's very important for all of us to have identification, because as soon as we come home, we want to be productive citizens. And in order for us to do that, we have to work, we have to create our bank account, create our system. And to do that, we have to have some support on getting this stuff. And I had to use, my wife had to pay for all my stuff, and that was a burden on her. And I support the bill. There should be some type of policy in play for when individuals come home, that they have the IDs before they get home, because that's another struggle for us to run around, and a lot of us don't know technology, so emails is hard. So I think there should be a policy that go with this, that while people are incarcerated and that on their way out, that they should get some type of education on technology, and that the ID should be, the DMV and the DOC should come together, and when individuals come home, they should have the ID as soon as they get out. If you have any questions, that's it.
Thank you, Mr. Moody.
Thank you.
Representative Fishbein.
Thank you, Mr. Moody, for coming here today. And
Thank you.
sharing part of your story. Can you just explain the Social Security situation as far as you understand it? So you went in with a certain Social Security number, and it.
So I'm a juvenile lifer. I came home on juvenile parole. In 1993, I was 15 going on 16. I came to jail when I was 17. So this is 1994. I knew nothing about IDs or social security numbers. I was illiterate to that stuff. So I didn't know nothing about my social security number or SS, all that stuff. So while I was in prison, I was under a different social security number. So when I came home, I went to go get my ID. I went to go get stuff that I need with my social security card. And they told me, this is not your social security number. And I was like, I've been under the social security number in the DOC for 25 years. I don't know before that, but when I came home, I had to get it fixed, and they found my real social security number. And I just went through the process of spending money.
So you think, and you may not know, but you think that when they did the paperwork initially as part of your incarceration, that perhaps they put down a wrong social security number at that point, and then it just carried on through the system?
You probably, I think that's what happened. That number was wrong. It was off. It wasn't just one number, it was off. And that experience, it was like traumatizing, because I came home with a goal. I came home to get my license. I came home to get my identification. I came home to get a bank account, and it slowed me down.
So I'm just looking at the language that's before us, and if we put the onus on DOC to get you an ID, in your particular case, 2 years prior to your release, or actually you would, I think you
for the
passionate release.
love seat.
I don't know where that.
Say you had a white and gold love seat.
Oh, you got background noise there? Okay. So wouldn't DOC have issued you, or had issued for you, an ID with the wrong number?
What'd you say?
If DOC's records indicated a wrong social security number for you,
But yeah, the black and gold set.
and under this bill, we would require DOC to get you an ID prior to your release. I'm concerned that that ID would then have the wrong social security number.
Yeah. With me, it would have been the wrong social security number. For future events and brothers coming home, it will help them to have the ID as soon as they come home.
Yeah, no, I got it, but I'm learning some interesting nuances here today. So you bring a very unique situation to the table, and I'm just adding that to the things that I've got to deal with here. Also, since that time, have you been able to, I mean, I assume you had a correct social security number before you went in. Have you been able to get a social security card with the correct number on it?
Yes, I had, after going through the process, and as I said earlier, I spent 25 years in prison, so I don't know the process. I don't know the technology. I didn't know what I have to do. Luckily, I have a wife who was in my corner that helped me navigate through the process of getting my social security number right, and getting me down to the DMV. But there are brothers who spent 30 years, 35 years, 40 years who don't know of the process. That's why I was trying to suggesting that before they come out to somehow have the ID ready.
Yeah, that's the intent of this legislation, but I'm just glad to hear that your situation, at least for now, was cured in this regard. So I thank you for your advocacy on behalf of those that are yet to be released. So thank you, sir.
Thank you for having me.
Thank you, Representative. Comment or question for members of the committee? Comment or question? Mr. Moody, did anything happen in this regard prior to your release when you were in the system? Were there any efforts made? Not on your part, but on the part of the system.
So when I was granted parole around March of last year, and then when they made my package, they gave me for my Husky, they gave me a number to go to. There was nothing prior to me coming home about my ID. Only thing that was focused on it was me having insurance. So when I came home, I just learned everything myself not by myself, but with my wife. No, I didn't get no identifications. I did nothing. All I got was a Husky number, and that was wrong because my social security number is wrong.
50%. Okay, thank you. Comment or question from other members of the committee? Comment or question? Seeing none, Mr. Moody, thank you for joining us today.
Thank you.
And Massaro.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, and Representative Fishbein, and other members of the Judiciary Committee. My name is Ann Massaro, and I stand in support of SB 1196, the portion of the bill concerning strip searches. According to DOC, strip searches are to prevent an unauthorized item from entering the facilities. The department states that these invasive searches are about safety and security. However, many in the psychological professions have determined that strip searches, by definition, are a form of sexual violence. Contrary to what you have heard here today, the body scanning technology does exist. Numerous other states and countries have abandoned the use of strip searches and replaced them with the use of more effective, safe, cost-effective, and far less violent body scanning technologies, which have been instituted for both incarcerated persons and DOC staff. Why does Connecticut continue to use strip searching? In my opinion, strip searching is a means of control, degradation, and humiliation of incarcerated people. You have heard testimony today from corrections officers about the Supreme Court ruling of 2012, deciding that incarcerated persons were denied protection under the Fourth Amendment. What you did not hear about this decision, which I have read about, was that many justices were very uncomfortable or, quote, on the fence about this decision. But without the presence of voices of people directly impacted or of advocates, the court was convinced simply by testimony of corrections unions and correctional officers. Contact with loved ones is crucial to anyone locked in these cells in order to receive healing and support. Yet each incarcerated person must choose, do I see a loved one or undergo the sexual violence and degradation of searching each time? We have Stop Solitary have heard untold stories from both men and women who have been incarcerated, how dehumanizing, degrading this practice is. Many people are re-traumatized even speaking about it. You will hear some of those stories today. At least one woman we spoke with even refused to see loved ones. Take into consideration also that the majority of incarcerated men and women have experienced some form of sexual abuse or sexual violence prior to incarceration. As a survivor myself of childhood sexual abuse, I know the years and years it takes to even begin to heal from this abuse outside of incarceration. Strip searching serves as a trigger, taking you back to the most damaging sexual violation you have ever experienced. For me, it would be so traumatic as to throw me back to all forms of self-harm, acting out, including drinking, drugs, rage, self-loathing, and even attempts at suicide. What does it say about our humanity that we would intentionally put people through this when incarceration is supposed to be about rehabilitation, healing, and getting people ready to return to their communities? We have alternatives. What is keeping us from employing them? And it is certainly not cost, since Connecticut has a budget surplus. Thank you very much for hearing my testimony today.
Thank you very much, Ms. Massaro. Comment or question from members of the committee? Comment or question, Representative Porter?
Thank you, Mr. Chair, and thank you, Ms. Mazzara, for your testimony. I don't have a question. I just really wanted to thank you for bringing that to our attention, because that's not something that I've heard mentioned, but I have been in and out of the public hearing. the fact that you have people coming in that have been sexually assaulted and carry that level of trauma, then to be exposed to strip searches and what that does to someone. So I appreciate you sharing your testimony and being before us today. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee, comment or question. If not, Ms. Massaro, it's good to see you again. I'm sure we will see you in the future. Angel Quiroz. Commissioner of Corrections, welcome back.
Good afternoon. For the record, Angel Quiroz, Commissioner, Department of Corrections, Senator Winfield, Senator Kissel, Representative Fishbein, and committee members. Thank you for giving this opportunity to speak today. My intention is not to go word for word on the bill, so I'm just going to summarize it real quick. We are in support of House Bill 6875 when it comes to identification. And I do agree that the importance of individuals that are being released from the department to have these identification. As Senate Bill 1196, Section 1, I am in favor of the advocacy group, the notifications from transfer from a higher security to a lower security of the individuals. And I think that with the department, we can work internally to see what mechanism we can put in place to notify the victim advocates. The new language when it comes to the probable cause, I'm opposing that session. However, I too, Representative Sandstrom, have gone through the airport and I've seen the technology and the body scanners. I am in early conversations looking into the cost and the amount of body scanners that we would need to, and then whereabouts will we use these body scanners? So that is a technology that I'm looking into so that we can, if there's area we can move away from the strip search, I'm open to that. So, so to answer your question, yes. And the only thing else before I take questions, since 2018, there's been 1,077 incidents in correction where contraband has been found in the facility. 65% of that contraband comes from the county jails, Hartford, New Haven, Bridgeport, Corrigan, and York. The Inspector General's report from last year identified there was 7 overdose in the Department of Correction for fentanyl. So my concerns with the probable cause, there's about 16,000 individuals that come yearly last year in 2022 as intake. There's no probable cause to do a search with this new language. So that means 16,000 individuals will not be strip searched. There's no probable cause when individuals come back from court. Those individuals will not be strip searched. So I do have concerns that we will see an increase of contraband. Open to questions.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Commissioner Quiroz, thank you for coming and testifying this afternoon. And I just want to say I appreciate the cooperation you've shown me and my constituents up in North Central Connecticut. We had the clear total of number of correctional facilities within a Senate district, but you keep closing down the facilities. I guess in a way that's good that there's less inmates overall, certainly since the high point during the Rel administration after the triple homicide and the Board of Pardons and Paroles were brought to a standstill, and there's a lot of elements that caused the population to be at its high point around that time. I would say right now, if there's any repurposing of any of the facilities that have been closed and apparently mothballed for the time being, please let me know as soon as humanly possible. My constituents are concerned by various other initiatives that the state is pursuing. And so we don't want to be taken by surprise regarding that. And when it comes to the strip search particularly, and let me just touch bases real quick. On the ID, I don't get it. Senator Winfield, our good chair, has said that he's worked on these bills for years, but clearly the undermining of reintegration with society and becoming law-abiding and tax-paying citizens, just that little thing is a real impediment. So anything that we can do to bring you with the commissioner of DMV, whatever it takes, it just doesn't seem like rocket science. On the other hand, getting this new technology or the technology that's similar to what we find in airports like Bradley International up in my district, I think that's more of a logistical, how much is it going to cost? Getting it into the facilities, it's just nothing that's going to happen overnight. At the same time, though, I think that maybe there's ways that we can minimize the use of strip searches because it would really horrifically demean an individual. And if we can do it in a better way, and I'm just wondering, is there any midway between moving into all technology versus what we're doing right now that you can think of or that we're missing?
Midway, I would say no. I think that the technology, to me, that body scanner will be the ideal. In my vision, I can see body scanners being utilized in the AP area for those individuals coming in. I can see body scanners being utilized after social visits. And then if the individual refuses to go through a body scanner, then we would have the proper cause then to go to a strip search. So my preference would be the technology.
And I appreciate that answer. And when you talk about rolling it out, there's going to be different places where it's going to be much more effective, maybe not effective, but efficient. The initial intake, going to and from where you know that an individual has to be searched. And again, as the corrections officers helped us, they said there's incidents where you have a concern that they have contraband, maybe it could be drugs, it could be something to hurt another inmate or themselves. And it may not be metal, it may be plastic. And trust me, I've had the correctional officers, presidents of the unions up in my district show me the shanks and the shivs, and it was like amazing. When you have a lot of time on your hands, you can come up with a lot of things to be a weapon. But under the current policy, there's just certain set times, especially in transfers in and out of the facility, where this is going to take place for the safety and security of the inmates and the COs. And I'm thinking that if we roll it out with a mind towards that, probably financially we can get our arms around it and logistically. So whatever this senator can do to help you with that, pursuing that goal, I think I'm ready, willing, and able to do whatever I can. But I'll wait and let my colleagues ask their questions. But I just want to thank you for all your hard work. I'm biased. I think when people work their way up through the ranks within our own correctional facility, it brings them certain insights and sensitivities that you don't find if you go out and conduct some sort of world-class national search. And I thank you for all your service to the people of the state of Connecticut.
Thank you.
Thank you, Senator. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, sir.
Good afternoon.
Thank you for being here. Reintegration is something very important to me. I'm hearing a lot of stuff that I'm concerned about. We heard from a gentleman this morning who was incarcerated for 25 years, and somebody knocked on his cell door one afternoon and said, "You're getting out tomorrow." 25 years ago, we were all raving over Prodigy and AOL, 2400 baud modems, right? It was a totally different world. And now this person is let out the next day, and it's basically, from what I'm hearing, go figure it out. And to his credit, to my knowledge, he has not recidivized. That's a big hurdle for that individual, I'm sure. When you come here today and you say you're in support of the bill with regard to the IDs, I have to ask, why haven't you already done that internally?
So there is a system internally. We do have an MOU with the motor vehicle department. And so we do have reentry counselors that work with these individuals, right? For the calendar year 2022, there was over 4,800 piece of items of identification that was secured by Department of Correction. Some were birth certificates, others were social security cards, others were driver's license, renewal driver's license, others were non-driver's license. Now, the Federal Act for the Real ID, in order for the Connecticut Department of Corrections motor vehicle departments to issue non-driver's license ID or driver's license, they have to have a certificate, birth certificate, and a social security card. So an individual in the case, I would take the current situation that we have with individuals that are born in Puerto Rico, that if they don't have an ID card, a real ID card, a driver's license, they can't get a birth certificate. So department spinning a circle, trying to get a photo ID from DMV when the individual really does not have a birth certificate, because Puerto Rico is saying, no, you can't have a birth certificate because you don't have the identification. So we have been working with the Department of Motor Vehicle, and I've heard these stories too. But there's many stories out there, success with individuals that have left the Department of Correction with identification. Some individual chooses not to participate in the ID.
No, I can understand that, but we heard from a gentleman a little while ago. I don't know if you were here.
I was here.
He was, 30 year, I think he had a life sentence. He was in there for 30 years. And during his term of corrections, he had a different social security number. And, with his situation, to his credit, he's got a loving wife who's, there by his side. The world is not perfect, but in my perfect world, once somebody is let out and they realize that error had happened, which wasn't, I guess, it wasn't his error. The paperwork when he was incarcerated was wrong. He should be able to go back to DOC and say, can you help me out? And, I would hope that now that we have the corrections ombudsman process that we're working towards, that's an individual that even somebody who's just let out can avail themselves of, because it's very important to me. But looking at 1196, you testified, first of all, I'm against section 2, so we'll just put that out to the side. But section 1, my concern there is it gives notice to the victims. What about the family of the incarcerated? Shouldn't they also have notice that their loved one is being transferred to another facility?
So if you go on the Department of Correction website, there's an archie, there's a location for where the individual. So if you looking for me,
I've been there.
yeah,
Yep.
Angel Carols, 1, 2, 3, 4, 5, 6 tells you exactly where the individual is at. So that's another mechanism for family members to know where the loved ones are at.
And is that real time updated?
That is real time updated.
Not in my experience. It is definitely not in my experience. I know in my experience, it is not, where I've had somebody who's been incarcerated, not a family member, but I've got a client, domestic violence case, and the wife is calling me and telling me where the guy is, and I'm on the DOC website, and I'm like, no, ma'am, this is what DOC says. No. He wants to see the kids. He's at this facility. So, in my experience, it's not. But do you have any objection to us adding to section 1? Should that language move forward, that notice is also given to the victim's family about transfer, because about a transfer prior to there too, right?
I don't have any objection.
Excuse me, you don't have any?
I don't have no objection.
Okay, okay. Well, I thank you. And I thank you for coming here today.
Thank you. Representative Callahan.
Thank you, Mr. Chairman. Good to see you, Commissioner. I have a question about the scanners that you're talking about. Prior to coming into this hearing today, I was just doing some reading. Is there limitations to the number of times inmates can be exposed and staff can be exposed to these scanners?
Yes, there are limitations of how many times per calendar year an individual can go through the body scanner. There is.
So it would be, to get these body scanners now, you'd also have to have staff recording how many times staff and inmates were exposed. And in addition, my second question would be, Commissioner, in listening to the testimony today, it was almost portrayed that some DOC staff, somewhat not enjoy, but the strip searches, but do you get complaints from staff about having to do these strip searches? It's like, it's not something they want to do.
It's not something staff want to do. I can tell you personally, as a correction officer in 1990, I worked the A&P room in Hartford for 3 years. And it was the most unpleasant duty for any correction officer, anybody to do, not just for the staff, but also for the individuals under our care.
Well, thank you, Commissioner. And so the issue with solving the issue of strip searches is scanners, but that seems to bring another issue into play, which I just wanted to bring to light to the hearing today. So I appreciate you coming in to testify, and I appreciate your answers. Thank you.
Thank you, Representative Porter.
Thank you, Mr. Chair, and thank you, Commissioner, for your testimony. Just a couple of questions. I wanted to go back to one that one of the COs wasn't able to answer, and it was around segregation, right? When folks are going to seg, they are stripped going in. Are they stripped coming out, was the question.
I believe not.
You believe now?
I believe not. They're not.
They're not.
They're not.
Okay. And then do you have, and I'm sure you do, data on how often contraband is actually discovered in strip searches? And I'm asking that because you did make mention that if this policy goes into law, you referenced the 1,077, 65% county jails, et cetera, that they wouldn't be done in those instances. I'm just curious to know how many instances such as those that you referenced that would not be covered by this law have actually, the outcome has been contraband was found. So that's not something I'm looking for you to answer now, but if you would just supply the committee with that information, that would be greatly appreciated.
Absolutely.
Then the other question I have is around minors. Are minors at facilities strip searched is the question.
A youthful offender is not strip search.
Okay, so are there any persons under the age of 18 in the state of Connecticut under DOC supervision that are subjected to strip searches?
Under 18, minor offense, they're not. Under 18, if they're being charged as an adult charges, they are.
So we do have minors that are stripped. Now, what happens if they refuse to be stripped? And this is for youth and adults. I'm just
In any
curious.
situation when an individual refuses a strip search, you can dry cell.
I'm sorry?
Dry cell the individual, put them in a cell and shut off the water and make sure that if he or she is hiding anything, that they can't flush it. So that's one option you can do. The other option is control strip search, which are seldomly done.
I'm sorry, what kind of
Control strip search.
Control
Yeah.
strip search. And what does that mean?
That's on the administrative director on searches. Basically, your clothes will be removed and the search will be conducted.
Okay, so I'm just curious as to how that happens. Are there restraints involved? How do
There's
you?
restraints. There's some restraints involved. So
Okay, that's why I'm asking, what's the
Yeah.
process?
So there are restraints involved. So the whole process is, if you're gonna take the shirt off and he's in restraints, so you remove the restraint. One officer has one hand, the other officer has the other hand. You put one hand up, you take the shirt off, then you put this hand up, and then you took the shirt off, and then you put the restraints back on.
And are there ever instances under a controlled strip search where they are cavity searches?
A cavity search is that's a great question, because I'm gonna clarify this. A cavity search can only be approved by a medical doctor, and cavity searches are not done inside correctional facility. If it's approved by a doctor, then they're taken to an outside hospital for that to be performed. But we do not perform body cavity searches
Within the facility,
within
any
the correctional
facility in the
any
state of
correctional
Connecticut?
facility.
Okay. All right, that's all I have for now. I'm sure we'll have a conversation offline, but I do appreciate you
Thank
being
you.
here today. Thank you, Mr. Chair.
Thank you.
Thank you, Representative Staffstrom.
Thank you, Mr. Chair, and good to see you, Commissioner. Thanks for being with us, and I appreciate you answering my question about the electronic stuff. my clerk is gonna get you a copy of a report that I stumbled upon today from the Department of Corrections in the state of Washington from 2017, where they issued a report to the legislature. Best I can tell, Washington legislature did what we often do, said, oh, we got this thorny issue, we're gonna make the agency study it and get back to us with a report. So they issued a report in 2017, and they found that that report indicates, at least from their research, that the cost of a scanner, body scanner, was about $225,000. But that there was overall savings to the department, because they said that if you look, they looked at the Women's Correctional Center out there and said there was approximately 1,500 strip searches per month at that facility. So I guess just rough estimates, would York be somewhat similar to that, more or less?
New York right now has a little bit over 700 individuals under our care. So I will have to calculate those numbers once I study it though.
Okay, but they were saying based on 1,500 strip searches a month, that equated to between 250 and 500 staff hours per month that were spent on strip searches. So I guess we could extrapolate that out at what the cost of man or woman hours is, and I'm guessing you may take issue with the testimony from the AFSCME representative about the staffing in our correctional facilities, right? I keep hearing we're still short staffed, but
We're not short staffed. We're 91%. One of the officers did indicate that the facility was fully staffed.
okay. So, but they said that this report from Washington basically said that if you took out the strip searches, that the body scan technology would reduce the amount of staff time down to about 4 hours. I mean, it would be a huge savings in terms of staff hours. Would you agree with that?
I agree with that. Totally agree with that.
Okay. And they also looked at, I think, the question Representative Callahan asked about the exposure. And, what they basically said is, well, radiation exposure from these machines is well within the federal guidelines. If we're talking about correctional staff, certainly we have TSA agents who deal with these all day, every day, and we've got safety procedures in place for them. And that they did not consider radiation exposure to be a major concern. And frankly, what they said is, particularly if we're using these scanners sort of in lieu of strip searches, if someone refuses to go through the scanner, then yeah, maybe they would be subjected to the strip search. But that would be the individual's option at that point, as opposed to the mandate or the default being a strip search. I found this report to be particularly interesting. It had seemed to me at one point, I said, well, maybe we should ask the department to study this issue, and which is sometimes what we do, but I'm not sure we need to. I think Washington has done it, and it seems like we could take a look at this and hopefully update it and see whether it's applicable here in Connecticut as well. But would seem to me to be.
Agree.
Thank you, Commissioner. And like I said, Nate is going to get you a copy of that report.
Thank you.
Thank you, Representative. I just want to make sure I heard correctly, because I'm listening with both my ears as the chair here and my ears as the chair of the Budget Committee on Judicial Corrections. So you are where in terms of staffing?
Excuse me?
Where are you in terms of staffing?
For correctional officer at 91%.
91%. Okay. So I have a question, and I know that we just had this follow-up conversation yesterday, but knowing that you were coming here to talk about IDs, do you have up-to-date information on where we are in terms of what we've done with IDs?
No, my staff are working to during that hearing yesterday. The committee told me, well, the chair told me 5 days.
Yeah, no, but
I don't have that information with me right now.
Knew you were coming here, and that's part of the conversation here. It is useful information for what we are trying to do here. Look, to me, the law is crystal clear as it currently sits. The law suggests that what we have been talking about are driver's licenses and state issued non-driver's IDs. The information we get is other stuff. And I'm not suggesting that other stuff is not important, but in order to know whether or not we are complying with the law, somewhat complying with the law, we need that information, both in the other committee appropriations and here in order to see what's going on. So I know appropriations gave you 5 days. Judiciary would like to get that information as soon as possible.
We will try to get to it as soon as possible.
Can you talk to me about, in these conversations, you keep bringing up the Puerto Rico situation, which I know is part of this. Can you talk to me in terms of, and again, we don't necessarily know how this breaks down given the other conversation we've been having, including yesterday, but can you talk to me where you think that sits in terms of portion of the total that we're talking about?
9%.
How much?
9% of the population.
9%?
9%.
Okay. And I think that's important too, because it keeps coming up, but I don't think that's even, I didn't think that was even close to the majority. So I just want to contextualize that for people listening. All right. Conversation from members of the committee, comment from members of the committee. Representative Porter for the second time.
Thank you, Mr. Chair, and I'll make this quick. Are we currently, DOC, are there currently contact visits?
Yes.
There are, okay. And then the other question that I have for you is, with non-contact visits, are the incarcerated people still subjected to strip searches for non-contact visits?
Non-contact visits. I will have to get back to you. I have not been, in a facility, working in a facility. Hold on. I have not worked inside a facility and conducted a strip search since the 90s.
I'm asking about policy, Commissioner.
Policy. I will have to get back to you. I'm going to say that, let me get back to you, make sure that they don't, or if they do.
Thank you.
Yeah.
Thank you, Mr. Chair.
Thank you. Before Representative Dillon, could you get that response back to the committee as a whole? Representative Dillon.
Good afternoon, Commissioner, and thank you for your testimony. Just to follow up on some questions that were asked earlier in the hearing, one of the people testifying before us made a statement about the availability of shift commanders on weekends when looking if they were going to get, authorization to do searches. Are there shift commanders available on weekends?
There are not shift commanders available on weekends or holidays. Shift commanders are the rank of a captain. They work Monday to Friday. However, on the weekend and on holidays, a lieutenant becomes the acting shift commander.
So in theory, there could be a higher up to go to for authorization?
In theory, the lieutenant that is working that day, that is in charge, he's the acting shift commander and assumes the same responsibility as the shift commander.
Okay, and they want to look at that again. That another is that just a simple forward-looking question related to the identification issue. And thank you very much for your testimony on that. I asked someone who testified earlier whether or not they were aware of any protocol in place that would prevent an inmate's bank account from being cheated by the state while they were incarcerated. Are you aware of any protocol like that?
I'm not. No.
Now, I wonder if it would be a potential way for your department to work with the treasurer's office to look at that, and maybe it's not the major issue before us today, but it's certainly a contributor or a barrier when you're re-entering. It was a non-issue for a long time because it was theoretically our policy to require you to pay back the cost of your incarceration, but that was changed. And I wonder if we can do a look back and see if people can get their assets, and if going forward we could work out a protocol that would protect their assets while they're incarcerated.
I can ask my staff to start working and start having those conversations.
Thank you very much, Commissioner, and thank you for your testimony today.
Thank you, Representative Dillon. Comment or question from members of the committee? Comment or question? Representative Callahan, is your hand still up, or do you have a second question? I'm going to assume the hand is still up. With that, Chief, thank you very much for joining us. I don't know why I said Chief. It's a long day for me. Thank you very much for joining us today. Brian Larson.
Good afternoon.
Good afternoon. You may testify.
Good morning. Good afternoon. I am Brian Larson. I have 8 years on the job. I'm a correction officer currently assigned to Manthan Youth Institution. I'm also a representative for Local 387, and I'm here to speak against the portion of the bill that covers strip searches. We've heard a lot of testimony from some of my coworkers as well as the commissioner, so I'm not going to bombard you with similar stories. I will start by saying that I think there's a big misconception as to what strip searches are utilized for. And I'd like to start by saying a strip search is not a punitive measure, and it's not done in a retaliatory measure. Strip searches are done for a number of reasons. Contraband, and contraband can cover many different aspects, including weapons. In some cases, these weapons are fashioned out of plastic toothbrushes, some of which were anywhere between 7 and 9 inches long, and when sharpened to a point can do significant damage to soft tissue. They also cannot be detected through a metal detector. Obviously, there's grave concerns with fentanyl being introduced into the correctional facility for both staff as well as the incarcerated individuals that could be exposed haphazardly to fentanyl. As far as health concerns, I know Katie Hill testified earlier about health concerns. One of the big health concerns that a strip search is proactive, which is the mental health aspect of it, where if an individual is being strip searched, something as simple as torn bed sheets, t-shirts, shoelaces, etc., that could be hidden on the person's body that wasn't found without a strip search could be conducive to suicide, as well as self-mutilation. I can tell you one instance that I experienced personally was bringing an individual from the main building to RHU for simply flagrant behavior. In the process of performing the strip search, which the inmate did comply with, a toothbrush was found that had been sharpened to a point. And when questioned as to why the inmate had the toothbrush, it wasn't for protection. He stated that he had a mission that he intended to carry out within the school. So based on the fact that officers were diligent in their duties and performing the necessary strip search, we can say that we proactively prevented a much more dangerous situation. I would also like to add that when we perform these strip searches, as though they are unpleasant and we don't look forward to them, it's always been my experience that we do these professionally and with as much dignity as we can to afford the inmate when we are performing these. We like to do them quickly, efficiently, and safely to ensure the safety of the staff, the individual that is being searched, as well as the inmate population around them. And I would also like to close with the fact that although there are some testimony out there and statistics about this, I have never experienced anything remotely close to being sexual or violent while performing these strip searches.
Thank you. Comment or question from members of the committee? Comment, question from members of the committee? Thank you very much. Next, we have Seth Freeman.
Good afternoon, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Seth Freeman, and I live in West Hartford. I'm the current president of Council of Connecticut Community Colleges, 4Cs, SCIU, Local 1973, which represents approximately 3,500 faculty and staff across our community college system, and approximately 400 adjunct faculty at the University of Hartford. And 4Cs is also a proud member of Recovery for All. I'm testifying today to testify in support of HB 6875, legislation that would ensure that every person leaving incarceration and returning to our communities has official state identification. Community organizations, individuals, reentry centers, and housing and health service providers all report the same thing. People are returning home without identification. At Transitions Clinic Network, a primary care health center provider serving Hartford, New Haven, and Bridgeport, which serves exclusively people returning home from incarceration, less than half of the patients return home with proper identification. We need to invest more in incarcerated residents in our state, both while they are incarcerated and during reentry, so they can return to our communities and live healthy and positive lives. We need to do our part and everything we can to remove barriers to successful reintegration. Proper identification is necessary for successful reintegration. Without a proper identification, it becomes difficult or impossible for an individual to obtain employment, housing, benefits, or healthcare services. This is not good for individuals returning from prison, and it's not good for our communities. This bill will significantly invest in our incarcerated populations to assist their transition back into our communities. Please support this important legislation. And thank you, committee members, for your hard work and for your service to our state.
Thank you, Mr. Freeman. Comment or question from members of the committee? Comment or questions? Seeing none, it's very good to see you. I'm sure I'll see you in the future. Next, we will hear from Diane Lewis.
Hello, Senator Winfield and members of the leadership and membership of the Judiciary Committee. My name is Diane Lewis, and I am a resident of Hartford, born and raised. I am a retention specialist with the State of Connecticut Building Trades Training Institute, a construction program for individuals seeking a career in the union building trades. I am the communications director for the social justice organization in Hartford, Voices of Women of Color, and I sit on the board of the Next Level Empowerment Program, a nonprofit organization whose main goal is to support the coordination of services and assist in improving the outcomes of returning citizens back to their home city. I am also a mother of a formerly incarcerated son who has been home for a little over 2 years. In solidarity with the other organizations that spoke today, we stand in support of HB 6875, an act concerning photo identification upon reentry into the community. Thank you for allowing me to speak to you today about why this bill is so important to me and our community as a whole. State law requires that the DOC make state ID available to incarcerated people upon their release. In the 17 years that I've been working with this population, I can tell you that that is not happening. Even with our program providing funds to individuals to purchase the required documents. A few days after my son was released from prison, he landed a job in a restaurant. He was ecstatic, and so was I, until they asked him for his photo ID and other employment-related documents. Of course, he couldn't accept the job without it. Even with my support, it was difficult for him to go through the process of obtaining a state-issued ID, but not everyone returning to us has that level of support. Please allow me to speak to you about Angel. Angel was a participant in the construction training program that I work for. He was released after doing a near 30-year bid. He was full of hope and promise with limited education and an inconsistent support system. He rode his bike to class every day, always on time. Always a positive story about what he saw on his bike ride to class. He was learning life all over again, and his excitement for this new beginning was contagious. Long story short, when it was time to go to job interviews, he learned what to say in the interview to sell himself, was advised to get there 15 minutes early, and he dressed up really nice. He learned what so many returning citizens learn once they come home. You need ID to get ID. The simple things we take for granted in our everyday life isn't that simple for our returning citizens. He felt defeated, and that light of excitement that made me smile every morning was extinguished. One morning, Angel told me that he felt invisible and wanted to drive his beloved bike into traffic one morning. My heart sank, and I never forgot it. That could have been my son, if not for some really good people that I met in this fight for freedom for formerly incarcerated people. I lost Angel. I don't know where he is today. And when you do this type of work, facing the reality that you lost one is both heartbreaking, and at the same time, is what motivates me to keep fighting. So I am here for all the angels, and along with the Building Trades Training Institute, the VOWOC Next Level Empowerment Program, we urge you to support this bill and hold the DOC accountable for providing returning citizens the same information that they use to ensure that they have the right person in their custody.
Thank you.
We are demanding that the DOC puts a state-issued ID in the hands of every single
Diane.
person being discharged from a correctional facility. And if this state is truly committed to second chances, it is critical
Diane.
that 2 years prior to release of the DOC, they start that process. Sorry,
Thank-
Senator.
Thank you.
And
Don't move. Don't move. There might be
I'm out
questions.
of time, but strip search the correctional staff.
Hold on. I know. I've been, listen, I've been there. I used to be, I know. And I know this is important. But we're trying to make sure you know what we're trying to do here. Comment or question from members of the committee, comment or question Representative Porter.
Well, first of all, I want to thank you for being here today and for your almost 2 decades of service to this freedom fight.
Thank you.
And you did get it in because I was going to ask you what was the experience of your son. The only question that I have around that you didn't address was, how long was it? Or I'm assuming he has ID because he's been home almost 2 years.
He has ID now.
But how long was it
Well, I
prior
had
to
to
his
take
release to getting?
2 days off work. And that was with the support of a friend of mine that knew someone at the DMV. So yeah, 2 days.
So you took 2 days off from work, but how
Mhm.
long was your son home before he had ID in hand?
Gosh, I don't want to say, I don't remember, but it was maybe 3 to 4 weeks because he was in the halfway house at the time.
Okay, so he did receive it before being released
Mhm.
from the halfway house.
Yeah,
All right.
because he needed to accept the job, and
Right.
in order to accept the job, he had to.
But
get the ID.
that was due to the connections that you
That
had.
was,
And we have to state that everyone doesn't have those connections.
right.
And everyone returning does not have the kind of support that your
That's
son
right.
had. So thank you. Appreciate you being here today.
Thank you.
You're welcome.
Thank you, Representative Porter. Comment. Wait. Comment or question from other members of the committee. If not, I just want to say this. Look, this is important to the committee, as I think you've heard.
Yes.
Across the party lines. It's particularly important to me because the last 2 bills dealing with this. And I'm sure that we had it right already. So we are going to get this right. And if we have to come back again, we will come back again. I'm hoping we don't, but I want you to understand that this is very important to this committee.
Yes,
So,
thank you. I recognize that. You should, when it's like topics like this, you guys should give us more than 3 minutes because I really wanted to get on that other bill too.
all right, thank you.
Thank you.
Comment or question? That's it. There we go.
Thank you.
Erica Bromley. Erica Bromley. Oh, there you are.
I'm hobbling.
I had you on remote, so sorry, I didn't see you.
Just in case, I wasn't sure. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the committee. My name is Erica Bromley, and I'm the Youth Justice Consultant for the Connecticut Youth Services Association. I'm here today to discuss 2 bills. My full testimony has additional information, but I will just highlight a few areas of support and concern. I'm speaking in support of HB 6888, but I'm also speaking in general opposition to House Bill 6889. I'm in support of the recommendations approved by the JJPOC and HB 6888 and will speak more specifically on sections 1 and 2. The pre-arrest diversion language for first and second time offenders for specified low-level offenses will allow for more youth to stay out of the JJ system and decrease disparities. Diverting youth before arrest can minimize recidivism, and youth are 2.5 times less likely to reoffend. Diversion is also a more cost-effective public safety strategy than court processing for low-risk youth. There are also a few small language changes that are necessary in order to make sure the bill language matches the intent language of the recommendations. Additionally, in section 2, we are requesting a representative from the Connecticut Youth Services Association be named as a member of the implementation team. Data from 2022 shows youth successfully completed diversion at a rate of 70%, with only 3.5% of youth rearrested during the time their case was open at a JRB. Rates over the last 6 years have ranged from 70% to 86% successful completion. Court data shows only 18% of youth in 2022 who were arrested for the specified charges, and the recommendation needed any type of supervision. Cases for these behaviors are already being organically diverted, and this would only further support and allow access to all youth without any disparities. Another important piece to discuss is the need for additional funding for the community-based diversion system. With additional reforms and more cases coming in, there's also a need to increase funding for those who are receiving these cases. The second bill I would like to testify on is HB 6889. I'm opposing this bill in its entirety, but would like to focus on sections 5 and 6 specifically. These sections essentially roll back very critical reforms that were made over the course of the last 5 years concerning family with service needs. Returning family with service needs cases back to court is a major step backwards and one that is not at all warranted. Family with service needs behaviors are not delinquent, illegal acts. Youth with FWISN behaviors are youth with high needs who are low risk and do not need to enter the court system just to receive services. Services available in the community largely match those that are utilized through the court system. Additionally, these proposed changes to FWISN have no impact on public safety. These are young people who are not engaging in delinquent behavior. They are young people who have behavioral health needs and who often need service provision as well as intensive case management, something court often cannot provide. In closing, Connecticut is a model state for its reform. Rolling back reform is not the answer. We need to continue to support community-based services to ensure youth are getting what they actually need, which is not court involvement. Thank you and happy to answer questions. The
Thank
first
you.
time I beat the bell, by the way.
You did. Representative Fishbaum.
Thank you, Mr. Chairman. Good afternoon. What is your actual knowledge about the Family with Special Needs program?
Family with service needs. The youth service bureaus are receiving those cases. I have been part of the JJPOC and was a member of the diversion work group and its chair when these changes were made.
Have you ever been involved with a family that is actually used?
Yes,
that
I was a
program?
youth service bureau director for 16 years before I became a consultant.
Okay, and you don't find any value in that service?
I find the value in the service of them receiving services in the community and not through court.
Okay, and understanding that not through court, the perception is that those cases go before a judge and there's findings of guilt. That's not the case.
Correct.
Essentially, a youth is assigned a probation officer through the juvenile court, and there is some sort of follow-up. Is that fair?
Generally speaking, yes, it is voluntary by the family and the youth. And a lot of the same services and programs that they would be referred to are the same ones that are available in the community. And we also know that any child who enters the court system is much more likely to return in the future.
Okay, so I just want to share with you an email that I got from one of my constituents. And I'm going to paraphrase certain aspects just to keep it, but this young man is 17 years old, and she looked into a residential treatment facility. She did all the assessments, but was denied because it was a place that the child didn't want to go to. And she can't make him. He's failing in school. His mouth is horrible, disrespectful. He's drinking, smoking, coming and going as he pleases, like he is an adult. Stealing. She's called the police. Now, ordinarily, this is a case that you hook her up with these social services, and they would apply for the Family with Service Needs program so that this kid doesn't get arrested at some point or kill someone because they're stealing a car. Without this program, what outlet do parents like this have?
Well, I want to clarify that it's not that there's no program. The referral has just changed from being referred to the court to being referred to a youth service bureau. And so it isn't like they're just out there hanging in the wind. There is a process. There's an actual form that mirrors the same one that was utilized before. And it is just sent to a youth service bureau where then they would do an intake, discuss with the family, try and figure out what kinds of ways they could engage the family and engage the young person. I'm not going to say that it's not a challenge for some families, for sure. But even if they were to go to court, if this were something that could be referred to court, again, those services are also voluntary in court, and there is really nothing that the court also could do in order to, force somebody to engage in services.
So in this particular case, they've already reached out to their town. And the extent to which the town Youth and Social Services Division can do anything here is extremely limited. You know, I think this program is necessary. But moving forward from there, you testified in support of 6888. And section 1 in Bill 6888 says that for the arrest, well, the perpetration of a certain illegal activity by a youth, that there shall not be arrest. You're aware of that?
Yep.
Okay. And are you aware of, now I'll read the statutes, 53A 110A. Do you know what that is?
I don't know what order they are in, but I know that it's simple trespass, creating a public disturbance, larceny 6, disorderly conduct.
Okay, so larceny 6.
Mhm.
So, we have places in this country that I'm seeing video of youth ransacking retail establishment. And if this law was to pass, you get 10 kids that go steal $499 worth of value from a merchant that is trying to somehow survive in this state. They don't get arrested, it goes to the JRB. That's what this would do.
Correct, and is actually happening for the most part as we speak currently.
And the JRB, Juvenile Review Board, not every town has one, first of all.
Correct. Close, getting there.
And what's the strongest power that a JRB has with regard to 10 youths from their community that just stole $499 from a merchant that's trying to survive in the state?
So the JRB process, if done the way in which, we would like it to be done, would hold a youth accountable by looking at who's been harmed and how they can help fix that. So dependent on the case, it could be a variety of ways to repair harm done. It's not, they would also be receiving services potentially that they might need, and so forth. And if they are not successful, then that case could be referred back to the police, who could refer that back to court.
So the question was, what is the strongest punishment that a JRB can levy upon these 10 individuals in my scenario?
Well, a JRB is not meant to be punitive. That's the entire point of having a JRB, is that so it can be restorative and hold kids actually accountable, opposed to punishing. But they, as I mentioned, they are able to send that back to the police, who can send that to court.
Okay.
So that would be if necessary, that would be at their discretion.
Can't find them, right?
Can't find who. Can't find who.
Well, I'm asking, my question twice already is, what is the severest penalty that a JRB can levy against these 10 children?
Yes, I understand that question. And again, we're not trying to penalize the young people. We are trying to help with the
I
situation.
understand what the
Okay.
policy.
So as I said, then what would happen if they were unsuccessful would be that they could be sent to court.
Okay, I believe the way the language says is the JRB would make their determination, and if there is not follow through with that, then it could be sent to court. That's what the language says, okay?
Correct.
But the JRB has virtually no punitive power. So if this law was to be adapted, let's say that these 10 individuals did this every day, 365 days a year.
The same youth?
Yeah.
They wouldn't be coming to the JRB.
Why? Under what language?
Well, this particular language is for first and second time offenses, and generally the JRBs are serving first and second time offenders.
Okay, what line are you referring to? where it says first or second.
That,
offense.
that is the language of the recommendation that we created.
I'm
I
looking
could
at
look
the-
for it, but,
I'm looking at the actual bill that we're talking about here today. Line 5 says, in lieu of arresting a child for violation of, so on and so forth. Doesn't say first or second offense. So I'm just looking at what we're looking at. So creating a public disturbance is another one of these statutes that go to a JRB. And do you know what creating a public disturbance is under our law?
it's an infraction.
Yep. Okay, that's the penalty, but do you know what the elements are?
I think that sometimes is at the discretion of an officer, but if you're asking if I know the exact language, I will say no. I mean, I know the intent.
Okay, well, it's not very long. If fights. In fact, it's not very long. I'll read it. Intent to cause inconvenience, annoyance, or alarm, or recklessly creating a risk of. They engage in fighting or in violent, tumultuous, or threatening behavior. Annoy or interferes with another person by offensive conduct. Makes unreasonable noise. I don't care about the unreasonable noise. I'm concerned about let's subjective. I'm concerned about the fighting, right? So I will tell you that I got a call from a mom who's got a child in a school in New Haven. Child likes to learn, but they're afraid to go to school. They're afraid of being bullied. They're afraid of fights. And this law, if it was to pass, would on every instance of fighting have to go to the JRB. The only other one I wanted to address with you is disorderly conduct. Do you know what disorderly conduct is under our statute?
Again, not the exact language, but the intent, yes.
Okay, well, we passed a law here, I think my first session, about what's known as upskirting, which is where somebody takes a cell phone and puts it underneath the female's skirt and takes a picture. I find it to be an offensive activity. But peeping Toms are part of disorderly conduct. So if you get a kid that is hiding in the closet of their next door neighbor so that they can watch them undress, besides simple trespass, which you've already written off because that automatically goes to the JRB. And I think for trespass to be criminal, it has to be some sort of posted sign. That voyeurism is dischargeable under this process. And, at the JJPOC, I know that there was a presentation about the proliferation of sex problems involving 17-year-olds in our state, that there's been a proliferation, a significant increase. I saw that presentation. And I'm concerned about, I'll read the language. While such person is inside a dwelling, not in plain view under the circumstance, no, I'll go back. Commits simple trespass and observes in other than a casual or cursory manner another person without knowledge or consent of the other person, while such other person is inside a dwelling and under circumstances where such other person has a reasonable expectation of privacy. That's exactly the scenario I just gave you. It's a young individual, we'll say a young boy, 17 years old, who's in his neighbor's home, watching the neighborhood girl change their clothes. And that can happen on a daily basis under this law. And it goes to the JRB with no punitive. I mean, I think that there should more than likely have some mental health situations that the Family with Special Needs program provides for. Anyway, there's a lot of problems. I thank you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question, Representative Howard?
Thank you, Mr. Chairman. And I'm going to ask you one quick question, and it's probably not a quick answer, and I'm happy to have more discussion, or if you could email me, I'm happy to have a Zoom. We could talk about it. But you have relative experience, and my question is, what is the answer, right? So I think all the members of this committee and this legislature at large, and likely the residents of the state of Connecticut, are in agreement that when juveniles are involved in behavior that may or may not be criminal, but they're outside of the control of their parents, whether they're truant from school, they're staying out late at night, they're driving across the state to steal cars or catalytic converters, or whatever they are, and the parents are not controlling those kids, and they're not getting to a point where there is, and you can use their punishment, whatever, accountability for bad acts. I've argued over and over that we cannot have a one-size-fits-all program. It just doesn't work like that. Every kid situation is unique. It's unique to them, certain things that they're born with, certain things in their environment, certain experiences they've had, et cetera, et cetera. So if it's a quick answer, you want to give it here, I'm happy to hear it. If it's a longer answer, I'm happy to have that conversation, but we need a solution. We cannot continue a process at which we have juveniles engaged in reckless behavior throughout the state that not only puts the public at risk, but themselves, and gets them on a path that's, the longer down the path they go, the tougher, I hope you would agree, it is to correct it. So if you want to speak to that now or talk to me after, I'm going to be clear with you. That's my intention. That's what I've been working on here. And I think that we have to come to an agreement, and if you would agree, that it isn't one answer, that there has to be multiple opportunities or multiple tools at the disposal of the government entities, all of them, to address a kid uniquely. So if you could respond to that, I'd appreciate it.
Sure, and I can do both. Happy to follow up with you. I think the first piece is really that the restorative foundation in diversion is just that. Accountability on an individual basis is going to look different depending on the behavior of each young person. And so that's the process, is identifying who's been harmed. How are you going to fix that? What else do you need to support you? Those are all individual. And so by doing that, you're addressing each individual situation, each individual need, based on that restorative foundation, while holding kids accountable. These are all very low risk kids. I will also mention a couple of things. One, the court has recently implemented risk-based case handling, which screens all youth coming in with a few exceptions, and any youth who screens out as low or medium risk to recidivate is automatically diverted back to the community. So these are all of the same kids that are going to be diverted back to the community anyway. The original recommendation, where this recommendation came from with the Council of State Governments, was actually to decriminalize all of these things. And over the last 3 years we've been working on this, we have adjusted it, and this is where we have landed. The other very quick answer I will give you is that part of the solution is identifying these youth and their needs much earlier. When you talk about things like truancy, when you talk about things like other behaviors, these are identifiable at earlier points in time. If kids are able to be identified by their schools earlier and not waiting until they're sophomores or juniors and they've missed 50 days of school, if we're talking about this at elementary school and middle school and all of those things, and addressing some of these needs earlier, that's the solution. That is really the only solution that I can tell you in a short answer, is earlier identification and earlier provision of services.
Full agreement, but to go back to my base question, what happens when we have, a youth, and even if it's a collection of low level offenses, and it's continuing, right? That to me, in my experience, which is probably less than yours, but I work a lot with kids and 21 years in law enforcement, is that those repetitive problems, is indicative of a lack of accountability. So what do we do? Because all of those the diversionary programs, all of the out of court stuff, JRB, all of it is dependent upon parental involvement and parental accountability to at least some degree. Wouldn't you agree?
Yes, but I will still go back and say that I think it's indicative of the fact that the root causes have not been addressed or addressed early enough.
Right.
And so again, we need to be able to make sure that we're serving them in a way where we can identify their needs, put the supports in place, and provide those services, which are the same services that come generally out of court as well.
Agreed. And so let me ask you this, and it may be, and certainly I'm sure you don't have empirical data, but anecdotally, how often are when we fail to address the underlying issue, or whatever words you said, or how you worded it, but we're not getting to the core of the problem. How often anecdotally is the core of the problem that the parents are not properly handling their role?
I think you're going to come across that, of course. I don't anecdotally even probably have an idea for that. I think it's really just oftentimes even the parents are in need of services as well. And so by addressing the family as a whole, then you're identifying what the needs are, not just from the young person, but from the family in general. Maybe there's basic needs issues. Maybe there's, whatever else it is. And by addressing all of that in a way that's not punitive, it's not scary, it's somebody who is advocating for you, all of those kinds of things, it's easier to put those kinds of things into place and have more success than if you send them to court for a punitive process.
Okay, I look forward to talking about it more. I think we're aligned in our goal. We just have to figure out, what the legislature's role is in that to assist to make it better and not worse. So I thank you for your time, and I thank you, Mr. Chairman.
Thank you.
Thank you, Representative Callahan.
Thank you, Mr. Chairman. Thank you, Ms. Bromley, for coming in. I just wanted to follow up with a couple of questions that the good ranking member and Representative Howard asked. If you've got someone who is going to be referred to the program, who perhaps there was a larceny of $450 involved, and the offender just is not going to abide by any of the rules of the program, is not going to pay back restitution, what's the recourse?
That young person would be referred back to the police department if they were the ones who made the referral, and then the police department could then, upon their discretion, send that back to court.
And we have an agreement with the police departments that if a case is referred to you and 4 months later it gets referred back to them, they can continue on with the case without having to do an arrest warrant or anything like that, correct?
Correct. That's the process now, is that it can be sent back to court. Usually they write a note on the police report that says they've been through the process and they've been unsuccessful.
Okay, and kind of going down the road where Representative Howard was going, as you know, I've got a background in this. I agree with the right program for the right person in addressing these things. Any issues that need to be addressed, whether it be basic needs, drug treatment, mental health treatment, family counseling. But at some point, there's got to be accountability. And when there's not accountability, I see these offenses escalating, and these youths get in more and more trouble later because they've had nothing but slaps on the hand up until a certain point. And I understand what you're trying to do, and it's admirable, but I do have concerns that we're going to have escalating problems, and which neither of us want. Would you like to answer that, or is that more of a statement than a question?
I mean, yes, certainly a statement. The only thing I will make mention of is the fact that accountability and punishment are not the same thing. And that if you are held accountable, then you are addressing the harm that you have caused, and you are repairing relationships and restoring relationships and repairing that harm. And so I want to make sure that we don't use those words as the same, because they are not the same. And so the Restorative Foundation does just that, holds kids actually accountable by having them identify who's been harmed and how do they fix it.
Oh, okay, and I see that, and I've seen the courts for years having people send letters to the victims in apology letters. But so I guess I've got my concerns on the table, and you and I and maybe Representative Howard can get together and talk further about it. I appreciate it. Thank you.
Thank you.
Thank you. Comment or question from other members of the committee? Comment or question? If not, Erica, thank you for joining us again. I'm going to turn it back over to Representative Staffstrom.
Thank you, Mr. Chair. Danielle Cooper.
Hello. Thank you and good afternoon to the distinguished leadership and members of the Judiciary Committee. My name is Dr. Danielle Cooper, and I currently reside in New Haven, Connecticut. I'm a certified prevention professional here in the state, as well as in Florida. I'm also an associate professor of criminal justice and the director of research at the Tau Youth Justice Institute, which is in West Haven, Connecticut. I think it's also important to mention that I serve as the principal investigator of several grant awards, specifically from the Office of Juvenile Justice and Delinquency Prevention, as well as the co-principal investigator of the Connecticut Connecticut Institute for Youth and Police Relations. Lots of my work and teaching are informed by the OJJDP's philosophy, which is to really enhance and focus on the welfare of youth and make sure that we're broadening opportunities for them, but also their priorities, which I feel like are essential to mention. So how do we take adolescent brain development into account so that we do not treat children or youth as adults? How do we be mindful that young people are better served in their communities, and that especially when their families are involved? And how do we make sure to provide opportunities equally across the board for young people? So I'm here based on that information to first and foremost offer testimony in support of House Bill 6888, an act concerning juvenile justice. I first want to amplify the provision that expands the membership of the JJPOC to include not only community members, but youth who are under the age of 26 and who have themselves been impacted by the juvenile justice system. I would be remiss if I didn't pause and say that I have learned so much from the youth and young adults who serve on the JJPOC's committees. This has been them sharing both their knowledge of advocacy, their lived experiences, and really a lot of what they do inform the practices and not just the policy recommendations that we have, but that is often within the work group structure. And this provision of the bill would allow them to actually be voting members of the Juvenile Justice and Policy Oversight Committee. I also want to speak in support of the bill in its entirety. So I believe firmly in the benefit of a community-based diversion system and its expansion and further resources allocated to it. I also support what would be the expansion of the Racial Profiling Prohibition Act to include pedestrian stops, as young people are not commonly the ones driving cars and stopped. They are often without those resources, especially the younger that they are. And so us better tracking data on pedestrian stops would potentially allow us to examine racial profiling by state and local law enforcement for those younger groups. In addition to the bill that I've already discussed, I'd also like to state my support for House Bill 6875, the act concerning the issuance of a state identification card and motor vehicle operator's license to a person being discharged from a correctional facility. And I'd like to end with strong opposition and affirmative, discussed with what is the opportunity that's being wasted if we were to advance House Bill 6889. The data show that adverse childhood experiences are even more likely to be experienced when you're a serious juvenile offender, and that our young adults are often facing traumatic, ineffective, and expensive experiences when they are in these systems. If we want to reduce mass incarceration, we must also be focused on improving juvenile justice. I thank you very much for your time, and I welcome any questions.
Comments from the committee, questions or comments? Seeing none, appreciate you being with us. Melissa Goman.
Hi, good afternoon. Thank you, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Melissa Koretz-Goman, and I'm testifying today in support of HB 6888, SB 1196, and in opposition to SB 6889 on behalf of the National Juvenile Justice Network. NJJN is a national membership organization focused on youth justice reform. We're comprised of 60 state-based organizational members across 42 states, including Connecticut. I'll start by briefly expressing our support for SB 1196 and urging you to pass this bill, minimizing the extremely dehumanizing and humiliating practice of strip searches by the Department of Corrections. But I'll turn the bulk of my remarks to HB 6888 and 6889. Regarding HB 6888, every section provides critical support for young people, as we highlighted in our written testimony. I'll focus on the bill's requirement of the development of a plan to remove youth under 18 from being held pretrial in adult jails. It's harmful to young people and to public safety to lock up adolescents in adult jails for a number of reasons. Chief among them, youth held in adult facilities are extremely vulnerable to physical and sexual assault and have much higher rates of suicide than youth in juvenile facilities. And research also shows that adult system incarceration increases recidivism among teens, thereby harming public safety. Recognizing these harms, the federal government amended the Juvenile Justice and Delinquency Prevention Act, or JJDPA, in 2018, requiring that all children under age 18, including those being tried as adults, be held in juvenile detention facilities pre-trial if they are detained as of the end of December 2021. So we urge you to pass HB 6888. So a plan and implementation can move forward expeditiously.
Thank you.
Regarding, thank you. Am I out of time now?
Close. I'm sorry. I thought you were wrapping up. I apologize.
Oh, okay. I just had a few things on HB 6889, which we urge you to oppose. We strongly discourage expanding the number of offenses that are automatically charged in adult courts and would encourage you, in fact, to end this practice. Adult prosecution causes young people great harm, as I discussed. And in Connecticut, those who enter the adult system are 30% more likely to be rearrested after returning to the community than young people who stayed in the youth legal system. So a determination of whether to charge a young person as an adult should always be given serious consideration by a judge. Nationally, the tide is shifting away from auto transferring youth to adult courts, and 26 states have made changes to their laws, reducing the automatic transfers of youth into adult court in the past 15 years. So we urge you not to pass HB 6889. Thank you.
Questions or comments from the committee? Seeing none, appreciate being with us. Lauren, Ruth.
Good afternoon, Representative Staffstrom, Representative Fishbein, and the distinguished members of the Judiciary Committee. My name is Lauren Ruth. I'm testifying today on behalf of Connecticut Voices for Children. We are a research-based advocacy organization located out of New Haven. We've submitted written testimony in support of House Bill 6888, Senate Bill 1196, House Bill 6875, and in opposition to parts of House Bill 6889. We appreciate that House Bill 6888 has provisions that would provide young people with connections to needed programs and services while reducing their contact with the criminal legal system. And it also has provisions that would improve living conditions for young people in the deepest end of the criminal legal system by making commissary more equitable and educational, and by revamping the plan to remove young people from Manson Youth Institute, which we know is an inappropriate setting for teenagers. We want to amplify Section 5 of House Bill 6888, which includes language to create a reentry plan for young people that leverages the good work being done at the reentry roundtables and the reentry welcome centers. Creating and implementing a reentry success plan is critical for supporting young people reentering their communities after involvement with the criminal legal system, for supporting their civic and economic participation in their communities, and improving public safety. So far, the reentry welcome centers, which were established during the pandemic using ARPA dollars, have been extremely effective. The Bridgeport Reentry Welcome Center has served over 200 people since its inception and reports reoffense rates in the low single digits. I want to flag for this committee that the welcome centers run out of ARPA funding in June 2024. At least the Bridgeport and Hartford centers expect to close their doors when that money runs out, absent securing new funding. So in order for this very good policy to be effective, the welcome centers will need new investments from the state. And we ask that this committee build language into this bill to not only renew, but expand their funding so that they can operate with full staffing and provide assistance to clients while they work to secure housing, access healthcare, and secure employment. I additionally want to raise that we support Senate Bill 1196, which would require DOC to have probable cause of possessing contraband to conduct strip searches. And we would ask that this committee consider extending the standard of probable cause to young people in judicial care and young people in schools, because currently these systems have a standard of reasonable suspicion to conduct strip searches. And so while I don't have time to talk about all parts of these bills, I want to thank you for giving me this opportunity to provide testimony and answer questions.
Questions or comments from the committee? Seeing none, thanks for being with us. Ken Barone.
Good afternoon, Representative Staffstrom, Representative Fishbein, and distinguished members of the committee. My name is Ken Barone, the Associate Director at the IMRP at UConn and manager of Connecticut's Racial Profiling Prohibition Project. I'm here today to testify on behalf of the Advisory Board regarding House Bill 6888, an act concerning juvenile justice. In particular, I'm here to discuss Section 8 of the bill to require the collection of pedestrian stop data. My comments will simply reflect technical considerations that I was asked to weigh in on. And my comments do not reflect a particular position regarding the merits of collecting pedestrian stop data. The advisory board has not weighed in or taken a position. That being said, Section 8 of the bill would require police officers to report information on pedestrian stops. The effective dates outlined in the bill do not provide sufficient time to properly implement the changes being requested in the bill. Making even small changes to the racial profiling data collection system is a timely process. We'd need to work with the Criminal Justice Information System, 107 police departments, and well over 20 records management system vendors. And we would want to, any changes we make, we would want to ensure that a cost is not passed on to municipalities to modify their RMS system. There are ways to do that, but we respectfully ask that if system modifications are being requested to collect additional information, that we be provided a minimum of 12 to 18 months to implement those requested changes. My written testimony outlines the effective dates that we recommend for the different sections of the bill. That's all I have today, and I'm happy to take questions if there are any. Thank you.
Questions or comments from the committee? Questions or comments? So, Ken, if I understand your testimony, I'm just looking at this. This says effective from passage, which obviously would be as early as June, and certainly you're saying that that wouldn't be practical, and that you believe it would be at least 18 months before you could implement.
In the testimony, written testimony, we request until January 1st, 2024 to come up with a standard, figure out what data to be collected, how to collect it. The Criminal Justice Information System would then need probably a full year to implement those technical changes and to push those changes out to departments. So we would ask that departments not be required to collect pedestrian stop data until January 1st, 2025. And then you need a year's worth of data before you can do any sort of a thoughtful analysis. So we would request that the first analysis of pedestrian stop data not be required to be reported until July 1st, 2026. That follows the timeline that it took us to implement the traffic stop data collection system. And so we think that would be reasonable.
All right. Ken, did you folks have an opportunity to weigh in on the definition of pedestrian stop in this bill, or no?
The advisory board did not weigh in on the definition of a pedestrian stop.
Okay. All right, thank you. Further questions? Seeing none?
Thank you.
Appreciate being with us. I have Pear Bog. Go ahead, sir.
Hello.
Can I just ask who's with you?
This is Andrew Clark, who is here.
Is Mr. Clark signed up to testify?
I signed him up. I was hoping to. I'm not planning to speak.
Okay, you can sit. Unfortunately, we do just kind of the way we've been doing it, and to keep a clean record, we can't actually allow you to testify or to speak, but happy to have you sit there. Go ahead, sir.
Dear committee, I'm in Connecticut. I'm a Norwegian citizen in Connecticut because it has been a reverse visit and invitation from Yukon University. After a visit, I received your group in Norway in November 2022. So they came to me because I'm a correctional manager and have been that since 1992, and I'm now into international relationship in the Directorate of the Correctional Service of Norway. So based on the purpose of my invitation to you and the visit that they paid me in Norway some months ago, I'm here to reflect these issues of the changes that we have done in Norway.
So let me stop you. What bill are you testifying on our agenda?
Well, I'm here also based on the sheets written by Andrew Clark.
But what bill on our agenda?
It's the 1196.
Okay,
It's the 6875 and 6888.
okay, perfect. Thank you.
So based on my experience from my many years in the judicial chain, since 1984, I started in the police. I have been a prosecutor, a judge, and a prison governor until 2001, when I became one of 6 regional directors in the Norwegian Correctional Service. So based on this experience, I'm here to exchange knowledge and best practice with you as an invitation from Connecticut. So I have in particular seen the discussion and followed your with interest the issues concerning identification papers. And I was asked by these colleagues from Connecticut what this practice in Norway was. And we have a full ability for anyone to have any kind of official identification papers. The other issue is the strip search, where the practice in Connecticut is quite similar to what we have done in the Norwegian.
I interrupted you real quick, so I'll throw you a softball question. So on strip searches, there's been quite a bit of, I think, back and forth today, and I don't want to speak for everybody on the committee, but I certainly am starting to get a sense here that there may be a willingness of the committee to certainly limit the use of strip search as much as possible. And particularly by using, well, we recognize that there is certainly a valid public policy ground for trying to keep contraband, drugs, weapons, et cetera, out of our prisons, that there may be technological advances that would help us accomplish some of these goals without the need for full-blown strip searches every time someone comes in or comes back into a correctional facility. So maybe you could, it's something I think I've been particularly focused on today. Maybe you could just specifically speak to that point of whether you're aware of technological advances that we should be looking at here in Connecticut to limit the use of strip searches in our prison system.
Well, concerning technical level of equipment, I think Norway should look to America to learn. But what we have done concerning this is quite the same practice, but we had court hearing and we lost as a government this court hearing for doing too much strip searches. The reason was the human rights regulations. And as part of this experience of mine, I was kind of surprised that we have been breaking the law for my 30 years in this correctional service. We changed the rules immediately, and we're now according to the human rights standards of not doing this unless there is a good security reason.
So would sort of routine visits outside of the courthouse or outside of the correctional facility? So, I guess maybe I'm not overly familiar with the Norwegian justice system, but for example, if someone is being held pre-trial, they need to leave a correctional facility to go to a courthouse, and then they return back to the correctional facility at the end of the day. In that instance, would someone be strip searched when they came back into the correctional facility?
Maybe, but there has to be an individual and a concrete kind of suspicion to do this right now.
Okay.
Earlier, we did it automatically.
Okay, great. Further questions or comments from the committee? Further questions or comments, Representative Porter?
Thank you, Mr. Chair. And first of all, Mr. Vaug, I just want to say welcome to the Connecticut General Assembly. As one of those persons that were afforded the opportunity to visit in Norway, I can't even begin to state how excited I am. You are here to share some of your knowledge with us. You brought up the human rights regulations and standards that you looked at. And I know that we've talked about Mandela rights, and I wanted to know, how did that play a role in what it was you all decided to do in Norway? And if you could just speak to what actually propelled you, right, to make the changes that you made in Norway, because Norway is recognized as the world's most humane penal system. So if you could just kind of go back and explain to us how you got to where you are today, because it's my understanding that that wasn't always the case.
No, I'm educated in law, and I was a prosecutor and a police employed for many years, and I didn't care too much about the human rights regulations for many years. I became a prison governor, and I still didn't care too much about that kind of regulations until the courts came to us and say, you have to change. And then the whole group of lawyers in Norway in all kinds of businesses and sectors, we had to change the attitudes concerning the human rights. So in many fields of our society, the human rights have been much more important, and it has happened quite rapidly. And concerning the prison situation, we are as all Norwegian governments, we are the sectors, we are the level of the legislation, the national legislation in Norway is below the legislations of international ratified conventions. So therefore we have it's a point of no return when we have kind of a dispute whether the Norwegian law and practice or the international conventions should be the leading factors. So we have had to change several things, but this concerning the strip search is among the last ones.
Thank you for that. And I mean, we know that there's a culture when we talk about the facilities that we're discussing today. I'm sure that same culture existed in Norway. And I'm just curious as to, how did you make the shift with everyone being able to come into agreement? I'm talking about, the correctional officers, the resistance there. How did you bring people together so that you were able to make these changes, which actually benefit everyone?
Well, it's not a quick fix, as everyone understands. It's a difficult system to change, but I would say that the curiosity and the involvement from the politicians of the highest level in the parliament was maybe the main factor. And then we made arrangements or situations that was positive from the prison situation, prison facilities that we could be proud of. We also had a lot of discussions internally how we could define our terms. For instance, the term of security, we divided to three, like the organizational security, the static security, and the dynamic security. And this matter of strip search is part of both dynamic securities, because it's a matter of the connection between the staff and the inmates, as well as the organizational matters. How should you do a service or an action like this? And now we have been guided by the human rights standards that it can be done, but it has to be done in a way of dignity.
Thank you for that response. And as far as the staff, right, the correctional officers, and I know that you don't call them correctional officers, and governor, just for those that don't understand, is actually a commissioner in Norway, is what you're called. How did you, what was their resistance? I mean, like the correction, were they immediately, in compliance? Was there pushback? Can you speak to how you actually were able to address what was going on inside in order to make this shift?
concerning this issue which is concerning the bill, it's a kind of task that no officer enjoys, and but it's a purpose done to secure the prison the best possible way. And now we have been guided to use, for instance, technical instruments much more. There is not it's not forbidden to do this anymore, but we have to do it just in certain cases, and we have to write a report and things like that. But the turnover of the whole culture of the Norwegian correctional service has been done in companionship with the prison officers and the unions. So we haven't done any larger steps without the internal discussions, and not everything has been accepted, but more or less everything is decided by the politicians, and the law is decided, and we all have to adapt to it. So I would say that the politicians interested in our agency has been of great importance. Also, the growth of the competence of the staff. We have like 2 years education before they are able to go into the wings, the prison officers, and also the training of the management. So it has taken a time, but now we have done it our way. So yeah.
Thank you for that. Sounds like stakeholders were at the table at every level, including the unions that represented the correctional officers, correct?
Yeah.
Okay. Well, I definitely thank you for bringing this to our attention and sharing what you've been able to do there, in the hopes that we will be able to do some of that transition as well. And I thank you for centering humanity when you looked at doing all this as well. Thank you, Mr. Chair.
Thank you.
And thank you, Andrew.
Thank you, Representative. Further questions or comments from the committee? If not, sir, welcome to Connecticut. Thanks for sharing your expertise with us.
Thank you so much.
Sue Hamilton.
Good afternoon, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Susan Hamilton, and I am the Director of Delinquency Defense and Child Protection with the Public Defender's Office. I appreciate the opportunity to be here with you today to provide testimony on two bills on your agenda, 6888 and 6889. I have submitted written testimony on both bills, so I won't repeat or read to you what's in there, but I would just highlight a couple of key points and then be available for any questions you might have. With regards to raised bill 6888, as the committee is aware, this would basically codify recent recommendations that were approved by the Juvenile Justice Policy and Oversight Committee. It does a host of things, as you are aware, including mandatory pre-arrest diversion for certain low-level offenses, requiring the development and implementation of reentry plans for youth who are reentering their communities after being incarcerated. It adds the membership and increases the membership of youth and parent voice as voting members of the JJPOC. And it also helps to create and enhance the racial profiling protections that exist to include pedestrian stops. Just real quickly with regards to section 1, and there may be some questions about that in response to prior testimony that you've already heard today. That bill as currently drafted would require mandatory pre-arrest diversion for low-level offenses, but would also allow the opportunity for those behaviors to be referred back to court if those interventions are unsuccessful. The language as drafted does not include first and second time offenses. I think to Representative Fishbein's questions earlier, that recommendation did include narrowing the scope of that language, so that may require some level of amendment. In addition, it phases in that proposal so that only certain behaviors would be diverted initially by July 1, and then the remaining behaviors would be phased in following the submission of a plan in July of 2024. Sections 4 and 5 respectively, again, help to develop equitable commissary practices as well as reentry plans for youth. We've heard about reentry challenges on a host of fronts this afternoon. And our office represents most of the young people, many of the young people who are incarcerated. And these plans and timeful planning and access to these supports are really critical, in our opinion, to their success. Real quickly with regards to, so we would urge the committees to act favorably on that bill. We are opposed to Senate bill, raised bill 6889 for a host of reasons. We do believe that the provisions in here would cause significant backsliding on some very effective youth justice reforms that this committee and others have worked on over the last several years. In particular, this bill adds or increases or could increase the likelihood of transfer of young people to the adult court by adding a serious juvenile offense to the list of offenses that would be automatically transferred. I would just highlight that that is just a definition that includes already a set of offenses that are already transferable, either automatically or otherwise, to the adult court.
Thank you.
Happy to answer any questions.
Representative Fishbein, followed by Senator Kissel.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
Just focusing on 6888 for a moment in section 1, I think I heard you say that would afford the ability for the matter to go back to court. Is that
Yes.
okay? So as drafted, when would this case ever get to court?
There may need to
When
be
you say
some.
back to court, it must have been at court. to
Well,
get back
it,
to court.
well, it currently under the existing system, many of these behaviors are already referred to the same set of services we're talking about here, but it's happening post-arrest versus pre-arrest. So under the existing system, that's happening already. To the extent that youth are receiving those services and they're not successful or effective, the case can go back to the referring entity, whether that be law enforcement or the schools, to then be referred to court.
Okay, but the language, should this pass, the case doesn't go to court. So you can't go back to court, right?
So maybe what we should refer to that as back to the police for follow-up as they see necessary, which could be a referral to court. They don't go to court first and then go to the
Agreed.
services, yeah.
Yeah, so when you say go back to court, if you don't go to court, then you can't go back to court, right? So the way the procedure, if this was to pass, is if a child is suspected of violating one of these statutes, it doesn't go to court, they're given a ticket. This is my experience with JRBs, right? Go to the JRB in your local community. JRB does their thing. And if they don't comply, then it can go to court.
Correct.
Okay. So does your department, your division represent families at JRBs?
No, not at the JRBs.
Well, don't you
We
think that-
represent, no, we would represent the child if there ultimately is a referral to court due to an arrest and a need to prosecute the case.
So, I've had experience at juvenile court where, I've been able to work, I've seen public defenders do a great job. I had a case where a target was found in a young man's backpack. It happened to be a picture of his ex-girlfriend. And it was thought that the holes that were on the target were created by the young man, that it was threatening, all this stuff, right? We went to juvenile court. We sat down with the public defender, got some advice. They were able to negotiate with the prosecutor, and it was a friend. It was, the kid hadn't really done anything, it was an amicable breakup, all that stuff. It was a one-off. But in that particular case, I don't think without the public defender's knowledge of procedure, rules of evidence, so on and so forth, it would have been that result, right? So certainly some of these matters can be troubling. They could be indicative of other issues. They could lead to other issues. Why is the public defender's office not valued in that realm?
Well, we are of course invested in kids not coming to the court system unless that becomes absolutely necessary. I should just clarify a couple of things though for you in terms of the cases that right now are going to court. Let's just say this doesn't pass. And most of these kids are still going to go to the services. They're going to be arrested first and hopefully successful so that we don't end up ever having to have the case prosecuted in a criminal kind of fashion. But if they do go to court even today, these types of behaviors are not ones that generally will be handled in a judicial fashion. So they will go to the juvenile court and they can be reviewed and screened out by probation and then referred back to the same set of services that this proposal gives them right at the outset. So the way we view this proposal is that it can promote more timely access to the same set of services rather than having the case go to court, screened by probation and then referred back. When those cases go, they call it non-judicial, our office is never involved. So really what it does is reserve the judicial resources, our office and some of the other judicial interventions for the more serious behaviors, either greater risk or greater need.
So I understand, but a lot of people who don't have any knowledge of the system think that this is the panacea for everything. Certainly there are defenses that can be asserted in court. Larceny 6 is stealing something up to $500. You get 4 kids that, just left the store and they're all sharing whatever was stolen. They're probably all going to get arrested. They go to juvenile court, you're going to be able to assert a defense that I didn't do it. Mm-hmm. You don't have that ability. Well, I guess you have that ability before a JRB, but you don't have anybody who has the trained knowledge as far as if that case went to court, whether or not that child could be exonerated.
Yeah, but I agree. There's benefits to having a defense of a case if it's necessary to handle a case in a criminal fashion. So that's exactly what would happen to the extent of behavior or an offense, a serious offense is handled judicially. It then is in that context. Offenses are raised, cases can go on, there can be trials. And ultimately, if there is going to be a disposition that requires access to a set of services, that will happen well down the line, as opposed to happening earlier right out of the gate. But in the types of behaviors we're talking about in this proposal, they wouldn't even be handled judicially, even if an arrested young person was actually referred to court. These would be screened out and sent back. So I agree with you. And I think that I don't know if it was Representative Howard or it might have been you, Representative Fishbein. A lot of the goals, I think, in terms of how we want to improve outcomes for kids and promote public safety, we're kind of in agreement with. The question is what is the best way to intervene in families and with children to make sure that we have the best opportunity for success. And so our support of this bill is really that these are the types of behaviors that should not necessarily require an arrest and a matter to be handled in a criminal way. I think there needs to be an opportunity, as it is now. These services are already in the community and they're working very well. We're seeing declines in the numbers of cases being sent post-arrest as a delinquency petition, where we have to actually bring a young person and their family to court and to handle it that way. That's not to say that there won't be cases, which is why we built into this the mechanism to have it go back to court if the interventions are not effective.
I hear what you're saying. I know about the current process. Where we are is, in my opinion, a watering down of the process. But to take away that ability, every case is different and every kid is different. So, but I thank you for your testimony.
Of course.
Further questions or comments from the committee? Further questions or comments? Representative Howard?
Thank you, Mr. Chair. Thank you, ma'am, for being here. So when a child is referred to juvenile court, who refers them to juvenile court?
That would be law enforcement.
And if they go to JRB, who is it then?
So depending on the level of the charge,
Mhm.
the case will be initially screened by probation
Mhm.
to determine whether or not that case should be handled. It's called non-judicial, where it would be.
Who alerts probation?
Probate, it comes as an arrest to court, a summons.
Okay, so am I to understand then for all of the diversionary programs that we have in this realm, not all related to children, the police officers are in fact the gatekeeper to it effectively, right?
For this particular process, yes.
So that brings me to your testimony in favor of Section 8. So many years ago, police officers used to walk down the street and they had great interactions with their community, and they could deal with things much more with a scalpel than with a broadsword because they knew their community. Then we put police officers in cars. When it was summertime, the windows were down, they did it more. Then we gave them AC, and progressively the interaction in non-incident related interactions with police in the community have diminished over the years. And certainly the advent of body cams, now the officers are charged with recording their interactions and going back and logging those. And I'm not speaking against body cams. I support them, of course. My concern is I'm not sure how we would ever determine what a pedestrian stop actually is. And my concern is that we are, especially in, neighborhoods like where I live and where I work, we are going to further diminish the positive interaction between law enforcement and their community, and specifically youth. I just don't, I don't see that as a positive step. I think, and I, in my community where I live and where I work as a police officer and have for 21 years, I love to brag about what I've done with children in that community. Talk about 180 kids coming out for a youth program that I've made play for free for 8 years with the amount of fundraising I've done. So I just reject the notion that police officers are globally bad for kids. And certainly you didn't make that notion, but it's made up here often. The interaction, law enforcement is the one profession in this state where individuals pass polygraph tests, psych evals, et cetera, to make sure they're good character, which isn't to say they all are. But why would we take steps to diminish that positive interaction between police and members of the community, and specifically youths, which this would effectively do?
First of all, I really appreciate you raising the point about some of the conversations that happen here, and this polarization that seems to occur sometimes between sort of, pro law enforcement, anti-law enforcement, pro public safety, that being somehow disparate from improved outcomes for youth, because that's not true. That section of the bill, though, I think is aimed, certainly the intent is not to interfere with or in any way, interfere with or negatively impact the relationships between law enforcement and youth in their communities. I think what it's aimed at is really addressing the disparate impact. And that's what that provision is really focused on. And I would say, I think to the point about also the other section about mandatory pre-arrest diversion, one of the things that also does, there's not a lot of uniformity across the state in how those decisions by law enforcement are made. And I'm not saying at all here saying that those are not well-intentioned, when whatever action is being taken with regards to the referrals to court, but they're not being handled, the same behaviors are not being handled the same way across jurisdictions. So same with Section 1, that standardization of how those interactions will occur will help to prevent and eliminate some of that from happening. Because I agree with you, and that's not always the case, but in those cases where it is motivated by that, that's what that section is attempting to try to address. And if there's ways to work on tailoring the language or revising in some way to make that clearer, I'm happy to help with that, as would be others who actively worked on that language for purposes of the JJPOC bill.
Sure, and I appreciate that. And what it's not my opinion that the intent is to do that. My opinion is the intent of this is to deter racial profiling and pedestrian stops. That's evident, right? I get it. I just think that today, if you had an officer who was doing that in a given community and somebody complained, all of their body cam stuff is locked and they can't change it. So it is what it is. And you could go and investigate that. I'm telling you, and I'm making my colleagues here aware, that will be the fallout. Much of the success that I had in my law enforcement career working in my community is that when I showed up at a scene when things were chaotic and somebody's in some sort of crisis because an incident occurred or they're having some sort of issue, They didn't see a uniform walking through the door, a person of authority and power coming through the door. They saw a person they knew, that they've talked to before, somebody's husband, somebody's father, somebody's friend. So because I had interactions with them when they weren't in those positions, in those incidents, and that has been massively successful in my career and the career of many of my law enforcement colleagues. I'm very concerned that passage of this language is going to further deter that, and it's only going to lead to more problems. And we don't need more problems. We need less of them. We need more integration between law enforcement and the communities that they serve. And this is a step in the wrong direction. And I give you an opportunity to respond to that, and then I'll yield back. Thank you.
Well, I suspect that you'll be hearing from others who will speak to that particular section, who worked more actively on that. But I will say, I agree with your point about the fact that we don't need more problems. We need fewer problems. I may disagree about sort of what the ultimate impact of this might be. But I do agree that we need to continue to try to figure out ways to build those relationships. And some of the ways things are happening currently are not promoting that goal, I guess I would say. But I sincerely do appreciate, first of all, the work that you do and your perspective on the unintended consequences that that language might give rise to.
Attorney Hamilton, just on that point, so I had asked this question of previous witness, but I got to be honest, when I first heard sort of the concept of, wait a second, we're going to track every pedestrian stop, how's that going to work? What's that going to look like? Is that going to prevent a police officer from having a chat with a kid or playing basketball? I sort of shared some of Representative Howard's concerns on that. But I'm looking at the language of the bill now. Line 848 to 854, unless I'm reading it wrong, is very, very, very narrow. I mean, maybe the word pedestrian stop is the wrong term to use here, but frankly, this is only looking at instances where a citation is issued, an arrest is made, or someone is frisked. So that's not the situation of, hey, you having a good day? How was school? Can we play basketball? I mean, you were talking very, very specific instances, and it's limited to those three of citation, an arrest, or frisk. Now, I guess one could argue, why would we need to track if there's already been a citation or an arrest? Really, what this is looking at is situations where there's a frisk. But I guess I'm trying to sort of, like I said, I initially sort of had concerns about where this was going. And now that I drill down in this language, unless I'm reading this wrong, I think the intent here is exceptionally narrow. Am I wrong on that?
No, I don't think you're wrong. I would agree. I think the intent and the language itself, I should back away from saying intent, but I think that as well, was to just add that in a limited way, along with the protections that already apply when it's a traffic stop. And so it is not like, to your point about making it difficult to have those interactions between young people and the law enforcement and others in the community that are trying to work with them. It is narrower in scope. So I think that's something for the legislature to keep in mind. And if that language is not clear enough, I know there will be other iterations of the bill as it moves forward. I do know there are some other clarifications that need to be made in the bill. So this might be one of them to the extent that needs more clarification.
Okay, thank you. Seeing no further questions, we appreciate being with us.
Thank you.
Christina Quaranta.
Representative Sastrom and members of the Judiciary Committee. My name is Christina Quaranta, and I'm the Executive Director of the Connecticut Justice Alliance. We are a statewide public policy, advocacy, and organizing youth adult partnership. Our mission is to end the criminalization of youth. While we support a number of bills that are included on today's agenda, along with Senate Bill 1196 limiting strip searches, I'm going to focus my points today on House Bill 6888 and House Bill 6899. CTJA believes in the investment in young people, families, and communities. And that should be at the top of every legislator's to-do list. Connecticut has made many strides in reforming the youth legal system over the past decade. It's also taken steps in abolishing damaging policies that have harmed communities. The young people in Connecticut cannot afford for us to throw up our hands and say we're done. We must continue to address root causes of youth crime and ask ourselves, are our policies about safety and security or power and control? Throughout today's public hearing, you've all heard a number of proposals, and let's talk a little bit more about 6888 and 6889. Both of those bills seem to be in contrast to each other. One calls for a plan to be drafted for the removal of young people from the Department of Corrections, while the other makes it easier to send a child to adult court and incarcerate children in adult prison. Those that are responsible for proposing the first piece of legislation say that it's for the safety and security of all, and we believe this is incorrect. This proposal goes against best practice and denies the research that tells us that sending a child to adult prison will only make it more likely that he or she will reoffend, will cause further trauma, and will have a negative impact on public safety. Here are some quick facts about kids in adult prison. In December of 2021, the U.S. Department of Justice found that Manson Youth Institution, located here in Chester, Connecticut, was violating children's constitutional rights regarding access to mental health care, isolation, and access to education. Today is March 15th of 2023, and we are still in the dark about the negotiations between the Department of Correction and the Department of Justice. We find this to be unacceptable. As of March 1st, 2023, there were 51 boys under the age of 18 inside of MYI. Are you okay with not knowing the conditions that they're in? Connecticut has one of the country's highest levels of racial disparity in its legal system. Manson Youth alone has over 80% of Black and brown youth that are incarcerated there, while we know that white youth commit crimes at the same rate as their peers. Black youth make up about 12% of Connecticut's youth population, but about 43% of the incarcerated youth population in Connecticut. We know that incarcerating young people undermines public safety, and it does not address the root cause. If the goal of Connecticut is to teach young people new skills and rehabilitate them, Connecticut's failing. If the goal is to punish them, Connecticut's getting 5 gold stars. If the goal is to return children to their families for them to be your neighbors, wouldn't you want them to receive effective care and treatment? Nearly every state in the 1990s rolled back policies to treat more young children as adults, and we've moved forward in Connecticut and other places to change that.
Thank you, Christine.
You're welcome.
Questions or comments? Seeing none, appreciate you.
Thank you.
Marcus Harvin.
Good afternoon, Senator Representative Strom and leadership and members of the Judiciary Committees. My name is Marcus T. Harvin. I'm a resident of New Haven, Connecticut. I'm here today in support of HB 6875, legislation that would ensure that every person leaving incarceration and returning to our communities has official state identification. Proper identification is necessary for many aspects of successful reintegration into communities. Without a proper identification, it becomes difficult or impossible to obtain employment, housing, benefits, or healthcare services. This is not good for individuals and is not good for our communities. This issue is of paramount importance to me because just about 300 days ago, I was released from the custody of the Connecticut Department of Corrections after serving 6 years and 2 months. The only form of identification the Department of Corrections provided me with was a document with his insignia imprinted on it, stating that I was released on May 16, 2022 from their custody, and that the aforementioned document may serve as a temporary form of identification. However, this document is insufficient to serve as a vehicle for verifying identity when pursuing reputable employment. This fact serves as yet another unintended consequence of incarceration. Moreover, it is an ever-present reminder of the formerly incarcerated person's classification of property and not person. It is akin to the past an enslaved individual would receive from their master, authorizing them to travel outside the perimeter of the plantation. In addition, a host of these returning to the realm of liberty do not immediately have the financial resources required to procure proper identification. In my humble opinion, proper identification is a basic human right, as it is a prerequisite to adequate employment, housing, and healthcare. I pray that this body discovers within itself the willingness and ability to put person before process. Thank you for this opportunity to testify. Please make sure that every person leaving incarceration has a proper state identification. Thank you.
Thank you, sir. Questions or comments for the committee? If not, appreciate being here and we hear you.
Thank you.
Scott Cochran.
Good afternoon, everyone. Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and the members of the Judiciary Committee. My name is Scott Cochran. I'm the Director of Madison Youth and Family Services in Madison, Connecticut, and I'm testifying today in my role as President of the Connecticut Youth Services Association, otherwise known as CYSA. I'm here to lend testimony in support of HB 6888. We support this bill. CYSA is a unified network of 103 youth service bureaus serving 138 towns across Connecticut. We play a pivotal role within our Connecticut communities. We do respectfully request that that the bill be amended to include CYSA as a seat at the table of the implementation team that's referenced in Section 2. For CYSA, we know our kids, we know our communities. It's imperative that we're a part of this conversation. We have a lot of input and I think an expertise around contributing to creating more of the framework that address the issues for our young people. We are on the front lines and we see firsthand all the time the impact of the increasing rates of depression and anxiety among our youth. We'd also like to offer testimony in opposition of HB 6889, as this bill would really kind of turn the clock back on some reforms that have already been made in the state of Connecticut. Studies have shown that most of the young people engaging in status offenses and poison behaviors are facing behavioral health issues, which are best supported through community-based resources. So respectfully, we oppose that particular bill. And with that, I'll conclude my testimony. We've offered written testimony as well.
Appreciate that. Questions or comments? Seeing none. Thanks for sticking with us well into the afternoon here. Thomas Burr. Thomas Burr. Matthew Quigley.
Yes, hello.
Go ahead, sir.
All right. Good afternoon, Chairman Winfield, Chairman Stastrom, members of the Judiciary Committee. My name is Matthew Quigley. I'm an executive board member for Council 4, AFSCME Local 1565 Correctional Employees Union. Our union is opposed to the Section 2 of Senate Bill 1196, an act concerning procedures of the Department of Correction relating to strip searches and the transfer of persons who are incarcerated between correctional facilities. Unfortunately, the use of strip searches are necessary to keep dangerous contraband out of correctional facilities. The department already has Administrative Directive 6.7, which regulates the use of strip searches in a correctional facility. I oppose the bill due to the requirements have an unrealistic process, an environment where timely intervention is needed to prevent the exposure of the ever-growing fentanyl epidemic. At Corrigan Correctional Center, in the last year alone, there's been nearly a 400% increase in fentanyl contraband conveyed into the facilities by the offenders. Just in the past month, I personally dealt with an offender who attempted to smuggle in 7 grams of fentanyl, nearly died, was Narcan 3 times, and 911 out of the facility. This then triggers a systematic search for further contraband. This triggers the systematic search for further contraband, where additional powdery substances were found, Suboxone, as well as marijuana. Strip searches are a necessary tool to prevent further incident and the preservation of life. Without this tool, who knows how many lives could have been lost? This is just one of hundreds of scenarios that could happen daily throughout the department, and only about one specific drug. What about every other narcotic with the possibility of a deadly outcome? What about the risk to offenders under the influence of these narcotics? What about the weapons? You've already heard testimony of a pistol being recovered at Bridgeport Correctional because of a strip search policy in place. My point is, dangerous situations can arise quickly in these facilities. This language would add to the risk. It's a very unnecessary risk. Thank you for considering my testimony. I'm willing to answer any questions if anyone has any comments or concerns.
Questions from the committee? Seeing none, appreciate you being with us.
Thanks.
Lindsay Puss.
Thank you. I think you're one of the few people who's ever pronounced my last name correctly. Hello,
Well,
my name
don't-
is Liz.
Don't, there's still a test on Staffstrom going on, so, you know.
Yeah. Hello, my name is Lindsay Poulos, and I am a community member of Hartford. Thank you for the chance to speak today in regards to the pressing need to oppose HB 6889 and support HB 6888. In HB 6889, this bill uses the word child 151 times, and yet does not recognize these children as such. This bill is a reflection of a complete disregard for already established rights and services and shows a lack of knowledge of what it takes to prevent crime in the first place. It is clearly an inflammatory reaction to the preceding bill, 6888, a bill that should be supported. Truancy is not indicative that a child is a threat to society. It is an indication that further support and intervention is needed. Youth who do not feel safe, supported, or hopeful in school and consequently avoid that environment do not deserve to be treated as criminals for that circumstance. In addition, children being withheld their right to pretrial release, a transfer hearing, and being sent to the adult court system automatically not only deny them of much needed and effective services, it is an assault on their already established rights and legal protections. In totality, this bill is designed to set children up to fail before their future even starts. I have worked in youth programming my entire career. I have seen time and time again what an olive branch, an opportunity, and most importantly, compassionate intervention with comprehensive resources can do for a child that has made a poor choice. A choice that was made when their options were few. Furthermore, perhaps we have all seen the grave injustice that occurs when people are punished for a crime that they yet to even be tried or convicted for. As Plato once said, the worst form of injustice is pretended justice. I implore this committee to focus their efforts on prevention, diversion, community-based intervention, and recognize that children are in fact children. There is decades of demonstrable evidence that this is what prevents crime, as we've heard today from multiple people. That this is what prevents recidivism, and this is what allows for true accountability and reform. We are all bound to the outcomes of our community's children, and in recognizing that, I hope we all act accordingly moving forward in opposing the bill of 6889 and supporting the bill of 6888. Thank you.
Thank you. Questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. I'm looking at the list and it doesn't have any information about you. So
Sure.
what is your what do you do, that kind of stuff? I mean,
I work at a nonprofit.
okay.
We receive public funding, so I am taking PTO today. I'm speaking on behalf of myself, not my employer. I've worked in youth advocacy for my whole life, so worked in case management. I've worked in programs. I've worked in multiple sort of environments, after school programs, prisons, treatment facilities for girls who are being diverted from being formerly incarcerated, often have experienced trafficking. So, you know, you name it, I've been a part of it.
Okay, well, that's helpful. Have you ever been in a juvenile court?
I have not. I have worked with youth who have been a part of the process and worked with organizations such as the organizations here today. Some others have relationships with CSSD. So I'm familiar with the process and I'm familiar with what it takes to support youth and reduce recidivism. In addition to that, I have a master's degree in social work. So I focus a lot of my research on mass incarceration and how to prevent that in the future.
Okay. So you, and I'm not being combative. But your knowledge in this area is book and not so much practical. I mean,
My knowledge in the impact that incarceration has on youth is there. If you're calling into question my integrity and my knowledge and the effects of incarceration on youth, I have demonstrable career experience in that.
okay. So one of the bills that you're here testifying about is 6889. And as indicated previously, that would provide for non-judicial intervention for repeated events of fighting. And
For public disturbance,
no,
for fighting.
that the fighting, well, the title of the statute says
Mhm.
public disturbance. but
Yeah,
we don't-
you had cited fighting as one example within a much larger statute and wanted to ignore the rest. So I'm just trying to get clarity on that.
No, I tend not to ignore much, but if we actually look at the statute, which is titled creating a public disturbance, says a person is guilty of creating a public disturbance when, with intent to cause inconvenience, annoyance, or alarm, or recklessly creating the risk of, engages in fighting or in violent, tumultuous, or threatening behavior. So one who fights can be arrested or charged with creating a public disturbance. That's, that's the title.
Mhm.
So under the bill, we'll go back to the question that I asked. If somebody under the bill that you're here supportive of has gotten into all of these fighting incidents, and let's say every other day, they're fighting with their teacher, they're kicking the principal and stuff like that. That's, fighting. There's no judicial intervention.
There is intervention
Okay.
through the JRB process, which has been cited multiple times by those testifying today. What I've observed with some of these questions is that,
Well,
you have people here, I'm answering a question. You have people here today who are speaking from career and lived experience and telling you what the process is. And then you get these curveball questions that are fear-based, that are kind of out there, fighting every day. I mean, sure, maybe it happens, right? But is it based in reality? Is it based in experience? I do question those questions that are being posed in the first place.
I thought you were
And
gonna-
as
I thought
we've
you were gonna
heard,
answer the question.
as we've heard from multiple
Hold
people
on,
testifying today.
hold on. I'm gonna step in at this point. We have to have a transcript of this, okay? So we can't talk over each other. I've let it happen a couple times, hoping it would improve. It hasn't. We need to be a little careful not to question each other's motives or each other's, I'll leave it at motives. And let's stick to the bill. We are talking about language and substance of a bill. So I'm going to stop right there and I'm going to ask Representative Fishbein if he has any final questions on the language of the bill of this witness.
Well, I'm sure I asked the question about the language of the bill.
Can you repeat the
bill-
question,
Sure.
Representative?
Yeah.
The fighting situation, the repeated fighting situation, under the language of the bill would provide for no judicial intervention. You agree or disagree?
I agree
Okay.
that there should be a process for youth that is in diversion, intervention through the JRB process as stipulated in the bill of 6888. I do not support Bill 6889, which you are the sole sponsor of.
Okay, I got all that, but there wasn't responsive. So you agree that there is no judicial intervention for the repeated fighting and.
Representative, I think you've asked this question a couple times.
Well,
I think she's
I'm a little
answered it.
concerned because part of the presentation by the testifier, and I quote, is lack of knowledge of what prevents crime. So that's the accusation. So I'm testing the acumen of the accuser.
Okay, this is not a cross-examination.
I
She-
understand the,
This is a public hearing. This is not a court. We are not applying rules of evidence. She has answered the question to the best of her ability. I believe that there are also other charges that someone, certainly for kicking a principal, that would be battery, which is a separate charge. Move on to the next question, please.
the, the disorderly conduct. Which also talks about engaging in fighting or violent or tumultuous threatening behavior. I'm trying to figure out when, in your opinion, is it appropriate for a court to get involved in repeated events?
When is it ever okay for a child to be tried as an adult when they are a child?
Wait, stop. Okay, he asked a question. You can't respond with a question.
Okay,
If you have an answer to his question, answer it. And if I have to interrupt again, we tend to try to be informal in this committee and allowing direct questions. But if I have to interrupt again, I'm gonna require the questions go through the chair and answer go back through the chair, which will slow us down. But I can't have this sort of back and forth right now. So can you answer the question that was posed to you?
sure.
If
Can you
not,
repeat
that's
the
okay.
question?
Sure, when is it appropriate, in your opinion, to have repeated events such as threatening, fighting, to become an issue for a court?
I think that that is a question that cannot be answered with one specific sort of response or example. I think that has to be done on a case-by-case basis with expert and the applicable parties involved. And I think that what 6889 does that is particularly harmful is that it removes the transfer hearing process, which removes the ability for youth to advocate for themselves, to be advocated for, and automatically puts them in the adult criminal system, which prevents them from getting these services that they need that reduces recidivism in the first place.
Right, well, I didn't ask you anything about 6889. We're
Okay.
talking about 6888, which is
Okay.
the bill that you've come here to testify in support of, which basically says that repeated activities keep on going to the JRB. So you heard the public defender before testify that it wasn't their intent, that they felt it was appropriate that after the first or second time, that it should not go to the JRB. Do you agree with that?
I agree with the process that youth should be diverted to the JRB, and that if it is determined by the parties involved that it needs to go to the court, then I agree with those parties.
Okay, well, that's not what the bill says, but thank you for coming here.
Further questions or comments of this witness? Representative O'Day?
Thank you very much, Mr. Chair. And Ms. Poulos, did I understand correctly? You don't believe any youthful offender should ever be treated as an adult?
Yes.
Tried as an adult?
Yes, I believe that.
Ever?
Yes.
Well, I just want to say, I think the way you've handled the questioning from the ranking member has been inappropriate. And I hope that further people have learned a lesson about how to properly respect and respectfully answer questions here. Thank you, Mr. Chairman.
Respectfully, I think that there's.
Ma'am, I'm gonna again step in. I don't believe that comment was called for, Representative. I think that I have appropriately admonished and not admonished, but I've appropriately tried to keep us constrained to the bill. I think she was trying to answer some pointed questions to the best of her ability. And it is not appropriate for us to opine on the appropriateness of her answers. Her opinion is her opinion, and she's allowed to express them in a public hearing, even
Thank
if
you.
members of the committee may disagree with her. Thank you very much for being here today to testify.
Appreciate
Just
it.
a point of order, Mr. Chairman. I don't believe these comments should be disrespectful, and I want that put on the record. Thank you.
I didn't take it to be mean disrespectful, and certainly Representative O'Day, I know you were the last person who would ever mean to be disrespectful to anybody in this body, so I didn't take it as disrespectful. I just want to make sure that it's been a long day. We have about a dozen or so folks left to testify. I just want to make sure that we are allowing folks the opportunity to testify, and that we can get through the rest of this list, right? Thank you. Nancy Peters.
Thank you.
Good afternoon, distinguished leaders and members of this Judiciary Committee. My name is Nancy Peters. I'm from Norwich. Today I'll be reading testimony given by Chastity West, who could not testify herself due to her incarceration. My name is Chastity West. I stand in strong support of the portion of SB 1196 that addresses strip searching. As a woman who's been incarcerated at York Correctional Institution for many years and has been made to undergo countless strip searches, I'm well qualified to talk about this humiliating and degrading experience. Strip searches are often performed by staff as punishment, quote, to remind them that they're inmates, to quote a supervisor. Inexplicably, they're also performed on the whole population whenever a staff member misplaces an object, be it a 16-inch metal ladle, a fetal heart monitor, or a toolbox. Yet this procedure that staff performs on us so casually, routinely, and unproductively is one of the most humiliating and intrusive things that can happen to an incarcerated woman. Strip searches are extremely sexualized, erotic even. Before the gaze of a same-sex guard, a resident must remove each item of clothing until she is completely naked and stand barefoot on a dirty tiled floor facing the guard as that person canvasses her naked body from head to toe. She must let down and tousle her hair as if it is up, open her mouth, lift and flick her tongue, and even remove her dentures if she's wearing any, subjecting her to further humiliation. The woman must lift her breasts and her belly if she's corpulent. Then, while facing the wall, she's directed to bend at the waist, pull her buttocks open, to fully expose her anus, vulva, and vaginal orifice, and cough, ostensibly to propel any concealed item from her body. If she's menstruating, she must remove her tampon in full view of the guard and perform the same bend, squat, and cough routine. By its very nature, vulgar and uncivilized, the strip search is eerily reminiscent of the bodily humiliations African captives endured when brought to the auction block. These enslaved people were considered chattel, which means movable property. Likewise, we incarcerated people are often referred to as state property by our keepers. As was the case with enslaved people, we are treated as if we don't own our bodies or have legal protection from such bodily violations, confirming the legacy of colonialism that prevails in both the system structure and the practices it relies upon. The practice of strip searches continually reminds us that the moment we enter a prison, not only does our body no longer belong to us, but now it's become a spectacle, an object of corporeal exploitation. Thank you very much for hearing her testimony.
Thank you, ma'am. We appreciate you presenting it for us. Appreciate being here. Representative Porter, do you have a question on the testimony as read? Do you have a question on that testimony? No. Oh, go ahead. I'm sorry. Go ahead, Representative Porter.
Thank you, Mr. Chair. And I don't have a question. I just want to make a comment. First, I want to thank you for having intestinal fortitude to read that testimony. And the more I hear about these strip searches, the more I know that we are on the right track to making sure that they're not random and that there is probable cause, proper cause to subject someone to this kind of inhumane treatment. Thank you.
Thank you very much, Rep. Porter.
Thank you, Representative, and thank you, ma'am, for being with us today. Barbara Fair.
Hi, my name is Barbara Fair. I'm a West Haven resident, licensed clinical social worker, mother, grandmother, and great-grandmother. And it's, I listen to these women talk about what they had to go through, and I can't see how anyone possibly, I'm talking about SB, this is really a mess. This is hard. I'm talking about 1196. It's just hard hearing people go through that humiliating experience, and for other people to not feel that. It's dehumanizing, it's degrading. It's not just embarrassing. It's humiliating, and for me, it's a bit perverted. And the question for me is, why did it take so long for someone to see something wrong with this happening to people, thousands of people, and the psychological harm that it causes? And it's especially painful knowing that our children go through the same thing, and these court support, judicial, wherever our children are, that they have to experience this also. So I'm not even going to go with my testimony. I just want to answer some of the questions that I heard today. For one thing, talking about the body scanners, there are body scanners that do not emit radiation. We can look into that if we're serious about it. The commissioner wasn't sure, well, I guess he said no, that people are not strip searched when there's no contact visit. I know for a fact that that's not true. They are. And then the directive, when I heard them say there's no cavity searches inside DOC, and directive states, Directive 6.7, Section 3Q says defines strip searches as visual cavity searches, and it talks about exploring the entire body, anus, or everything. So I don't know how he's not aware that these kind of things happen. So I look at Mandela rules, where the minimum standard for correctional people is that strip searches are only as a last resort. There must be probable cause. Because of the humiliating and degrading experience, they must be private and respecting the human dignity of people. I don't know how you have human dignity doing that. But then I also heard officers say we don't like doing it. And yet just this morning, I got an article of a lieutenant in DOC who actually got arrested for voyeurism, taking his phone and using it to photograph a young lady. And then one final thing I want to get in there is about, they talk about the strip search is mostly about getting drugs and stuff out of the system. Okay.
Thank you. Questions or comments from the committee? Representative Porter.
Thank you, Mr. Chair. And you were talking about strip searches. I'm just wondering, what exactly is it that was spoken of in the article that you read today that relates to that when you talk about this correctional officer? And is it in the state of Connecticut? Well, I have a couple of questions. First, I want to know, is it in the state of Connecticut that you're
Yes,
referencing?
Carl Robinson, lieutenant.
Okay.
And arrested this very month, just about a couple of weeks ago. So when you talk about people who don't enjoy it, I don't know why he's taking pictures of women, watching them undress.
Okay, and then I want to go back to the strip searches and what you were saying about well, I don't want to use the word enjoyment, but I'm not sure the point you were trying to make in support of this bill as it relates to the testimony that you're giving right now.
Because I heard it being said that the correctional officers do not enjoy it. So I'm wondering why we have an officer who just recently arrested enjoying watching someone undress. And so that to me just it's like it's something to think about why we do these strip searches. Is it really about safety and security, or is it more about power and control, saying I have the power over your entire body and I can do what I want. I can look at you when I want, and there's nothing you can do about it, because if you refuse, I can put you in isolation. To me, that's like being raped at gunpoint and knowing I can't do anything about it. And yet we're state sanctioned in this kind of behavior.
But do you support strip searches if there is probable cause?
If there is probable cause. And then when you think about probable cause, you got to realize probable cause is the third level standard. The standard we have now is reasonable suspicion. That's the lowest standard. And so we definitely need to raise it to the point of probable cause. And then finally, around strip searches, when they say it's about put a lot of emphasis on drugs, we have to look at the fact that we have correctional officers who have been arrested and charged with bringing drugs into the system, one just last year. So when you say it's about keeping drugs out of the system, I think that's the main reason we need to have the body scanners. And in places like Tennessee and New York, all people that come into facilities are body scanned, and they do it because they know correctional officers bring drugs into the system.
Well, thank you for making that point, because I know also in speaking with Per Vag, who's here from Norway, he stated the same thing. Their scanners are used on both the faculty, the correctional people, as well as the inmates, to ensure that that's not happening, which you just stated. So thank you again for your testimony. I know how hard it is for you to come here and testify on these things, and I do appreciate you. Thank you, Mr. Chair.
Thank you. Further questions or comments? If not, Ms. Farah, always good to see you. Thanks for being with us today.
Thank you. And I hope you pass it this session.
Ileana
Don't put
Pujols.
it off.
Dear Representative Staffstrom and members of the Judiciary Committee, my name is Ileana Pujols, and I am testifying today in support of HB 6888 as a whole, but will focus on Section 3 specifically in my testimony. I am currently the Policy Director at the Connecticut Justice Alliance. We work alongside young people impacted by the legal system we are discussing today on a daily basis and are deeply connected to the work of the state's Juvenile Justice Policy and Oversight Committee. The section I will highlight today is an important step towards creating a legal system that works to increase public safety and support young people currently incarcerated in our judicial system or at higher risk of becoming impacted by it. In my role at CTJA, I serve as the co-chair of the Community Expertise Work Group of the JJPOC. The JJPOC has operated as an oversight body of the youth legal system since legislatively appointed in 2014. To date, the JJPOC has 42 members, 40 appointed professionals, and 2 appointed parents. Although the JJPOC attempts to engage directly impacted youth and community members in its annual work, neither youth nor directly impacted community members are appointed as voting members, meaning no matter how much feedback they provide, they do not have a true voice on what becomes a JJPOC recommendation yearly. Passing Section 3 of HB 6888 would ensure that 2 directly impacted youth between the ages of 18 and 26 and 1 directly impacted community member would have voting rights, along with stipends, transportation reimbursement and support, and childcare financial support similar to the rest of the members currently appointed and paid for their presence. This section has been introduced for 3 years in a row, yet has passed out of the JJPOC with full bipartisan support, yet did not make it through the legislative session. It's important that we make sure that all audiences involved in the efforts of the JJPOC have a voting seat, and this would fill that gap. This kind of membership expansion is not rare or uncommon nationally. The Juvenile Justice Reform Act led to the Office of Juvenile Justice Delinquency and Prevention, creating a requirement very similar to this. Expanding this membership to include those 3 individuals would barely meet the national trend, yet is a step towards following national practice for such bodies of work. I shared earlier at our public hearing that I understand that many may think youth who have been in the system as voting members is absurd or ineffective. Others will say there's no way you can trust a previous criminal with this kind of responsibility, but I am living proof of the opposite. I joined the JJPOC as a participant in 2017 at the age of 19 years old, and can promise you that I probably know more about the work of the JJPOC than some of the appointed members, respectfully. I urge you to consider the importance of this bill and make sure we prioritize this section no matter what happens to the rest of the bill. Thank you for allowing me for the time to testify today.
Thank you, ma'am. Questions or comments? Seeing none, always appreciate seeing you. Marissa Mascolo Halm.
Good afternoon, Representative Staffstrom, Senator Kissel, members of the Judiciary Committee. My name is Marisa Halm. I'm an attorney with the Center for Children's Advocacy. I direct our Youth Justice Project. Just as a matter of context, I work on a regular basis with justice-involved youth and provide Know Your Rights trainings in particular for the young people who are at Manson, the correctional facility, housing minors. I've submitted written testimony on 3 different bills in support of 1196, which would limit strip searches in DOC, against 6889, which would roll back very important juvenile reforms, and in support of 6888, which an act concerning juvenile justice, which would which our office is in support of in its entirety. I want to focus my oral testimony here in particular on 6888 and section 6 of that bill, which we want to draw your attention to. This section of the bill would create a plan to remove minors from the youth and minors from the care and custody of the Department of Corrections. We would ask that the committee pass this section of the bill with amended language. Currently, the language in the proposed bill suggests that the judicial branch should come up with this plan. We'd like to recommend that a working group be convened with key stakeholders, including youth who are directly impacted, to come up with that plan. And I've attached suggested language to our testimony that the committee can refer to. The removal of these youth is long overdue. Their removal was intended to be effectuated back as a result of Public Act 21-174, which was passed by this committee. Section 6 of 6888 will, with the amended language that we're recommending, will get this done. Connecticut, which you may or may not know, is one of the biggest offenders, worst offenders in the US when it comes to incarcerating minors in adult prison. All of our neighboring states incarcerate 0 minors in adult prison. This is because they know the consequences are not positive. Incarceration of youth in adult prison leads to more recidivism and less rehabilitation. Connecticut needs a plan to appropriately house these youth and to do so ASAP. All of the key stakeholders at the table are in agreement that this is something that we should do. We would urge the committee to endorse section 6 of this bill with the development of a work group that can include youth voice and directly impacted folks to get this done. Thank you.
How's that for timing? Questions or comments from the committee? If not, appreciate being with us.
Thank you.
Ramon Garcia.
Good evening. My name is Ramon Garcia from New Britain, Connecticut, and today I'm testifying in support of House Bill 6888 and that concerning juvenile justice, and Senate Bill 1196 and that concerning procedures of the Department of Correction relating to strip searches. On House Bill 6888, specifically sections 3 and 6, having experienced Connecticut's juvenile system at a young age, I realized that the state's current way of dealing with justice-impacted youth is contrary to these kids becoming better and healing from the many traumas they have to endure as a result of poverty, living in neglected communities, being from single-family homes, etc. Oftentimes, these societal ills are a main contributor of their incarceration. And if we begin to address some of these root causes, it would increase public safety by far and would also save taxpayers millions of dollars spent to keep these youth locked inside cages. I also want to highlight that it is extremely important to assist the parents, especially those who are returning citizens who are parents to many of these kids. Currently, my teenage son is incarcerated at Manson Youth in Cheshire due to my inability to house him and give him the supports he needs. After my release from custody in 2018, I reiterated this to the Department of Children and Families as well as the Department of Social Services, and no assistance ever came. I hope Connecticut will become an example for the rest of the country and really tackling the root issues that have these negative effects on our youth. On Senate Bill 1196, I fully support curbing some of the atrocious strip searches that are too often weaponized by correctional guards to humiliate, dehumanize, and exert their authority and control over people in many cases. During my incarceration in the Department of Corrections, I experienced many traumatic moments due to these strip searches. And when I attempted to address some of these issues with the administrators while I was still in custody, I was retaliated against. There's a common formula used by the DOC that one person messes it up for all. And to penalize many over the acts of a few is an extreme and gross injustice. Thank you all for your time.
Thank you, sir. Seeing no questions, Representative Porter.
Thank you, Mr. Chair. And I'm asking this because you have the lived experience. When you did go through the strip searches, were they done in private, where you were the only person that was incarcerated? I know there may have been other COs or numerous.
No, that was the issue, particularly in Osborne. I mean, it ranges from prison to prison. Nothing is really ever uniform, but they have a makeshift courthouse inside Osborne that I think at one time they were using for immigration. And they have benches, you know, well, similar to like church benches, they're wooden. And you know, they would there would be like 10 to 15 guards, and there would just be 15 naked bodies just being strip searched all at the same time. And at this particular incident where I was retaliated for reporting, was the officer called all of the prisoners. It was like on a Saturday morning during visits, and he made all the, you know, everybody sit down who wasn't even being strip searched. And just 2 corrections officers were stripping about 20 to 30 people while everybody was just looking on. So we basically had a strip like in front of like 30 people. And then when I retaliated, there's supposed to be barriers and dividers, and people that are not part of the strip search are not supposed to be present. But when I kept addressing this, they kept telling me that's how it's always been. And one of the officers that did this during this incident happened to be a more senior officer, and they retaliated against me. They waited one day, made me go last, and there was like still 10 officers there. I was by myself, and then he just, you know, he tried to humiliate me. I had a religious headpiece. He took my sneakers, he wiped it on there, and then tried to tell me to keep bending over at the waist. And I told him, I said, I've already done it. And so he told me I was refusing. And when the guards, the 2 lieutenants came down, they asked me if I was refusing, and I was already standing naked at that time for about 10 minutes. I said, does it look like I'm refusing? So after, they asked the guard to, perform the strip search, and exactly what I did the first time is what I did in front of the guards. They were like, the lieutenants, they said, you're good, go to your block. I requested to speak to the state police, through the PREA Act, because, I felt sexually violated. And they put me in solitary confinement, stripped me again, put me in solitary confinement, and then came down 5 hours later and said, listen, we don't even want to do this to you. Just sign this paper saying you feel safe and you can go back to your cell. We didn't even pack your stuff. So to safeguard themselves from liability, they had me sign a paper or just be in solitary confinement for no disciplinary issues, just because I made a complaint. So, yeah.
Like, I thank you for that testimony. I thank you for sharing that personal information with us, because we've been told quite the opposite by some of the correctional officers that actually testified today. So I believe in, everyone having a fair shot at telling their story. Nobody's closer to this than someone who's experienced it. And I'm sorry that you went through that. Thank you, Mr. Chair.
Thank you.
Further questions or comments? Not, thank you for being with us, sir. Thanks for
Thank
sticking
you.
with us.
Have a
Thanks
good
for
day.
sharing your story. Mark Donald.
Good afternoon, members of the Judiciary Committee. My name is Mark Donald. I am the Executive Director of RIASAP. I come to you as a parent of teenagers. I come to you as a former teacher and principal, South Bronx, New Haven, and Stanford. And most importantly, I come to you as someone who's learned a lot over the years. And I think one thing that I have learned in regards to speaking about House Bill 6889 is that doesn't work. The FWISN system didn't work. It doesn't work. I learned it from working with families. Learned it from overseeing a juvenile review board currently. Unfortunately, there's many other things that we can put in place that would. So in that regard, I'm going to speak in support of Bill 6888. And I'll start with some numbers. 85% of the young people that enter our juvenile review board program in Bridgeport complete it successfully. What does that mean? So they complete the program, they attend a panel, which is a part of community members, adults in the community, who make recommendations about their plan to restore. It's all about restorative justice and accountability. And anybody who argues that that's soft, that's not holding people accountable, is not familiar with the process. And I'm happy to have a conversation after and talk through it in a little more detail. So 85% of those young people complete juvenile review board requirements that they're involved in the plan. So their case is not referred back to the courts or back to the police to go to the courts. Next number is 99. 99% of the mediations that are agreed to in our community mediation program hold for 3 to 6 months after the mediation is completed. That does not include the 2 to 4 months that they undergo the process. So that whole process is around 1 year. 99% of those who agree to go to mediation complete it successfully. 86% that have the option of going to mediation enter into those agreements. So those are 3 diversionary programs that we under RIASAP run, we host, we save taxpayer monies. The next number I'll put out is 1.8 million. There was a study done between 1980 and 2010, $1.8 million, the amount of money saved in Connecticut through mediation programs. Currently, as far as I know, we run the only juvenile mediation program in the state, and that's all privately funded currently. That in particular program is done in concert with the courts in mostly Lower Fairfield, Waterbury, and Torrington. So that's Stanford and Bridgeport. The other piece when we're talking about finance and making smart investments is our juvenile review board program in the last fiscal year costs about $2,300 a young person. With that in mind, I'll just wrap it up very quickly. You know, when you talk about running a program and how we try and do things in Bridgeport under RIASAP, we offer a spectrum of services that are focused on the young person in front of us.
Thank you. Representative Howard?
Yeah, sir, thank you. You may have heard me, I'm not sure if you're in the room earlier, I mentioned that the diversionary programs have great success, and it sounds like you have great success in Bridgeport. I appreciate your numbers. Do you happen to have the numbers of the youth that go through the JRB, successfully complete it, and that you never see them again? And I mean that you never see them in a negative light. In other words, they don't reoffend. Do you have that number?
Yeah, so that's a great question. And I think in order to study it, which I heard some members of this committee talk about last week, there has to be an MOA between DCF and CSSD in order to get those numbers completed. Right now, we only have anecdotal numbers because we run a gang intervention program, Street Safe Bridgeport, which works with youth that have a little higher risk level. So the only way we'd know is if they return to that program after. So our juvenile review board, typically we work with a young person 6 months to a year. And then once they leave our program, we aren't able to track because they've completed it successfully.
Right, and thank you, I appreciate it. So I think it is an important number for us to know that we can sort of build upon that. So I don't know if you happen to know any state reps from Bridgeport that might have influence in that area, perhaps you can talk to them and we can move forward on it. Thank you.
I know.
Thank you, Mr. Chairman.
Let me know when you meet them. Mark, always good to see you. Appreciate you sticking with us. And I just we've had a long day and a long hearing on this. We've talked a lot about juvenile review boards. And, one of the things I think that I take away or I hear as I'm talking to my colleagues is, unfortunately, not all juvenile review boards are created equal, as they may say. And I think some are more successful in some parts of the state than others, unfortunately, and that's just the reality. But I've said it before, and I will say it here publicly: if there are folks in communities who are concerned about sort of how their JRB is working, if it's not working properly, if they feel it needs a model to emulate, come to Bridgeport, because as far as I'm concerned, Bridgeport does it better than anybody in the state, and that's in large measure a testament to you. So I appreciate your advocacy and appreciate all your work on behalf of the city.
Thank you. And there definitely are others who do very good work, and we're happy to work to create a consortium or whatever at the leadership of this group or with private funding, because it is.
Don't burst my bubble. I'm the chair. I get to decide. All right. Next up will be Justin Carbonella.
Thank you. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kitzel, and Representative Fishbein, and members of the Judiciary Committee. My name is Justin Carbonella. I am the Youth Services Director for the City of Middletown, and also the immediate past president of the Connecticut Youth Services Association, of which I sit on the board as an ex officio member. I'm here to testify in support of HB 688 and its proposal to create a pre-arrest diversion process. We have found here in Middletown that our diversion team, what is commonly referred to as a juvenile review board, is sufficiently successful in working with young people as they find themselves arrested for the first or second time. Our process, I love a bit of healthy competition, so I will aptly say that I believe our process is the best in the state, and would love to talk to Bridgeport and others who are doing really successful work at embracing young people, their behaviors, and ensuring that accountability is seen and recognized, and folks who are both impacted by crime in a number of different ways all feel validated by the process. So that is both the young person, their family, and any victims of crime. And I think that is unique to a restorative model. And it is a much harder process for a young person to go through than purely punitive measures, at least in my experience of running both types of process. While I do believe that diversion is doing right by young people, I also believe that funding it is doing right by people and young people. Currently, state funding for this process equates to about $300 to $600 per youth in the way that we serve them. Just providing an Uber ride to our location is about 10% of funding at times. So I want to make sure that I say out loud and strongly that changes in state policy must also be followed by funding. We can't continue to refer young people to diversion programming without the requisite funding. Furthermore, I just want to acknowledge in section 2 that it does talk about the development of an implementation team. And I do think it is critical that at least one, if not multiple, YSB, CYSA representatives are part of that team. We are living these processes daily and think it is critical that while the voices of the deep end of the system are present in this implementation team, I think it's really critical that folks who share the lens that we do are also contributing to its development. And I appreciate, I know it's been a long day, so I appreciate everyone's time.
Yep. Questions or comments? If not, we appreciate you being here, and I appreciate the competition. So keep at it.
Thank you.
Deshaun B. Deshaun B. Ray Boyd. Ray Boyd. Kathy Flaherty.
Good afternoon, Representative Safstrom, Senator Kissel, Senator Winfield, Representative Fishbein, members of the Judiciary Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project. I gave you written testimony on 3 bills in favor of 6888, opposed to 68889. Also want to offer support for 6875 so people have IDs when they re-enter. But I'm going to focus my testimony today on 1196. Frankly, I was disgusted by the testimony of a correction officer who said he did not perceive strip searches as sexually violent because he didn't experience them that way. I would ask you to consider that the perpetrators of harm rarely perceive what they do as being harmful to other people, because what they do via the policy is dehumanize people. I usually don't feel like I'm going to vomit when I write my testimony or sit in this chair, but I've had it happen to me on my last psychiatric inpatient hospitalization at UConn Health, which at that time had the contract for DOC's behavioral health. I had gone to the emergency room seeking help. I was getting admitted to the 7th floor, and I did not want to come out of the bathroom stall because the one nurse, so it was just one person, and having it just be one person is not some kind of huge benefit, told me what I'd have to do. To which my response was like, I'm not doing that. And she's like, if you don't come out, I will come in there and get you. That was my last hospitalization because I told my husband, I don't care what's wrong with me. I am never, ever subjecting myself to that again. That we do this on a routine basis to people in DOC, that we do this on a routine basis to people in maximum security at Whiting Forensic Hospital, which is a hospital where people are there for treatment. And I brought the Whiting Forensic Hospital strip search policy with me because I had somebody from my office send it to me when I heard the questions people were getting earlier today. This bill is not eliminating strip searches. It is eliminating the routine use of them when there are other avenues to provide the safety and security that everybody claims they need in a way that does less harm to people. Thank you.
Thank you, Kathy. Thank you for sticking with us and sharing your personal story with us. Seeing no questions, appreciate being here.
Thanks.
Hoya Jerami. Hoya Jerami. Tino Negron.
Good afternoon, Representative Strasser, the rest of the team here to look at these bills and these initiatives that, you know, some of us sometimes just think as a form of a complaint. This House bill that I'm here for on 76875, I'm not into numbers, I'm into people. But what I did yesterday, having a conversation at Transitions Clinic down in Yale, driving up from Bridgeport, was able to have this discussion once again about this issue that we're having with some form of identification. And I've been having this discussion since I was released from incarceration after serving 30 years. And 30 years ain't a long time, but it's a long time when you're out back in the community that the community continues to have this discussion about resources. And one of the biggest components I believe that we should start talking about is how you can identify with being released back into a society that talks about a second chance. where we could start looking at these issues and concerns with a piece of paper that has a photo on it. And I didn't have my ID till like 6 months later, but I'm not gonna tell you no lie. Yes, I did, because I knew some people, I knew some people in the community that was already doing this type of work. And I made some phone calls and they drove me to Hamden, they drove me to Cheshire, they drove me to all these different types of places. But what disturbed me the most was yesterday I brought somebody that was just released under the 1584 juvenile bill, just like me. He was released about a week ago, and I happened to be a part of the hearing to show him some support. And that's the young man, Keith B, stand up in the back, if you will. He was just recently released after serving 30 years as well, from the age of 14 to 44. And when I brought him up to New Haven, to a community that has all these different types of resources with Yale University and different types of people that sits before us and sits behind us that does this work. One of the biggest components that the director of the halfway house asked me, I said, no, don't ask me, ask him. So they asked him, they said, you have any IDs? And his answer was no. So he was released after serving 30 plus years. And this is 5 years after I was released almost. And he still don't have an ID. And it's not just the language and these types of things that we write up and use. Some of you people that came up today done a phenomenal job. And it was told to me I could do this over a phone. Over a phone, it don't get done, Senator Stranson. I think that we need to see the lives of these people that have been impacted, that are still being impacted, because his sister that sits next to him that was younger than him when he went to prison, she said the same thing. Why do they don't have no ID? So the biggest component I think we should start talking about with those that are incarcerated, those that are released back in our society, it's a piece of paper and it's a picture. Do we think we can handle that obligation? Do you think there's some money involved that we can start looking at to tap into that? There's a lot of money involved. And they just close down a bunch of systems. And if we could really start caring about those that are returning back into our society, and the biggest component I keep hearing is being somebody's neighbor. So I've been home 5 years now. Recidivism still, Senator Stranson, 78.6. We still looking at them numbers, man. Thank you for having me today.
Thank you, Sarah. Thanks for putting a fine point on it for us. See no questions. Appreciate being with us. And you are right, sir. Being here in person for that does matter. Sarah Egan.
Good afternoon to the committee. Senator Winfield, Representative Fishbein, Representative Staffstrom, all members of the committee. This testimony is submitted on behalf of the Office of the Child Advocate. The obligations of the OCA are to review, investigate, and make recommendations regarding how our publicly funded state and local systems meet the needs of vulnerable children, and to investigate conditions of confinement for incarcerated youth aged 15 to 21. I specifically wanted to reference my written testimony in support of Bill. I had it right a second ago. 6888, an act concerning juvenile justice and the provisions that call for implementation of a plan to move minor children from DOC custody to the juvenile system. As the committee may know, the Office of the Child Advocate is statutorily charged to review conditions of confinement for detained and incarcerated youth throughout the state, age 15 to 21. Following OCA's baseline report in 2019, which report found significant concerns regarding conditions for minor boys at Manson Youth Institution, a DOC facility, the United States Department of Justice launched its own investigation into conditions of confinement in the facility. In December 2021, the Department of Justice concluded its investigation, finding that the department's investigation concluded that there is reasonable cause to believe that Manson's isolation practices and inadequate mental health services seriously harm children under the age of 18 and place them at substantial risk of serious harm. In addition, Manson fails to provide adequate special education services to children with disabilities, and that these violations are pursuant to a pattern or practice of resistance to the full enjoyment of rights protected by the Constitution and federal law. The DOJ made sweeping findings that basic conditions in the facility, including the inadequate mental health assessment and service delivery, violate children's constitutional rights. And as others have mentioned today, the Department of Justice remains in settlement negotiations with the state of Connecticut to resolve these civil rights violations. The OCA is currently working on our third report, which will include additional focus on conditions for young adults aged 18 to 21 at MYI and across several DOC facilities. We do continue to identify significant concerns, including the inadequacy of rehabilitative programming, group and individual mental health treatment for young people, educational services for students with disabilities, and the use of restrictive housing, restraint, and use of chemical agent, particularly for young people with the most significant mental health and special education needs. We do meet with the Department of Justice regularly to update them on our work. And while they don't and can't share the details of their settlement discussions with the state of Connecticut, they do frequently ask us whether Connecticut is still considering moving minor youth out of the Department of Correction. And we tell them that that remains a subject of advocacy, but there is no firm plan to do that at this point. And this bill would include language to move that plan forward as it needs to do.
Thank you.
That rest on the rest of my testimony if there are any questions.
Thank you. We appreciate it. Questions from the questions from the committee? Seeing none, appreciate being here.
Okay, thanks very much.
Terry Ricks.
Good evening, Representative Stastrom, Representative Porter, distinguished member of the Judiciary Committee. I'm a Black woman who is a survivor of a lifelong of oppression. Every day of my life has been a fight, and I cannot think of a fight that is more necessary and even life-altering than this one. Like many of the people the committee has heard from today, strip searches are dehumanizing, humiliating, state-sanctioned trauma and sexual violence. I do not say this lightly, and this is very difficult to talk about. I was and am already a rape survivor. When I became incarcerated for 1 year, when my daughter and family would come to visit me during the beginning of my sentence, I would be strip searched before and after seeing them. This was especially problematic and traumatic when a woman are experiencing their monthly cycles. I never understood why I had to go into a room, take off all my clothes, and have to expose myself in front of people, then go to a visit, maintain my composure, and still talk to my daughter. I knew that as soon as I left, I would have to engage in the same activity that I dealt with going into that visit. After enduring this torture for 6 months, I had to apologize to my family and ask them to stop coming to visit me because I could no longer go through the torture. I think it's also important to say that I never saw any justification. I take that back. I saw some justification for strip search. But for these strip searches, and if any correctional officer that needed to be searched, they should be the ones that should be strip searched. They bring contraband in, meaning phones, drugs, and other contraband in the correctional facility. The Department of Correction will say the strip searches are about safety and security, but my experience was that it was really all about power and control. If we are being honest about wanting to help people come out of incarceration with opportunity and ability to live a successful and productive life, whether it's about making sure they have an ID, a GED, medical care, medical health supports, then the Department of Correction has to stop burying incarcerated people in trauma. It's been nearly 20 years since I walked out of Niantic. Yet I can remember and feel those strip searches like they happened to me yesterday and this morning. I urge the member of this Judiciary Committee to vote in favor of Senate Bill 1196 so that the people who are incarcerated can have the privacy and safety they need and deserve to continue to grow and come out of there as regular human beings. Thank you for listening to my testimony. I'll be happy to answer any questions.
Thank you, Ms. Ricks. Questions or comments from the committee? Questions, comments, Representative Porter?
Thank you, Mr. Chair, and thank you, Terry, for sharing your testimony. And I am sorry that you had to go through that experience. And I say that on behalf of anybody that has or continues to experience this. My question to you is, you stated that you stopped having visits with your family because of the trauma. Were there other instances outside of that where you experienced the strip search after you stopped having visitation with your family?
That's an excellent question, because a lot of times they say strip searches are necessary for contraband and stuff. Yes, that can be true. But what about the ones that's not necessary? What about the ones you just walking out of the chow hall and they decide to pick you. You getting strip searched. They didn't see you do anything. I went to the chow hall one time in 1 year, because the first time I went, I was strip searched. The second time, why am I getting strip searched if you got me out my cell? You did. Bring me to a visit. You strip searched me there. I go to the visit. You strip searched me after. Where did I get something from? You? So there is many occasions where strip searches are totally unnecessary. It depends on the CO. Some of them they do like it. We have gender biases, individuals that has these positions. We have women that like women that enjoy strip searching. I dealt with that, and that's why I stopped visiting, because just one CO was there every time, and it was just too. It was not a strip search. I was violated.
Thank you. I appreciate that. And I just needed to make sure that they were not standard
No.
according to what we've been told today, and that there are random strip searches.
Oh, there are
going
random
on.
strip search.
Thank you for that. Thank you,
very
Mr.
much for
Chair.
asking that question.
Thank you. Further questions or comments? Seeing none, appreciate you sticking with us and
Thank
sharing
you
your
for
story.
listening.
That concludes our public hearing for today. Thank you all for being here. We'll declare this public hearing closed, and we will be back on Friday morning at 10 a.m. for claim